अनाथ रक्षके श्री कामाक्षि सुजनांगमोचनि शंकरी जननी सुजनांगमोचनि शंकरी जननी विनायकुनि वलनु ब्रोववे निन्नु विनाविल पुलेव रम्मा विनायकुनि अम्मा.
Thank you, Anaga. That was very soothing. Now, I would request our beloved principal, Dr. Sudha G. Ma'am, Vivipura College of Law, to give the welcome address to the gathering.
Good morning, everyone. Respected dignitaries on the dais, ladies and gentlemen. It is indeed a great pleasure for me to extend welcome to the dignitaries and delegates to this national conference on honor killing in India, need for legislative framework, organized in association with Karnataka Institute for Law and Parliamentary Reform and Vishveshwarapura College of Law. It is a great honor to welcome and introduce Honorable Mr. Justice Krishna S. Dikshit, Judge, High Court of Karnataka, Chief Guest of today's conference. Lordship is enrolled as an advocate in 1989 and practiced in High Courts of Karnataka and Madras. Law of writs, election laws, service laws are interesting areas of Lordship. Lordship was appointed in 1999 as the Senior Standing Counsel for Election Commission of India and also as an additional Central Government Standing Counsel. Lordship served as a Standing Counsel for University Grant Commission, the Competition Commission of India, Telecom Regulatory Authority of India, Karnataka Veterinary Sciences University, Baba Atomic Research Center, National Institute of Unani Medicine, and a panel council for nationalized banks. Lordship has great affinity towards the students because Lordship was also teacher and always found himself in the community of the students. Lordship is a voracious reader and he has contributed articles on contemporary issues published in various newspapers and magazines. In 2014, Lordship was appointed as Assistant Solicitor General of India and elevated as Judge, High Court of Karnataka in 2018. On behalf of Kilpar, Rajavakkaligara Sangha, Vishveshwarapura College of Law, I extend a warm welcome to you, sir. May I request Dr. Sanjeev Gowda, sir, to honor the Lordship. I wholeheartedly welcome Professor Dr. C. Basuraju, Vice Chancellor, Karnataka State Law University, Hubballi. Professor has graciously consented to be the keynote speaker of today's conference. Professor started the academic career in 1995 as a law teacher in prestigious institution National School of India University, Bangalore, and later on moved to Department of Law and Research, University of Mysore. Professor has served in various capacities as a in-charge Vice Chancellor of University of Mysore, Registrar of University of Mysore, Dean Faculty of Law, Director of School of Law, Member of Syndicate, Academic Council, etc. Considering his academic credentials, he has been nominated as a member to the National Assessment and Accreditation Council. Professor has, to his credit, published more than 125 research papers, both in national and international academic journals, published books, innumerable research papers at national and international various forums. Professor academic record is very impressive, obtained a gold medal in his undergraduate course, and is a recipient of Yashashvi Sadhaka Award in 2011, Best Citizen of India Award in 2012, National Integration Award in 2015, RTI Awareness Award in 2015. Sir, on behalf of Kilpa, RVS, Vivipura College of Law, I extend a warm welcome to you, sir. May I request Lakshmi Shah, sir, to honor this. A knowledge summit such as this conference needs the support and blessings of diverse dignitaries. The institution deems to be its privilege to have been supported by Karnataka Institute of Law and Parliamentary Reform. The director of this institution, Shri Dwarakanath Babu sir, president of today's conference, who has been an important guiding force to this conference. Sir, I extend a very warm welcome to you, sir, on behalf of Raja Vakkaligara Sangha and Vishweshwarapura College of. I request Dr. Girish to. We have amongst us a great orator, dedicated teacher who has mesmerized scholars and people of variable calibers with his intelligent charm. That is Dr. Chidanand Reddy sir. Sir, I heartily welcome you on behalf of Raja Vakkaligara Sangha and Vishweshwarapura College of Law. I request Dr. Rashmi to welcome thee. It is an honor for me to welcome our chairman, sir, that is Law College Governing Council Chairman, Shri K.S. Suresh, who has been an instrumental in all our academic and co-curricular activities. Thank you very much. I take this opportunity to express my thanks for support and encouragement, sir. I request Vasavi ma'am to welcome the sir. I also extend a warm welcome to Dr. Evaya Odaya, researcher at Kilpar, organizing secretary of the conference. On behalf of Raja Vakkaligara Sangha and Vivipura College of Law, I welcome you, sir. A warm welcome is extended to resource person of today's technical session, Dr. Girish Kumar, Advocate High Court of Karnataka. Sir is with us, being a part of this inaugural session. Welcome you, sir. I also extend a warm welcome to all the panelists, paper presenter, participants who have come from various colleges. On behalf of Karnataka Institute of Law and Parliamentary Reforms, Raja Vakkaligara Sangha, Vivipura College of Law, I wholeheartedly welcome you all. A warm welcome is extended to the media persons. I also extend a warm welcome to all my beloved staff, dear students, and I hope you all will have a great time. And I apologize. I also extend a warm welcome to this conference, Mr. Vasant Ladwa, the syndicate member of KSLU. Sir, who is with us today. Welcome you, sir. Once again, a great welcome to you all. Thank you very much.
Thank you so much, ma'am. Now, I request all our dignitaries on the dais to light up the lamp of wisdom and start the conference.
K. Dwarakanath Babu, Director Kilpar, as a chairperson of the session. I extend a warm welcome to you, sir. Here is a brief profile. K. Dwarakanath Babu, Director Kilpar, Bengaluru. Sir completed his LLB in 1984 from Vivipura College of Law and joined government service and served more than 38 years. He was appointed as Secretary to the Government Department of Parliamentary Affairs and Legislation in 2013. He is also the member of Karnataka Law to the state legislature and subordinate legislature committees and drafted major legislations. Thank you, sir. On this occasion, we are blessed to have Speaker of the session, Professor Dr. C.S. Patil, Director, Research Department, Kilpar, and indeed it's my pleasure to extend a warm welcome to you, sir. Professor Dr. Chidananda Reddy S. Patil graduated from the University of Mysore and he moved over to Dharwad to pursue his studies in law at the University College of Law. He completed his LLB in 1986, obtained master degree in law from University of Mysore, specializing in constitutional law. He secured first class at University Dharwad. Patil sir has taught law for over 3 decades at JSS Law College, Mysuru, HAL Law College, Dharwad, KLE Law College, Bengaluru, University Law College, Dharwad, and KSLU Law School, Hubballi.
Hello.
Framework organized by Karnataka Institute for Law and Parliamentary Reforms, Kilpar, Bangalore, in association with Vivipura Law College of Law, Bangalore. First year LLB from Vivipura College of Law. Thank you all. Now, I would request our guest of honor, Honorable Mr. Justice Krishna Sir, Judge, High Court of Karnataka, Bangalore, to give inaugural address to the gathering.
ನಿಮ್ಮೆಲ್ಲರಿಗೂ ಮುಂಜಾನೆಯ ಅಭಿವಾದನ. ದೀಪಜ್ವಲನದಿಂದ ಪ್ರಾರಂಭವಾಗುವಂಥ ಮುಂಜಾನೆಯ ಸಮಾರಂಭ ಮನಸ್ಸಿಗೆ ತುಂಬ ಖುಷಿ ಕೊಡುವಂಥದ್ದು. I believe everybody will understand Kannada. I'll speak in English also, but Kannada is it's in my heart. But our constitution is written in English. That also you have to keep in view. Most of laws are in English. This hall is full of dignitaries today. So I offer my obeisance to each of the dignitaries, and everybody is a dignitary to me, those on the dais and off the dais. Professor C.S. Patil, Professor Basavaraju, Madam Principal, Directors, and the office bearers of Kaligara Sangha, galaxy of my friends in the front row who want to deter me being present here. It gives me a great pleasure that I have been invited for the inaugural lecture today. Had they not invited me, I would have asked them to summon me here. I would have told them, please invite me. The subject is very emotive, and the title of today's seminar conference. Honor killing framework of legislation. Honor and killing can never go together. The first edict of Lord Basaveshwara, I don't say that it is edict because he never made edicts as such. Everything was made by edicts in the West. In East, concept of edict was lesser, very, very less in obtainment. The first, perhaps, advice of Lord Basaveshwara, Kalabeda, then Kolabeda. Kalabeda, Kolabeda, Usiya Nudiyalu Beda, Anne Nindisabeda, Tanna Bannisabeda, Idiru Haliyalu Beda. Ide Antaranga Shuddhi, Ide Bahiranga Shuddhi. The first edict of Moses on the mountain, which the Christian literature called as sermons on the mount. Thou shalt not killest. You should never kill anybody. Why we should not kill? We should not kill because we cannot recreate who is killed. Your right to annihilate something cannot exist unless we have power to regenerate it. If that is so, if you are not supposed to denigrate anybody, how come that you will put an end to the life of anybody? That too in the name of honor. Maryada Hatya. It is like boiling ice. Can there be ice which boils? So Maryada and Hatya can never go together. But throughout the history, go to Hammurabi's edicts. There was honor killing. Some shlokas in Manusmriti give scope for the interpretation that there was honor killing that obtained during Manu's period, BC 1200, something like that. There is some debate which is the right timing of Manu, because there were many, 7 Manus. But there was such a suggestion, if you go by what P.V. Kane writes on history of Dharmashastras, Mahamahopadhyaya. But Manu also said, Yatra narestu pujjante, tatra ramante devataha. Where women are honored, the gods dwell there. This also he said. We cannot selectively approach the Smritikaras. Then I need not mention the other scriptures of other faiths, because I don't want to unnecessarily say something and create tumult. Already there is a lot of tumult in the society. The object of conference is not to generate more tumult, but to generate the thinking process, put it in the focus, enhance it to the higher levels. I understand all are dignitaries, I am repeating, and all are, it's very matured audience. Therefore, try to see the things in the right perspective. The honor killings, even in West, were rampant. We never made any legislation justifying killing of persons for trivial reasons. But in the West, there were legislations. Witch Hunt Act, prevention, from 15th century. women were killed. They were tied to the log and left in the Thames River. They were burnt alive. They were made to eaten by dogs in a spot where people would throng. Read Western history by Arnold Toynbee, Will Durant, the story of civilizations. Crime against women. The history is replete with instances. Nature has placed women arguably at some disadvantageous position, but men have made the things worse. Women, right from the days of Hammurabi, we take Hammurabi as the first lawgiver. I do not know on what basis he said in all jurisprudence, most of the famous jurisprudence books, including Salmon refers to Hammurabi, at least 11th edition of Fitzgerald, perhaps it may not. 11th edition by Glanville Williams mentions about that. Yes. Why women are targeted? That too in a country where scripture said they should be worshipped. The great position was given to women in this country. When debate took place between Mandana Mishra and Adi Shankaracharya, the judge was the woman, Ubhaya Bharati, and wife of Mandana Mishra himself. She gave a judgment against the husband and in favor of Adi Shankara. The great wives of Yagnavalkya, whom you study Yagnavalkya's writings are the basis of Mitakshara by Vijnaneshwara. Vijnaneshwara is commentary on Yagnavalkya's write-ups, which you study in Mitakshara. Mitakshara, Mita Akshara, limited letters, limited writing, by Rishi Vijnaneshwara of Maraturu in Gulbarga. They are commentaries on the works of Yagnavalkya, who had two wives. Maitreyi was one of them, and always used to consult Maitreyi. And without her approval, things were never put in public domain. Dr. Ambedkar, whom very often and almost in every conference, function, gathering, I cannot keep quiet. I cannot leave myself unuttered about Dr. Ambedkar, Baba Sahib, great soul. He used to consult Madam Savita. There's a famous book by Savita Deshpande, My Days with Dr. Ambedkar. He used to consult. Vasishta used to consult his wife Arundhati, and all Saptarishis except one, all they used to consult their wives. The Vedic literature injuncts, you cannot undertake any function, any ritual without having your wife beside. And she was called Ardhangini, Ardha Anga. Namma Ardha Nari, in Ardha Nara, Nara Nari, Ardha Narishwara. Ardha Narishwara, go to Google. The divine Ishvara is Ardha Nara, Ardha Nari. In us, there is a woman hidden, and in women, there is a man hidden. See the biology, evolutionary biology. Therefore, dishonoring woman is dishonoring men. Till perhaps 1891 in England, Professor C.S. Patil is here. In English legal history by Jackson, killing of wife was not an offense of manslaughter. Till 1891, because wife was considered to be part of the husband and it was considered as half suicide. Many were acquitted also. Only in 1890 when law came to be repealed. Till thereafter, decades, no right to vote was given to the women in the West. Compare this with our history. Compare this with our history. In Islamic law, very responsibly I am speaking now, and I am quoting the books also. Faiji's outlines of Muhammadan law, Mullah's Muhammadan law, Verma's Muhammadan law, Mitra's Muhammadan law. All these four books are, I am referring because highest court of the country has referred to them as the standard texts. For certain rituals in Islamic law, 2 women witnesses are required. 1 woman witness is no witness at all. I will not mention something in Bible. I don't want to, since it's a very matured audience. I will not much mention. You read. In almost all scriptures, regardless of the faiths, religions, traditions, there are some stanzas which are very, very derogatory to women. Almost, it's regardless of, this is religion neutral. Why that happens? There is one answer. There is one shloka. Ashwan naiva gajan naima Mruga naiva cha Aja putra balin detyat Daivo durbala ghatakaha. Darwin had said in his The Origin of Species. He said survival of the fittest. Of course, there is another book by Survival of the Sickest also is available in Google nowadays. The shloka says, when we offer a particular prey on the altar, what animal we will choose? ಆನೆಯನ್ನು ಬಲಿ ಕೊಡ್ತೇವಾ ಯಜ್ಞಕುಂಡಲದಲ್ಲಿ? ಅಶ್ವನ್ನೈವ. ಕುದುರೆಯನ್ನು ಕೊಡ್ತೇವಾ? ಅಶ್ವನ್ನೈವ. ಆನೆ ಇಲ್ಲ. ಗಜನ್. ಹುಲಿ ಸಿಂಹಗಳನ್ನು ಕೊಡ್ತೇವಾ? ಮೃಗ ನೈವಚ ಅವ್ನು ಕೊಡ್ಲಿಕ್ಕೆ ಹೋದ್ರೆ ನಮ್ಮನೆ ಆಹುತಿ ತೊಗೊಂಡ್ಬಿಟ್ರೆ ಹಾಗಾದ್ರೆ ಯಾವ್ದನ್ನು ಕೊಡ್ತೇವಿ? ಅಜ ಪುತ್ರ ಬಲಿನ್ ದೇತ್ಯಾತ್. ಅಜ ಅಂದರೆ ಆಡು ಸಂಸ್ಕೃತದಲ್ಲಿ. ಆಡಿಗೂ ಕೊಂಬಿರ್ತದೆ, ಅದು ಸ್ವಲ್ಪ ಹಿಂಗೆ ಗೋರು ಮಾಡಿದರೆ, ಹಾಗಾಗಿ ಆಡಿನ ಮರಿಯನ್ನು ಕೊಡ್ತೇವೆ. ಅಜ ಪುತ್ರ ಬಲಿನ್ ದೇತ್. ವಾಟ್ ಈಸ್ ದ ಮೆಸೇಜ್? ಲಾಸ್ಟ್ ಲೈನ್. ದೈವೋ ದುರ್ಬಲ ಘಾತಕಃ. ನೀವು ದುರ್ಬಲರಿದ್ರೆ ದೈವ ನಿಮಗೆ ಘಾತ ಮಾಡುತ್ತದೆ. ದೈವ ಅಂದರೆ ಸೊಸೈಟಿ, ಸ್ಟೇಟ್ ಆಲ್ಸೋ. ನೀವು ಪ್ರಬಲರಾಗಿದ್ದರೆ ಯು ಆರ್ ಪ್ರೊಟೆಕ್ಟೆಡ್. ಪ್ರಬಲ ಆಗೋದು ಅಂದ್ರೆ ಏನು ಮಾಡಬೇಕು? ನಾವು ಪ್ರಬಲರಾಗಿದ್ದೇವೆ ಅಂತ ನಮ್ಮಷ್ಟಕ್ಕೆ ನಾವೇ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಕೊಳ್ಳಿಕ್ಕೆ ಬರ್ತದ? ಇಲ್ಲ. ಜಗತ್ತಿನ ನಿಯಮ, ಯಾರು ಪ್ರಬಲರಿರ್ತಾರೋ ಅವರ ಪರವಾಗಿ ಯೂನಿವರ್ಸ್ ವಿಲ್ ಕಾನ್ಸ್ಪೈರ್. ದ ಯೂನಿವರ್ಸಲ್ ಪ್ರೊಸೆಸ್ ಕಾನ್ಸ್ಪೈರ್ಸ್ ನಾಟ್ ಇನ್ ಫೇವರ್ ಆಫ್ or not on the basis of right and wrong, but on the basis of strength and weakness. Those who are strong we will support them. Those who are weak we will finish them off. Will Durant, the great author of Story of Civilization, 11 volumes, he concised it in a small book, Lessons of History. Very small book, but 350 pages perhaps. ಅದರ ಥೀಮ್ ಏನು ಅಂದರೆ, ನಿಮಗೆ ಸ್ಟ್ರೆಂಗ್ತ್ ಇದ್ದರೆ, ನಿಮ್ಮ ಸ್ಟ್ರೆಂಗ್ತನ್ನು ಜಾಸ್ತಿ ಮಾಡಿಕೊಂಡ್ರೆ ನೀವೆಲ್ಲರೂ ಬದುಕ್ತೀರಿ, ಬಾಳ್ತೀರಿ, ಬೆಳೆತೀರಿ. ಇಲ್ಲ ಅಂದರೆ ಅಳಿತೀರಿ. ಅಳಿವು, ಫಾಲ್, ಯು ವಿಲ್ ವಿದರ್ ಅವೇ. ಬರೀ ನೀವು ಎಲ್ಲ ಮನುಷ್ಯರು ಒಳ್ಳೆಯವರಾಗಿರಬೇಕು, ಈ ಎಲ್ಲ ಸ್ಕ್ರಿಪ್ಚರ್ಸ್ನಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ. ಕುರಾನ್ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಬೈಬಲ್ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಸ್ಮೃತಿಕಾರರು ಹೇಳಿದ್ದಾರೆ, ವೇದದಲ್ಲಿ ಹೇಳಿದೆ, ಮನುಸ್ಮೃತಿಯಲ್ಲಿ ಹೇಳಿದೆ, ಯಾಜ್ಞವಲ್ಕ್ಯ ಸ್ಮೃತಿಯಲ್ಲಿ ಹೇಳಿದೆ, ಯೋಗ ವಾಸಿಷ್ಠದಲ್ಲಿ ಹೇಳಿದೆ, ಛಾಂದೋಗ್ಯೋಪನಿಷತ್ನಲ್ಲಿ ಹೇಳಿದೆ, ಕುರಾನ್ನಲ್ಲಿ ಹೇಳಿದೆ, ಝಂದಾ ಅವೆಸ್ತಾ ಪಾರ್ಸಿ ಗ್ರಂಥದಲ್ಲಿ ಹೇಳಿದೆ, ತೋರಾ ಆಫ್ ಜ್ಯೂಸ್ನಲ್ಲಿ ಹೇಳಿದೆ. ಒಳ್ಳೆಯರಾಗಿದ್ದೇವಾ? ಹಾಗಾಗಿ ಬರೀ ಹೇಳೋದನ್ನ ಬಸವೇಶ್ವರರು ಹೇಳಿದರು, ಎಂಥ ನಮ್ರವಾಗಿ ಹೇಳಿದರು. ಯಾವುದ್ಯಾವುದೋ ಕೆಳಗಿನ ಜಾತಿ ಎಲ್ಲ ಅವ್ರನ್ನೆಲ್ಲ ಕರ್ಕೊಂಬಂದು ಅನುಭವ ಮಂಟಪ ಮಾಡಿ ಅಲ್ಲಿ ಅವ್ರ ಕಡೆಯಿಂದ ನೀರು, ಜೋಳ, ಅಕ್ಕಿ, ಹಿಟ್ಟು ಅವ್ರ ಕೈಯಿಂದ ಅಡುಗೆ ಮಾಡಿಸಿ ಎಲ್ಲರಿಗೂ ಗುಣಪಡಿಸಿ ಎಲ್ಲರಿಗೂ ಚಿಂತನೆಗೆ ಹಚ್ಚಿ 12ನೇ ಶತಮಾನದಲ್ಲಿ ಅನುಭವ ಮಂಟಪ, ಅನುಭಾವ ಮಂಟಪ, MM ಕಲಬುರ್ಗಿ ಆಗಿದೆಯಾ? ಇಲ್ಲ. ಹಿಸ್ಟರಿ ಶಬ್ದವನ್ನು ನೀವು ತಗೊಳ್ರಿ. ಹೀಸ್ ಎ ಸ್ಟೋರಿ, ನಾಟ್ ಹರ್ ಸ್ಟೋರಿ. ಯಾವುದೇ ಧರ್ಮಗ್ರಂಥವನ್ನು ತೋಳಿ, ಯಾವುದನ್ನು ಹೆಸರು ಹೇಳೋ ಅಗತ್ಯ ಇಲ್ಲ. ನಿಮ್ಮೆಲ್ಲ ಮೆಚ್ಯೂರ್ಡ್ ಪೀಪಲ್, ಸಾಕಷ್ಟು ಅಧ್ಯಯನ ಮಾಡಿದಂಥವ್ರು ಎಲ್ಲ ಇರುವಂಥವರು. ನೀವು ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಗಿರ್ಬೋದು, ಅಥವಾ ನಮ್ಮ ಪ್ರೊಫೆಸರ್ಸ್ ಇರ್ಬೋದು, ಕುಮಾರ್ ಇರ್ಬೋದು, ಲಕ್ಷ್ಮೀಶ್ ಇರ್ಬೋದು, ಪ್ರೊಫೆಸರ್ಸ್ ಆರ್ ಆಲ್ಸೋ ಹಿಯರ್. ನಿಮಗೆಲ್ಲ ಎಕ್ಸ್ಪೋಜರ್ ಇರುವಂಥವರು. ಯಾವುದೇ ಗ್ರಂಥ, ಧರ್ಮಗ್ರಂಥಗಳನ್ನು, ಬಾರಿಂಗ್ ಫ್ಯೂ ಎಕ್ಸೆಪ್ಷನ್ಸ್ ಇನ್ ಇಂಡಿಯಾ, exceptions in India, because I do wide range. Somebody lied, your principal was lying to you in the morning. She is entitled to that. I am an voracious reader, which I am not. I am a limited reader. What I do, reading every day I do that. ಓದಂಗೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಈ ಎಲ್ಲ ಗ್ರಂಥಗಳನ್ನು, ಮತಗ್ರಂಥಗಳನ್ನು ಕಣ್ಮುಂದಿಟ್ಕೊಂಡು ಆಬ್ಜೆಕ್ಟಿವ್ಲಿ ನಾವು ಹೇಳೋದಿದ್ರೆ, ವುಮೆನ್ ಈಸ್ ನಾಟ್ ದೇರ್ ಫೋಕಲ್ ಪಾಯಿಂಟ್. ವಿಮೆನ್ ಆರ್ ನಾಟ್ ದೇರ್ ಫೋಕಲ್ ಪಾಯಿಂಟ್. ಮೆನ್ ಆರ್. ಎಲ್ಲೋ ಒಂದು ಕಡೆ ಮಾರ್ಜಿನಲ್ ರೆಕಾಗ್ನಿಷನ್ನು, ಎಕ್ನಾಲೆಜ್ಮೆಂಟ್, ಅವರ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಅದ ಎಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಭಾಳ ಮಾರ್ಜಿನಲ್ಲಿ ಆಗಿದೆ. ಯಾವ ಇತಿಹಾಸದ ಯಾವ ಘಟ್ಟದಲ್ಲಿ ಹೆಣ್ಣು ಗಂಡಸಿಗಿಂತ ಹಿಂದೆ ಉಳಿಯಂಗ ಮಾಡಲಾಯಿತು ಅಂತ ಹೇಳೋದು ಸ್ವಲ್ಪ ಡಿಫಿಕಲ್ಟ್. ಮ್ಯಾಟೆಲ್ಲಿ ಅನ್ನುವಂಥ ಫೇಮಸ್ ಡಾಕ್ಟರ್, ರೈಟರ್, ವುಮನ್ ಅನ್ನುವಂಥ ಪುಸ್ತಕ ಬರೆದಾಳೆ. ಒನ್ ಆಫ್ ದ ಫೈನೆಸ್ಟ್ ಬುಕ್ಸ್ ದಟ್ ರೀಸೆಂಟ್ಲಿ ಐ ಹ್ಯಾವ್ ರೆಡ್, ಮ್ಯಾಟೆಲ್ಲಿ. You can check in the Google. In fact, earlier primitive societies were matriarchal. ಅಲ್ಲಿ ತಾಯಿ ಸಾಮಾನ್ಯವಾಗಿ ನೆಟ್ಟಲ್ಲಿ ಬರೀತಾಳೆ, ಹೆಣ್ಣಿಗೆ ದಪ್ಪ ತೊಡೆಗಳು, ದಷ್ಟಪುಷ್ಟ ದೇಹ, ಹೀಗೆಲ್ಲ ಇತ್ತು. ಯಾಕಂದರೆ ಮಕ್ಕಳನ್ನು ತನ್ನ ತೊಡೆಯಲ್ಲಿ ಹಾಕ್ಕೊಂಡು ಬೆಳೆಸ್ಬೇಕು, ಅವು ಹಾಲು ಉಣಿಸ್ಬೇಕು, ಆಮೇಲೆಲ್ಲ ವ್ಯವಸ್ಥೆ ಮಾಡಿಕೊಡ್ಬೇಕು, ಅವರನ್ನು ತಗೊಂಡು ಬೇಟೆ ಹೋಗಬೇಕು, ಯಾವುದಾದ್ರೂ ಪ್ರಾಣಿ ಅಟ್ಯಾಕ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದರೆ ಮಕ್ಕಳನ್ನು ಹೊತ್ಕೊಂಡು ತಪ್ಪಿಸ್ಕೊಳ್ಬೇಕು. ಮ್ಯಾರೇಜ್ ಇರಲಿಲ್ಲ. ಮ್ಯಾರೇಜ್ ಇದ್ದರೆ ಹಸ್ಬೆಂಡ್ ಇರ್ತಿದ್ದ. ಮ್ಯಾರೇಜ್, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಮ್ಯಾರೇಜ್ ಕೇಮ್ ಮಚ್ ಲೇಟರ್ ಆಫ್ಟರ್ Cro-Magnons, to use words of MacIver and Page, the great anthropologists. After Cro-Magnon man, not even Homo sapien, Cro-Magnon, over 30,000 years ago in France, the Hotel Cro-Magnon was being excavated. At that time they found that ಆ ಪಳೆಯುಳಿಕೆ ಎಲ್ಲ ಸಿಕ್ತು. ಆ ಆಧಾರದ ಮೇಲೆ Cro-Magnon ಅಂತ ಕರೆದ್ರು ಆಂಥ್ರೋಪಾಲಜಿಯಲ್ಲಿ. Cro-Magnon ಪೀರಿಯಡ್ನಿಂದ ಆಯಿತು. ನಾಟ್ ಇವನ್ ನಿಯಾಂದರತಾಲ್, ಮಚ್ ಆಫ್ಟರ್ ನಿಯಾಂದರತಾಲ್. This being said, you have studied famous judgment Shantabai versus University of Madras, University of Madras versus Shantabai, where a lady from Udupi was denied admission to the college on the ground that no admission can be given to the women. Matter reached the highest court of the country, and court said university is not a state under Article 12, and therefore no relief was granted to the lady. This is after the constitution, enactment of the constitution. That judgment came to be reversed by Apex Court in Ujjambai versus State of UP years later, where university came to be held, an instrumentality of the state under Article 12 for the first time. To decide equality, we wanted to have the status of the entity which denied equality. What is the logic? If you say equality, it is equality. Can it be on the ground that it is theater that she wants to go? College? Tea stall? Hotel? Based on state, the gender. Have you ever seen any man being killed because he was in adulterous relationship? Till Macaulay enacted his code in Macaulay happened to be first chairman of the law commission, of the first law commission. Adultery, if women do it, they are not entitled to inherit the property. They are not entitled to maintenance at the hands of the husband. Where are the corresponding laws for the men? It is punishable. And see the provisions in CRPC, who can lodge the complaint? Bigamy. See the law. Who can lodge the complaint in adultery, in bigamy? Others have no locus standi. Though in criminal jurisprudence, the concept of locus standi is alien. Antule, A.R. Antule versus R.S. Naik, Shivdev Paswan versus Bihar, 19 at least, long. Concept of locus standi is alien to criminal jurisprudence. Therefore, anybody can set law in motion, criminal law in motion, but not the law relating to adultery, not the law relating to bigamy. There is legislative discrimination against women. Have you ever seen any man being killed on this Maryada Hatya? Who does it? It is men men only, maybe women also are betters. But the victim is invariably women. ಯಾಕೆ? ಹೆಣ್ಣು ತಾಯಿ ಸ್ವರೂಪ. ಹೆಣ್ಣಿಲ್ದಂಗೆ ನಾವು ಭೂಮಿ ಮೇಲೆ ಬರಲಿಕ್ಕೆ ಆಗ್ತಿತ್ತ? ದೇವರು ಸೃಷ್ಟಿ ಮಾಡಿದ್ದು ಬೈಬಲ್ನಲ್ಲಿದೆ. ದ ಗಾಡ್ ಕ್ರಿಯೇಟೆಡ್, ಪೋಪ್ ಇಸ್ ಟು ಸೇ, ದ ಗಾಡ್ ಕ್ರಿಯೇಟೆಡ್ Adam and Eve, not Adam and Steve. Without Eve, there could not have been this world. Adam and Eve ate the apple in the garden, Eden garden, and we all are here because of that is the biblical version. ಅವಳು, in fact, the Institution of Property by Bhalla, a book published by Indian Law Institute, he has traced history very beautifully. Women were treated as property of men in west, east, north, south, and in all ಅಷ್ಟದಿಕ್ಕು. ಎಲ್ಲ 8 ದಿಕ್ಕುಗಳಲ್ಲಿರುವಂಥ ಭೂಭಾಗಗಳಲ್ಲಿ women were treated as chattel. ಮನುಸ್ಮೃತಿಯಲ್ಲಿ ಒಂದಿದೆಯಲ್ಲ ಶ್ಲೋಕ, ಪಿತಾ ರಕ್ಷತಿ ಕೌಮಾರ್ಯೆ ಭರ್ತಾ ರಕ್ಷತಿ ಯೌವನೆ ರಕ್ಷಂತಿ ಸ್ಥವಿರೇ ಪುತ್ರ ನ ಸ್ತ್ರೀ ಸ್ವಾತಂತ್ರ್ಯಂ ಅರ್ಹತಿ. ಪಿತಾ ರಕ್ಷತಿ ಕೌಮಾರ್ಯೆ, ಚಿಕ್ಕವಳಿದ್ದಾಗ ಹೆಣ್ಣನ್ನು ತಂದೆ ಸಾಕ್ತಾನೆ. ಸಾಕ್ತಾನೆ ಅರ್ಥ ಸಲುಹುತ್ತಾನೆ. ಭರ್ತಾ ರಕ್ಷತಿ ಯೌವನೆ, ಯೌವನದಲ್ಲಿ ಗಂಡ ನೋಡ್ಕೊಳ್ತಾನೆ. ನಿಮ್ಮ ಲಾನು ಹಾಗೆ ಇದಾವೆ. ಮೋಸ್ಟ್ ಆಫ್ ದ ಲಾಸ್ ನೋಡಿಕೊಳ್ಳಿ. ಸೆಕ್ಷನ್ 125 of CRPC, judgments under section 151, the Hindu Maintenance, Adoption and Maintenance Act, and in Islamic literature from even before Shabanu, DV Act, Hindu Marriage Act, the Christian Marriage Dissolution Act, all. The duty is with the husband. Rare judgments are there. Allahabad High Court judgment is there. Wife should also maintain the husband if he is incapable of maintaining himself, provided wife has sufficient means. For men it is not a ground. You have no sufficient means is no ground to say that I don't want to maintain my wife. Beg, borrow, steal. For women, no. It's your duty. Duty arises under the religion, arises under the legislation, and arises under the reason. We wrote one judgment that way. Duty to maintain life, wife and children. There is lot of women feminist movement going on. The very basis of the movement is that women are different from men. Nobody can deny that. Women are different. Therefore, in feminist movement, what you will see is more women, not men. That being said, women are superior to, the difference is in degree of superiority. They are superior to us. Now you are speaking of a legislative framework to prohibit honor killing. 302 is not sufficient. 299, 300, 302 are not sufficient. Macaulay said, Rudyard Kipling said, if you go to Indian reservoirs and ಒಳಗಡೆ ಮುಳುಗಿ ಆ ರಿಸರ್ವಾಯರ್ಸ್ ನೆಲವನ್ನು ಮುಟ್ಟಿ ನೋಡಿ, ನಿಮಗೆ ಒಂದು ಬಾಣಂತಿಯ ಕೈ, ಮಗುವಿನ ಬುರುಡೆ ಸಿಗ್ತದೆ ಅಂತ ಬರೆದ ರುಡ್ಯಾರ್ಡ್ ಕಿಪ್ಲಿಂಗ್. ಥ್ರೂಔಟ್ ಹಿಸ್ಟರಿ there is bias against women. That's what Universal Declaration of Human Rights says, followed by CEDAW, UN resolution. The gender sexuality and religion tradition. With this, honor killing is associated. Gender, sexuality, religion and traditions. All they take birth in our mind. Creations of our mind. Therefore, address the psyche in a mass level. Just by making law, cannot wrote the edict he had built in 12th century. There is a famous story in 12th century, Jewish story. Canute and the tides. He had built a palace on the seashore and made a law. The tides shall not come to my house. The tides did not obey. Calendars, Bentham says, calendars, trees, bacteria, virus, animals do not obey law. Therefore, whole concept of person in Samand, to say rights and duties, they are founded on the concept of person. Unless personality is attributed, no right, no duty. Shivaji, the great Maharaja, Shivaji, he treated his reptile as a human being, Yashvanta. He used to call it as Yashvanta. Whenever he used to go for war, first question he would ask is, where is Yashvanta? Jatayu in Ramayana was treated by Rama and Lakshmana with the attributes of humanity. Hammurabi treated the ox with the elements of humanity and wrote with Samand says, if the ox were to gore a man to death, the ox shall be pelted with a stone and killed. And the bigger punishment is, his flesh shall not be eaten. ಅವನನ್ನು ಕೊಲ್ಲಬೇಕು. ಇದು ಒಂದು ಆ ಹಸುವನ್ನು ಅಥವಾ ಯಾವುದೇ ಪ್ರಾಣಿ ನಿಮ್ಮನ್ನು ಅದನ್ನು ಕೊಂದರೆ ಅದನ್ನು ಸ್ಟೋನ್ನಿಂದ ಹೊಡೆದು ಕೊಲ್ಲಬೇಕು. There are such scriptures, I will not name them. The woman in adultery should be stoned to death ಅನ್ನುವಂಥ ಸ್ಕ್ರಿಪ್ಚರ್ಸ್ ಇದಾವೆ. Since you are a matured audience, I will not say more. There are scriptures which say woman, wife more particularly, can be beaten with the branch of an olive tree, but its girth should not be larger than of your thumb. I will not naming the scripture. If anybody wants to verify, go to scriptures and see them. But throughout it is there. This ill treatment, this derogatory treatment of women, discrimination, rank discrimination, it is there throughout the history. Though the extent is coming down because of legislative measures, our constitution makes separate provision under Article 15. Article 15 makes a separate provision for women and children. We should say namaskar to Dr. Ambedkar. All women should ಪ್ರಾತಸ್ಮರಣೀಯ ಅಂತ ತಿಳ್ಕೊಳ್ಬೇಕು. ಮುಂಜಾನೆದ್ದಾಗನೇ ಒಂದು ಸಾರಿ ಎಲ್ಲ ಗ್ರೇಟ್ಸಿಗೆ ನಾವು ನಮಸ್ಕಾರ ಮಾಡ್ತೇವಲ್ಲ, ಅಂಬೇಡ್ಕರ್ ಅವರಿಗೆ ನಮಸ್ಕಾರ ಮಾಡಬೇಕು. ನಾನು ಅಂಬೇಡ್ಕರ್ ವಾದಿ ಅಲ್ಲ, ನಾನು ವಿಚಾರವಾದಿ ಒಂದು ರೀತಿ. ಆದರೆ ಅವರ ವಿಚಾರಗಳನ್ನು ಓದಿ ನೋಡಿದಾಗ ಎಂಥ ಪವರ್ಫುಲ್, ಎಷ್ಟು ಒಂದು ಹ್ಯೂಮನ್ ಅಪ್ರೋಚ್. ಅದರ್ವೈಸ್ ಪ್ರಾಪರ್ಟಿನೇ ಸಿಗ್ತಿರ್ಲಿಲ್ಲ ನಿಮಗೆ. ಇನ್ ಅಮೇರಿಕಾ ದೇರ್ ವಾಸ್ ನೋ ರೈಟ್ ಟು ವೋಟ್ ಟಿಲ್ 1932. ರೈಟ್ ಟು ವೋಟ್ ಇರಲಿಲ್ಲ, ಬಾರಿಂಗ್ ಮಾರ್ಜಿನ್ಸ್. ಪ್ರಾಪರ್ಟಿ ಹೋಗ್ಲಿ, ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಇರಲೇ ಇಲ್ಲ. ವೆದರ್ ಇಟ್ ವಾಸ್ ಶಾಸ್ತ್ರೀಕರಣ ಆರ್ ಅಶಾಸ್ತ್ರಿತ್ವ ವಿಚಾರ ಲೆಜಿಸ್ಲೇಟಿವ್ ಏನಿತ್ತು ಇಲ್ಲ ಎಕ್ಸೆಪ್ಟ್ ಮೇಂಟೆನೆನ್ಸ್. So I am extremely happy. Long lectures are not desirable, but generally my lectures are longer. ಬಹಳ ಖುಷಿ ಆಯಿತು. ಇಂಥ ಕಾನ್ಫರೆನ್ಸ್ ಆಗಬೇಕು, ಅವೇರ್ನೆಸ್ ಆಗಬೇಕು. ಬರೀ ಲಾ ಮಾಡೋದ್ರಿಂದ ಆಗಲ್ಲ ಅದು. ಮೆನಿ ಲಾಸ್ ಆರ್ ಡೆಡ್ ಬಿಕಾಸ್ the bulk of the community does not approve the definition of law. John Austin's definition of law, which Professor C.S. Patil myself very often used to quarrel about the definitions of law. Austin defined law as command of the sovereign, habitually followed by bulk of the community and sanctioned for violation. Bulk of the community should habitually obey it. If the bulk of the community does not obey, law loses link with the masses, and it will be no law, to use the words of Ehrlich, the German scholar, jurist. Ehrlich said, living law of the people idra matra samajakke upayoga. Exceptions ide, like William Bentinck, Sati prohibition, Sahagamana prohibition, Pundagandaya, Bentinck. So ಲೆಜಿಸ್ಲೇಟಿವ್ ವೇನಿಂದ ಪಬ್ಲಿಕ್ ಅವೇರ್ನೆಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡಬೇಕು ಅನ್ನೋದು ಒಂದು. ನೀವು ಮನೆಯಲ್ಲಿ ಹೇಳಬೇಕು, ಅಣ್ಣ ತಮ್ಮಂದ್ರಿಗೆ ಹೇಳಬೇಕು, ತಂಗಿಯರಿಗೆ ಹೇಳಬೇಕು. ನಿಮ್ಮ ಬೆಸ್ಟ್ ಟೈಮ್ನಲ್ಲಿ ಶುಡ್ ವಿಸ್ಪರ್ ಇನ್ ಟು ಯುವರ್ ಕಂಪ್ಯಾನಿಯನ್ಸ್. ವುಮೆನ್ ಆರ್ ಸ್ಪೆಷಲ್, ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಬಿ ಪ್ರೊಟೆಕ್ಟೆಡ್, ದೇ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಟು ಅಟಾನಮಿ. See that Neena Gupta case by the Supreme Court. See the privacy judgment. Air hostess case you have seen. Nargesh Mirza versus Air India, where Nargesh Mirza's employment, she was terminated for employment because she had begotten a child. The rule provided for termination, if an air hostess contracts marriage and begets a child, her beauty goes down, and therefore, that was the argument before the highest court of the country. Women lose beauty after procreation, but we want beautiful women in the airships. That was the argument. Read that judgment. Such ridiculous we are. Our concept of truth, beauty itself will be challengeable. Bhairappa's famous work, Truth and Beauty, Satyamattu Saundarya. Not that beauty, unless you read those things, unless you dispel your predilections. View means I. We. There cannot be change in the social attitude. The social attitude nalli ಬದಲಾವಣೆ ಬೇಕು ಅಂದರೆ ಇಂಥ ಕಾನ್ಫರೆನ್ಸ್ ಆಗಬೇಕು. ಇಂಥ ಕಾನ್ಫರೆನ್ಸ್ ಇನಾಗ್ರೇಟ್ ಮಾಡಲಿಕ್ಕೆ ನನ್ನನ್ನು ನೀವೆಲ್ಲ ಕರೆಸಿಕೊಂಡ್ರಿ, ಸಮನ್ ಮಾಡಿದ್ರಿ. Your summons, your invitation, it's a great honor to me, and very patiently you have heard my tortuous speech. Thank you. Thank you so much.
Sir, your numerous perspective on the topic enlightened us and have helped us to, get into deep research in the same topic. Thank you so much. Now I would request our guest, Professor Dr. C. Basavaraju Sir, Honorable Vice Chancellor, KSLU Hubballi, to present keynote address.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಟು ಒನ್ ಅಂಡ್ ಆಲ್. Respected on the dais, our Honorable Judge, High Court of Karnataka, Shri Justice Krishna S. Dikshit Sir, Director, Kiel Park, Shri K. Dwaraknath Babu, my colleague and presently the Director, Research in Kiel Park, Professor C.S. Patil, Chairman, Governing Council, Vivipura College of Law, Shri K.S. Suresh, Principal of this great college, Dr. Sudha, Research Head of Kiel Park and Organizing Secretary, Dr. Erevaya Odeyar, IQAC Director and my student, Dr. Sanjeev Gowda, all the dignitaries sitting before the dais, all my dear students, invitees, members from media, ladies and gentlemen. Today I am really so happy to hear our Honorable Justice very important issues raised and also clarified through various instances, quoting from different scriptures and various writers, not only Indian writers but also Western writers. I am always reminded of one Vachana, Basavanna's Vachana, before going into the concept of honor killing, Maryade Hatya. I am very much moved by the way in which Basavanna said in one of his vachanas, Ivanaraya, Ivanaraya, Ivanaraya endaniseraya, Ivanammava, Ivanammava, Ivanammava endenisaya. Such a great words always reminded of us. When we always speak about the discrimination, polarization, we should always remember Basavanna's Vachanas. You all know that Basavanna's Vachanas has created a great revolution in the entire world. ವಚನ ಕ್ರಾಂತಿಯ ಮೂಲಕ ಸಮಾಜವನ್ನು ತಿದ್ದುವ ಕೆಲಸವನ್ನು ಮಾಡಿದಂತಹ ಒಬ್ಬ ಶ್ರೇಷ್ಠ ವ್ಯಕ್ತಿ ಈ ವಿಶ್ವದಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತಂದರೆ ಅದು ಬಸವಣ್ಣ ಮಾತ್ರ ಅಂತ ನಾನು ಭಾವಿಸಿದ್ದೇನೆ. ಯಾಕೆ ಅಂತಂದರೆ ಅವರ ವಚನದಲ್ಲಿರ್ತಕ್ಕಂಥ ಮಾನವೀಯ ಮೌಲ್ಯಗಳು ಇವತ್ತು ಯಾವ ನಿರೀಕ್ಷಿತ ಮಟ್ಟದಲ್ಲಿ ನಾವು ನೋಡಬೇಕಾಗಿತ್ತೋ ಆ ಮಟ್ಟದಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ ನಮಗೆ. ಗ್ರೇಟ್ ಸೈಂಟಿಸ್ಟ್ಸ್ ಅಂಡ್ ಗ್ರೇಟ್ ಸೋಷಿಯಲ್ ರಿಫಾರ್ಮರ್ಸ್, they have left behind us human values for the reformation of the society. But still, even after 73 years we have completed from the date of Constitution came into force, we are debating on this discrimination and inequality in our society. ನಮ್ಮ ನಾಗರಿಕ ಸಮಾಜದಲ್ಲಿ ಅನೇಕ ಅನಾಗರಿಕ ಕೃತ್ಯಗಳು ಇವತ್ತು ಕೂಡ ಜ್ವಲಂತವಾಗಿದೆ ಅಂದರೆ ಇಟ್ಸ್ ಎ ಶೇಮ್ ಆನ್ ಅವರ್ ಪಾರ್ಟ್. 73 ವರ್ಷಗಳಲ್ಲಿ ಸಾಕಷ್ಟು ಸಾಧನೆಯನ್ನು ಮಾಡಿದ್ದೇವೆ ನಾವು. ಸಂವಿಧಾನ ಪೂರ್ವದಲ್ಲಿ ಅನೇಕ ಸಮಸ್ಯೆಗಳನ್ನು ನಾವು ಸಾಮಾಜಿಕ ಸಮಸ್ಯೆಗಳನ್ನು ಎದುರಿಸಿದ್ದೇವೆ, ಧಾರ್ಮಿಕ ಸಮಸ್ಯೆಗಳನ್ನು ಎದುರಿಸಿದ್ದೇವೆ. ಒಂದು ವರ್ಗ ಮತ್ತು ಇನ್ನೊಂದು ವರ್ಗದ ಸಂಘರ್ಷಣೆಯನ್ನು ನೋಡಿದ್ದೇವೆ. ಆದರೆ ಭಾರತ ಸಂವಿಧಾನ ಬಂದ ನಂತರ, ಜಾರಿಗೆ ಬಂದ ನಂತರ ಇನ್ನೂ ಕೂಡ ನಾವು ಅನೇಕ ಈ ಸಾಮಾಜಿಕ ಅನಿಷ್ಟ ಪದ್ಧತಿಗಳಲ್ಲಿ ಒಂದಾದಂತಹ ಈ ಮರ್ಯಾದೆ ಹತ್ಯೆಯನ್ನು ಜೀವಂತವಾಗಿ ನೋಡ್ತಿರ್ತಕ್ಕಂಥದ್ದು ಅತ್ಯಂತ ಅವಮಾನ, ಅಪಮಾನ, ನಮ್ಮ ಈ ಸಮಾಜಕ್ಕೆ. We are all responsible to this. It is not one individual or two individuals. We are all responsible to this social evil which still persists in the society. ಅನಿಷ್ಟ ಪದ್ಧತಿಯಾದಂತಹ ಅಸ್ಪೃಶ್ಯತೆ ಸಂಪೂರ್ಣವಾಗಿ ಸರ್ವನಾಶ ಆಗಿದೆ ಅಂತಕ್ಕಂಥದ್ದು ಕೂಡ ಅಸತ್ಯವಾದಂಥ ಮಾತು. ಯಾಕೆ ಅಂತಂದ್ರೆ ನಾವು ಈ ಒಂದು ವಿಚಾರ ಸಂಕಿರಣವನ್ನ ಪ್ರಾರಂಭ ಮಾಡುವಾಗ ಮೂಲ ಉದ್ದೇಶ ಇಂತಹ ಅನಿಷ್ಟ ಪದ್ಧತಿಗಳಿಗೆ ಏನಾದರೂ ನಾವು ಒಂದು ಪರಿಹಾರವನ್ನು ಕಂಡುಹಿಡಿಯಲಿಕ್ಕೆ ಸಾಧ್ಯನಾ, ಕಾನೂನಾತ್ಮಕವಾಗಿ ಕಂಡುಹಿಡಿಯಲಿಕ್ಕೆ ಸಾಧ್ಯನಾ, ಅಥವಾ ಮಾನವೀಯ ಮೌಲ್ಯಗಳ ನೆಲೆಗಟ್ಟಿನ ಒಳಗಡೆ ಕಂಡುಹಿಡಿಯಲಿಕ್ಕೆ ಸಾಧ್ಯ ಅಂತಕ್ಕಂಥದ್ದನ್ನ ಇವತ್ತು ನಾವು ಚರ್ಚೆ ಮಾಡಬೇಕಾಗಿದೆ. ಎಲ್ಲವನ್ನೂ ಕೂಡ ನಾವು ಕಾನೂನಿನ ಚೌಕಟ್ಟಿನ ಒಳಗೆ ಪರಿಹಾರವನ್ನು ಕಂಡುಕೊಳ್ಳಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಇಟ್ ಈಸ್ ಇಂಪಾಸಿಬಲ್ to remedy all our social evils through legislations. If the legislations are not respected, our laws are not taken into confidence, and what is the net effect of this law? As a result of this, a series of social evils are occurring in the society. It is very unfortunate that we have been discussing the discrimination, inequality, the exploitation against women even after so many years. There are so many reasons why this social evil exists in the society, because we know that we are all living in this state of dichotomy between the rich and the poor. This should go first. Dichotomy between the wise and virtue, dichotomy between the good and bad, and dichotomy between the male and female should go. Every individual in this society, as a person in the eye of law, should have an equal status, should have an equal benefit, should have an equal right to enjoy in this society. And until and unless that is contemplated and that is received from every individual, I think these kinds of social evils do exist in our society. There are so many reasons for these social evils. Earlier we used to talk about the caste system. Then we were talking about the untouchability. We are talking about the exploitation. And now in the 20th century, recently, we are talking about this honor killing. ಸಂವಿಧಾನದಲ್ಲಿರ್ತಕ್ಕಂಥ ಅಸ್ಪೃಶ್ಯತೆ ಅಂತಕ್ಕಂಥ ಈ ಒಂದು ಸಾಮಾಜಿಕ ಪಿಡುಗು ಬೇರೆ ಬೇರೆ ರೂಪಗಳಲ್ಲಿ ಇವತ್ತು ಕಾಣಿಸ್ಕೊಳ್ತಾ ಇದೆ. ಇವತ್ತು ಸ್ವಾತಂತ್ರ್ಯ ಬಂದಿದೆ, ನಮಗೆ ಈ ದೇಶಕ್ಕೆ ಸ್ವಾತಂತ್ರ್ಯ ಬಂದಿದ್ರೂ ಕೂಡ, ಸಂವಿಧಾನಿಕವಾಗಿ ಹಲವಾರು ಸ್ವಾತಂತ್ರ್ಯಗಳನ್ನು ನಮಗೆ ಸಿಕ್ಕಿದ್ರೂ ಕೂಡ ಕೆಲವು ವಿಚಾರಗಳಲ್ಲಿ ಇನ್ನೂ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ನಾವು ಪಡೆದಿಲ್ಲ. The best example is honor killing. If you don't have the freedom to enjoy your right, if you don't have a freedom to marry any individual of your choice, then what kind of freedom we are talking about? What kind of freedom we have in the Constitution if these freedoms are not respected by ourselves? And therefore, the honor killing, it always takes place as a result of the disruption of cultural and traditional beliefs. We have not come out even today from our traditional beliefs and our cultural beliefs. ಈ ಮೂಢನಂಬಿಕೆಗಳಿಂದ ನಾವು ಹೊರಬರಬೇಕಾಗಿದೆ. 73 ವರ್ಷಗಳನ್ನು ಕಳೆದಿದ್ದೇವೆ, ಮೂಢನಂಬಿಕೆಯಿಂದ ನಾವು ಇನ್ನೂ ಹೊರಗಡೆ ಬಂದಿಲ್ಲ. ನಮ್ಮ ಆಚಾರ ವಿಚಾರಗಳಿದೆಯಲ್ಲ ಅದು ನಮ್ಮ ಏಕತೆ, ಐಕ್ಯತೆ ಮತ್ತೆ ಒಬ್ಬ ವ್ಯಕ್ತಿಯ ಪ್ರಗತಿಯತ್ತ ನಾವು ಅದನ್ನು ಬಳಸಬೇಕೇ ವಿನಃ ಆ ವ್ಯಕ್ತಿಯ ವ್ಯಕ್ತಿತ್ವದ ಕುಂಠಿತಗೊಳಿಸುವ ದಿಕ್ಕಿನಲ್ಲಿ ನಾವು ಬಳಸಬಾರ್ದು. We have a good culture today. Our culture, Indian culture is very much appreciated by the Westerners. It is true. We always speak about a good culture. And good culture always nurtures a good citizens of this country. It is true. But this good culture shall not come in the way of enjoying your other freedoms which are guaranteed under the Constitution. Our framers of the Constitution, and especially I am focusing upon Dr. B.R. Ambedkar, he has given the various freedoms, keeping in mind that the vulnerable sections of this society, not only since the Constitution came into force, even prior to Constitution came into force, ಸಂವಿಧಾನ ಬರೋದಕ್ಕಿಂತ ಮುಂಚೆ ಇದ್ದಂಥ ಆ ಒಂದು ವ್ಯವಸ್ಥಿತ ಸಮಾಜ, ಅವರಿಗೆ ಆದಂಥ ಕಹಿ ಘಟನೆಗಳು, ಮಹಿಳೆಯರಿಗೆ ಆದಂಥ ಕಹಿ ಘಟನೆಗಳನ್ನು ಅವರು ನೆನಪಿಸಿಕೊಂಡು ಸಂವಿಧಾನಕ್ಕೆ ಹಲವಾರು ಹಕ್ಕುಗಳನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. In spite of all these things, today we are still living in the midst of this kind of social evils. The social evils which are tightening our freedoms, and our cultures are used for the pro-developmental process of humanity. It gives fruits, but it affects the growth of the individual, then it will never be appreciated. See, therefore, one of the reasons why this honor killing, which is becoming so rampant in the recent past, is the existence of caste and community norms. Until the caste system is completely obliterated from the society, I really do not know how many years still we take to obliterate this casteism, this caste factors, this untouchability, this discrimination and polarization among the individuals, even though they are endowed by nature equal status and equal opportunity. But still, we are living in this dichotomy. This caste and community norms, in fact, they are responsible for not allowing the men and women to go for marriage of a different caste, different community. The community and caste should not come in the way of enjoyment of individual freedoms. And of course, there are plethora of decisions given by the judiciary, including the Supreme Court. And I am sure that this kind of social evils, which always retards the development of the society, it retards the development, economic development, social development, cultural development of the society. And I am sure that after the Constitution came into force, economic development has taken place. Political democracy has been achieved. But have we achieved the social democracy? Had we achieved social democracy, why there have been so many honor killings in this civilized society? I think this is a time where we need to ponder ourselves. We need to introspect ourselves. What best we can do? Shall we regulate these kind of social evils like honor killing through a legislation, or creating awareness, creating human values, taking the human values down to the last man of the society, the common man of the society, and to understand the importance of these human values and human culture. That is why even at the initial stage of the education, our student must be inculcated with the culture, a good culture. And good culture always, in fact, it retards and it regulates these kind of social evils in the society. It is not only just legislation, it is not only the law. You cannot transfer everything in terms of law. You cannot regulate everything in terms of law. But human mindset should also be changed. If I do not change my mind, if I do not change my mind to respect the others, to give respect to the elders, to follow the human values, I think what law can do, law can punish, but it will never change my mindset, my culture, and my way of looking at the society. And I'm sure that in this conference, there are so many resource persons have come to address and to ponder over these issues. And I hope that many remedies will be addressed by the resource persons to bring back our society, which is thought of by our constitutional makers, that is egalitarian type of society. We need to have a society which is free from all kinds of evils, all kinds of discrimination, all kinds of inequalities. We had never expected that even after 73 years, this kind of social evils would exist. Every day, if you open the newspaper, television, every day you find, in one way or the other, in one manner or the other, you find there is an honor killing, honor crimes. And of course, even though we do not have a specific legislation, there are so many other legislations which support, which regulates the offense of honor killing. And in that way, and I'm sure that this conference would go a long way in identifying certain remedies to build our society, an egalitarian type of society, a society which is a healthy society and where everyone should live with peace and harmony. Thank you so much.
Thank you so much, sir, for providing us with your insights on honor killing. It was pleasure listening to you. Thank you once again. Now I would like to request our guest, Shri K. Dwarkanath Babu, sir, Director, Kilpar, Bangalore, to give away presidential address.
Good morning, everybody. ವೇದಿಕೆ ಮೇಲೆ ಇರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಎಸ್ ಟಿ ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಅವರೇ, ವೈಸ್ ಚಾನ್ಸಲರ್ ಆದಂಥ ಪ್ರೊಫೆಸರ್ ಬಸವರಾಜ್ ಅವರೇ, ಪ್ರೊಫೆಸರ್ ಸಿ ಎಸ್ ಪಾಟೀಲ್ ಅವರೇ, ಹಾಗೂ ವಿಪುರಂ ಲಾ ಕಾಲೇಜಿನ ಗವರ್ನಿಂಗ್ ಕೌನ್ಸಿಲ್ನ ಚೇರ್ಮನ್ ಆದಂಥ ಸುರೇಶ್ ಅವರೇ, ಹಾಗೂ ಈ ದಿನ ಈ ರಾಷ್ಟ್ರ ಮಟ್ಟದ ಒಂದು ಈ ಕಾನ್ಫರೆನ್ಸ್ ಏರ್ಪಡಿಸಿದ್ದೀವಿ. ಇದರಲ್ಲಿ ಪಾಲ್ಗೊಳ್ಳಕ್ಕೆ ಬಂದಂಥ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳೇ ಹಾಗೂ ಫ್ಯಾಕಲ್ಟಿ ಮೆಂಬರ್ಸ್, ನಮ್ಮ ಕರ್ನಾಟಕ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲಾ ಆ್ಯಂಡ್ ಪಾರ್ಲಿಮೆಂಟರಿ ರಿಫಾರ್ಮ್ಸ್ ಇದು 2005ರಲ್ಲಿ ಅಸ್ತಿತ್ವಕ್ಕೆ ಬಂದು ಇದು ಸರ್ಕಾರದ ಒಂದು ಅಂಗಸಂಸ್ಥೆಯಾಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೆ. ಇದರ ಒಂದು ಭಾಗವಾಗಿ ಈ ರೀತಿಯ ಒಂದು ಸೆಮಿನಾರ್ಸ್ ಮತ್ತು ಲೀಗಲ್ ಅವೇರ್ನೆಸ್ ಪ್ರೋಗ್ರಾಮ್ಸ್ನ ಹಮ್ಮಿಕೊಳ್ಳೋದು ನಮ್ಮ ಸಂಸ್ಥೆಯ ಧ್ಯೇಯಗಳಲ್ಲಿ ಒಂದಾಗಿದೆ. ಇವತ್ತಿನ ದಿನ ನಾವು ಹಾನರ್ ಕಿಲ್ಲಿಂಗ್ ಬಗ್ಗೆ ಒಂದು ಏನು ಚಿಂತನೆ ನಡೆಸಿದ್ದೀವಿ, ಇದು ಎಷ್ಟು ಪ್ರಸ್ತುತ, ಯಾಕೆ ಇನ್ನೂ ಈ ಕಾಲಘಟ್ಟದಲ್ಲೂ ನಾವು ಈ ಬಗ್ಗೆ ಕಾನೂನು ಬೇಕೇ, ಕಾನೂನು ಯಾಕಿಲ್ಲ, ಈ ಬಗ್ಗೆ ಚರ್ಚೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಮಾನ್ಯ ಜಸ್ಟಿಸ್ ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಅವರು ಹೇಳಿದರು, ಕಾಲ ಕಾಲಕ್ಕೂ ಹೆಣ್ಣನ್ನೇ ಬಲಿಪಶು ಮಾಡ್ತಾ ಬಂದಿದ್ದಾರೆ, ತಾರತಮ್ಯ ಮಾಡ್ತಾ ಬಂದಿದ್ದಾರೆ. ನಾ ಸ್ತ್ರೀ ಸ್ವಾತಂತ್ರ್ಯ ಅರ್ಹತಿ ಅಂತ ಮನುಸ್ಮೃತಿಯಲ್ಲಿ ಹೇಳಿದಂಥ ವಿಚಾರ ಕೂಡ ಕೋಟ್ ಮಾಡಿದರು. ಇದನ್ನು ಸರಿಪಡಿಸೋ ನಿಟ್ಟಿನಲ್ಲಿ ನಾವು ಒಂದು ಹೆಜ್ಜೆ ಇಡಬೇಕಾಗಿ ಬಂದಿದೆ. ಪಾಶ್ಚಿಮಾತ್ಯ ದೇಶಗಳಲ್ಲೂ ಸಹ ಈ ರೀತಿಯ ಹಾನರ್ ಕಿಲ್ಲಿಂಗ್ ಇತ್ತು ಅನ್ನೋದು ಕೂಡ ಹೇಳಿದರು. ನಮ್ಮ ಸಂವಿಧಾನದಲ್ಲಿ ಸಮಾನತೆ ಕೊಟ್ಟರು, ಆಸ್ತಿಯಲ್ಲಿ ಸಮ ಪಾಲು ಕೊಟ್ಟರು, ಎಕನಾಮಿಕ್ ಎಂಪವರ್ಮೆಂಟ್ ಆಫ್ ವುಮನ್, ಎಜುಕೇಷನಲ್ಲಿ ಎಂಪವರ್ಮೆಂಟ್ ಇದೆ, ಎಂಪ್ಲಾಯ್ಮೆಂಟಲ್ಲಿದೆ, ಸೋಷಿಯಲ್ ಎಂಪವರ್ಮೆಂಟ್ ಆಗಬೇಕಾಗಿದೆ. ಅದು ಆಗದಿರ ಅವರಿಗೆ ಸಮಾನತೆ ಸಿಕ್ಕಲ್ಲ. ಆದರೆ ಅವರ ಕೆಲವು ವೀಕರ್ ಸೆಕ್ಸ್ ಅಂತ ಏನು ಕರಿತೀವಿ, ಅದೇ ಅವರ ದೌರ್ಬಲ್ಯ ಅನ್ನೋ ರೀತಿ ಮನುಷ್ಯ ಡಾಮಿನೇಟ್ ಮಾಡ್ತಾ ಬರ್ತಾ ಇದ್ದಾನೆ. ಹಾನರ್ ಕಿಲ್ಲಿಂಗ್ ಇದು ತಾವೆಲ್ಲ ಗಮನಿಸಿದ್ದೀರಿ. ಅಂತರ್ಜಾತೀಯ ವಿವಾಹಗಳಾದಾಗ ಇದು ಹಾನರ್ ಕ್ರೈಮ್ಸ್ ಮತ್ತು ಹಾನರ್ ಕಿಲ್ಲಿಂಗ್, ಇದು ಏನು ಒಂದು ಆ ಸೋಷಿಯಲ್ ಪಂಚಾಯತ್ಸ್ ಅಂತ ಏನು ಹೇಳ್ತೀವಿ, ಕಮ್ಯುನಿಟಿ ಪಂಚಾಯತ್ಸ್ ಅಥವಾ ಕ್ಯಾಪ್ ಪಂಚಾಯತ್ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೂಡ ಹೇಳಿದೆ. ಇಲ್ಲಿ ತೆಗೆದುಕೊಳ್ಳುವಂಥ ತೀರ್ಮಾನ ಅವ್ರನ್ನ ಸಮಾಜದಿಂದ ಬಹಿಷ್ಕಾರ ಹಾಕೋದು, ಸಮಾಜದ ಕಟ್ಟುಪಾಡುಗಳಿಗೆ ಅವ್ರನ್ನ ಒಳಪಡಿಸೋದು, ಸೋಷಿಯಲ್ ಬಾಯ್ಕಾಟ್ ಇದೆಯಲ್ಲ, ಇದು ಒಂಥರ ಕ್ರೈಮ್. ಇದರ ಮುಂದುವರೆದ ಭಾಗವೇ ಅವ್ರನ್ನ ಕೊಲ್ಲುವಂಥ ಕಾರ್ಯ ನಡೀತಾ ಇದೆ. ಹಳ್ಳಿಗಳಲ್ಲಿ ದಿನ ಬೆಳಗಾದರೆ ಪತ್ರಿಕೆಯಲ್ಲಿ ವರದಿ ಆಗುತ್ತೆ, ಪೆಟ್ರೋಲ್ ಹಾಕಿ ಸುಟ್ಟು ಬಿಡೋದು, ಯಾವ ಎವಿಡೆನ್ಸೂ ಇಲ್ಲ. ಅವರಿಗೆ ನಮ್ಮ ಸಂವಿಧಾನದಲ್ಲಿ ಆರ್ಟಿಕಲ್ 19 ಮತ್ತು 21 ಏನು ರೈಟ್ ಟು ಲಿವ್, ರೈಟ್ ಟು ಚೂಸ್ ಲೈಫ್ ಪಾರ್ಟ್ನರ್ ಎಲ್ಲ ಹೇಳಿದ್ರು ಕೂಡ ಸಿಗ್ತಾ ಇದೆಯಾ? ಇದನ್ನು ಯಾವ ರೀತಿ ಪರಿಹರಿಸಬೇಕು ಅನ್ನೋದು ಪ್ರಶ್ನೆ ಇವತ್ತು ನಮಗೆ ಸವಾಲಾಗಿದೆ. ಇವತ್ತು ನಾವು ಇದನ್ನು ಚರ್ಚೆ ಮಾಡಲಿಕ್ಕಾಗಿ ಇಲ್ಲಿ ಸೇರಿದ್ದೀವಿ. ಈ ಸಂಬಂಧ ಒಂದೆರಡು ಮಾತು ಹೇಳಬೇಕಂದ್ರೆ, ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಕಾಲ ಕಾಲಕ್ಕೆ ಇದನ್ನು ಹೇಳ್ತಾ ಬಂದಿದೆ, ಇದು ತಪ್ಪು, ಇದು ಮಾಡಬಾರ್ದು ಅಂತ. 2018ರಲ್ಲಿ ಶಕ್ತಿ ವಾಹಿನಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಏನು ಬಂತು, ಅದರಲ್ಲಿ ಕೆಲವು ಗೈಡ್ಲೈನ್ಸ್ ಕೂಡ ಹಾಕಿದ್ದಾರೆ. ಯಾವ ರೀತಿ ಸರ್ಕಾರ ಇದನ್ನು ತಡೆಗಟ್ಟಬೇಕು ನೋಡಿ. ಕೊಂದರೆ IPC ಬರುತ್ತೆ, ಕೊಂದಾದ್ಮೇಲೆ ಹೇಗೆ ವಾಪಸ್ ತರ್ತೀರಾ? ಬಲಿಪಶು ಆದವ್ರನ್ನ ಕ್ಯಾನ್ ವಿ ಬ್ರಿಂಗ್ ದೆಮ್ ಬ್ಯಾಕ್? IPC ಇದೆ, ಕ್ರಿಮಿನಲ್ ಕಾನ್ಸ್ಪಿರಸಿ ಪ್ರೊವಿಷನ್ಸ್ ಇದೆ, ಅಬೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಫೆನ್ಸ್ಗೆ ಪ್ರೊವಿಷನ್ ಇದೆ, 301, 302 ಇವೆಲ್ಲ ಇದೆ. ಆದರೆ ಕೊಲ್ಲಕ್ಕೆ ಮುಂಚೆ ತಡೆಯೋದು ಹೇಗೆ? ಈ ಬಗ್ಗೆ ಚಿಂತನೆ ಆಗಿ ನಮ್ಮ ಲಾ ಕಮಿಷನ್ಸ್ ವರದಿ ಕೂಡ ನಾವು ಇಲ್ಲಿ ಗಮನಿಸಬೇಕಾಗುತ್ತೆ. ಲಾ ಕಮಿಷನ್ ತನ್ನ ವರದಿಯಲ್ಲಿ ಹೇಳಿದೆ, ಈ ಲೆಜಿಸ್ಲೇಷನ್ನಲ್ಲಿ ಪ್ರಿವೆಂಟಿವ್ ಮೆಷರ್ಸ್ ಆರ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಪೋಸ್ಟ್ ಕಿಲ್ಲಿಂಗ್ ಅದು ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ, ಅವನು ತಗೊಂಡೋಗಿ ಜೈಲಿಗೆ ಹಾಕ್ತಾರೆ. ಅದೊಂದು ಭಯ ಇರುತ್ತಷ್ಟೇ. ಕೊಲ್ಲಬಾರ್ದಂತ ಭಯ ಇದ್ದರೂ ಕೊಲೆ ನಿಂತಿದೆಯಾ? ರೇಪ್ ಮಾಡಬಾರ್ದು, ಅದು 10 ವರ್ಷ ಜೈಲು, ಏನು ಲೈಫ್ ಸೆಂಟೆನ್ಸ್ ಅಂದರೂ ರೇಪ್ ಮಾಡೋದು ನಿಂತಿದೆಯಾ? ಈ ರೀತಿ ಡಿಟ್ರೆಂಟ್ ಆಗಿ ಇಟ್ಟರೂ ಕೂಡ ಜನ ಭಯ ಪಡ್ತಿಲ್ಲ. ನಮ್ಮ ಬಸವರಾಜ್ ಸಾಹೇಬರು ಹೇಳ್ತಾ ಇದ್ರು ವಚನಗಳು ಅಂತ. ನನಗೆ ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ವಚನ ಜ್ಞಾಪಕ ಬರುತ್ತೆ. ನಾವು ತಿದ್ದುಗೊಳ್ದೀರ ಸಮಾಜ ಸರೋಗಲ್ಲ. ನಾವು ಪ್ರತಿಯೊಬ್ಬರೂ ತಿದ್ದುಕೋಬೇಕು. ನಿಮ್ಮ ತನುವ ಸಂತೈಸಿಕೊಳ್ಳಿ, ನಿಮ್ಮ ಮನವ ಸಂತೈಸಿಕೊಳ್ಳಿ. ಆವಾಗ ಲೋಕದ ಡೊಂಕು ತಾನಾಗೇ ಇದಾಗುತ್ತೆ ಅಂತ. ಆದರೂ ಜನ ತಿದ್ದುಕೊಳ್ಳಲ್ಲ. ಅವರಿಗೆ ಈ ಪೀನಲ್ ಕ್ಲಾಸ್ ಇಲ್ದಿರ ಭಯ ಬರೋಲ್ಲ. ಸೊ ಇಲ್ಲಿ ನಾವು ಚಿಂತನೆ ಮಾಡಬೇಕಾಗಿರೋದು ಇಷ್ಟೇ, ಪ್ರಿವೆಂಟಿವ್ ಮೆಷರ್ಸ್. ನಾವೇನಾದರೂ ಕಾನೂನು ಅಂತ ಮಾಡಿದರೆ ಯಾವ ಪ್ರಿವೆಂಟಿವ್ ಮೆಷರ್ಸ್ ತಗೋಬೇಕು? whenever we find that this kind of ಕಾನ್ಸ್ಪಿರಸಿ is going on, ಅಥವಾ ಈ ರೀತಿಯ ಒಂದು ಘಟನೆ ನಡೀತಾ ಇದೆ ಅನ್ನೋ ಸುದ್ದಿ ಯಾರಿಗಾದರೂ ಗೊತ್ತಾದರೆ ಇಮ್ಮಿಡಿಯೇಟ್ ಸಬ್ ಡಿವಿಷನಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಗೋ ಅಥವಾ ಪೊಲೀಸ್ ಕಮಿಷನರ್ಗೋ ಸುದ್ದಿ ಮುಟ್ಟಿಸಿದ್ರೆ, ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ಗೆ ಇಮ್ಮಿಡಿಯೇಟ್ ಅವರು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕು. ಅದನ್ನು ನಿಲ್ಲಿಸೋದಕ್ಕೆ ಕ್ರಮ ತಗೋಬೇಕು. ಸಬ್ ಡಿವಿಷನಲ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಗೆ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡುವ ಮತ್ತು ಆ ವಿಚಾರದಲ್ಲಿ ತೊಡಗಿಕೊಳ್ಳೋರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡುವಂಥ ಪ್ರೊವಿಷನ್ಸ್ ತರಬೇಕು ಅನ್ನೋದು ಶಿಫಾರಸಾಗಿದೆ. ಈ ಪ್ರೊವಿಷನ್ಸ್ನ ನಾವು ಗಮನದಲ್ಲಿಟ್ಕೊಂಡು ಹೊಸ ಶಾಸನ ಮಾಡುವಾಗ ಘಟನೆ ನಡೆದ ಮೇಲೆ ಮಾಡುವಂಥ ಪೆನಾಲ್ಟಿಗಿಂತ ಘಟನೆ ನಡೆಯೋಕ್ಕೆ ಮುಂಚೆ ಅದನ್ನು ತಡೆಯೋದಕ್ಕೆ ಏನು ಮಾಡಬೇಕು ಅನ್ನೋ ಪ್ರೊವಿಷನ್ ನಾವು ಮಾಡಬೇಕಾಗುತ್ತೆ. ಇದಕ್ಕೆ ಉದಾಹರಣೆ ಹೇಳಬೇಕಾದ್ರೆ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಪ್ರೊಹಿಬಿಷನ್ನಲ್ಲಿ ಕೂಡ ಆ ಪ್ರೊವಿಷನ್ ಇದೆ. ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ನಡೀತಿದೆ ಅಂತ ವಿಚಾರ ಗೊತ್ತಾದರೆ ಚೈಲ್ಡ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್ ಅಲ್ಲಿ ಹೋಗಿ ಅದನ್ನು ತಡೆಯುವಂಥ ಮತ್ತು ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡುವಂಥ ಪ್ರೊವಿಷನ್ ಇದೆ. ಸಿಮಿಲರ್ ಪ್ರಾವಿಷನ್ ವಿ ಹ್ಯಾವ್ ಮೇಡ್ ಇನ್ ದೇವದಾಸಿ ಆ್ಯಕ್ಟ್. ನಮ್ಮ ಕರ್ನಾಟಕದಲ್ಲಿ ದೇವದಾಸಿ ಪದ್ಧತಿ ಅಂತ ಒಂದು ಅನಿಷ್ಟ ಪದ್ಧತಿ ಇದೆ. ಅದರಲ್ಲಿ ಈ ಕರಿಮಣಿ ಕಟ್ಟುವಂಥ ಒಂದು ಶಾಸ್ತ್ರ ಕೂಡ ಇದೆ. ಕರಿಮಣಿ ಕಟ್ತಿದ್ದಾರೆ ಅಂದರೆ ಕಟ್ಟಿದಾದ ಮೇಲೆ ಅವಳು ದೇವದಾಸಿ ಪದ್ಧತಿಗೆ ಒಳಗಾಗ್ತಾಳೆ ಅನ್ನೋದು. ಆ ಕಟ್ತಿದ್ದಾರೆ ಅನ್ನೋ ಸುದ್ದಿ ಗೊತ್ತಾದರೆ ತಹಸೀಲ್ದಾರ್, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಇಮ್ಮಿಡಿಯೇಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿ ಅದನ್ನು ಸ್ಟಾಪ್ ಮಾಡುವ ಮತ್ತು ಆ ವಿಚಾರದಲ್ಲಿ ಯಾರ್ಯಾರು ತೊಡಗಿಸ್ಕೊಂಡಿದ್ದಾರೋ ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡುವ, ಅವರಿಗೆ ಶಿಕ್ಷೆಗೆ ಒಳಪಡಿಸುವಂಥ ಪ್ರೊವಿಷನ್ಸ್ ಮಾಡಿದ್ದೀವಿ ನಾವು ದೇವದಾಸಿ ಆ್ಯಕ್ಟಲ್ಲಿ. ಆ್ಯಂಡ್ ವಿ ಗಾಟ್ ಎ ಪ್ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅಸೆಂಟ್ ಆಲ್ಸೋ ಟು ದಟ್ ಲಾ. ಸಿಮಿಲರ್ ಪ್ರೊವಿಷನ್ I think we require to be done in this honor killing. ಯಾರು ಈ ರೀತಿಯ ಒಂದು ಪ್ರೀತಿಸಿ ಮದುವೆ ಆದಂಥ ಹುಡುಗ ಹುಡುಗಿಯೋ, ಇದರಲ್ಲಿ ದುರುಪಯೋಗ ಆಗಲ್ಲ ಅಂತ ನಾನು ಹೇಳಲ್ಲ. ನೀವು ಇದು ಒಂದು ಸೋಷಿಯಲ್ ಈವಿಲಲ್ಲಿ ಇನ್ನೊಂದು ದುರುಪಯೋಗ ಆಗುವಂಥ ಆ್ಯಂಗಲ್ ಕೂಡ ಹೇಳಿರ್ತೀನಿ. ಈ ಲವ್ ಜಿಹಾದ್ ಅನ್ನೋ ಹೆಸರಿನಲ್ಲಿ ಹೆಣ್ಮಕ್ಳನ್ನ ಮರಳು ಮಾಡಿ ಮತಾಂತರ ಮಾಡುವಂಥ ಇದು ನಡೀತಾ ಇದೆ. ಇದು ಒಂದು ಸೋಷಿಯಲ್ ಈವಿಲ್ ಇರ್ಬೋದು. ಆದರೆ ಸ್ವತಂತ್ರ ಆಗಿ ಈಗ ಇಷ್ಟಪಟ್ಟು ಮದುವೆ ಆಗೋರಿಗೆ ಆ ಸ್ವಾತಂತ್ರ್ಯ ಕೊಡ್ದಿರ ಹೋಗುವುದು, ಅಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಪೊಲೀಸ್ನವರು ಸಹಾಯಕ್ಕೆ ಬಂದು ಅವ್ರನ್ನ ಮದುವೆನೂ ಮಾಡಿಸ್ಬೇಕು ಅಂತ ಕೂಡ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದೆ. ಅವ್ರಿಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಬೇಕು, ಅವ್ರಿಗೆ ವಾಸ ಮಾಡೋಕ್ಕೆ ಪೀಸ್ಫುಲ್ಲಾಗಿ ಬದುಕೋದಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಡ್ಬೇಕು ಅಂತ ಕೂಡ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹೇಳಿದೆ. ಅದನ್ನು ನಾವು ಕಾನೂನಲ್ಲಿ ಅಳವಡಿಸಿಕೊಂಡು ಅಂಥ ಪ್ರಿವೆಂಟಿವ್ ಮೆಷರ್ಸ್ ಏನೇನು ಅಂತ ಈಗಾಗಲೇ ಲಾ ಕಮಿಷನ್ ತನ್ನ ವರದಿಯಲ್ಲಿ ಹೇಳಿದೆ. ಇನ್ನೊಂದು ಈ ವಿಚಾರದಲ್ಲಿ ಹೇಳಬೇಕಾದ್ರೆ 3 ರಾಜ್ಯಗಳಲ್ಲಿ, ರಾಜಸ್ಥಾನ ಮತ್ತು ಇನ್ನೂ ಇತರ 3 ರಾಜ್ಯಗಳಲ್ಲಿ ಈ ಲೆಜಿಸ್ಲೇಷನ್ ಪಾಸಾಗಿ ಪ್ರೆಸಿಡೆಂಟ್ ಅಸೆಂಟ್ಗೆ ಹೋಗಿದೆ. ಆದರೆ ಪ್ರೆಸಿಡೆಂಟ್ ಅಸೆಂಟ್ ಸಿಕ್ಕಿಲ್ಲ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನಮ್ಮ ಸರ್ಕಾರ ಏನು ಕ್ರಮ ತಗೋಬೇಕು, ಯಾವ ರೀತಿ ಇದನ್ನು ತಡೆಗಟ್ಟುವಂಥ ಪ್ರಿವೆಂಟಿವ್ ಮೆಷರ್ಸ್ ತಗೋಬೇಕು, ಇವತ್ತು ಆ ವಿಚಾರ ಚಿಂತನೆ ಆಗಲಿ. ನೀವೆಲ್ಲ ಇದನ್ನು ಚರ್ಚೆ ಮಾಡಿ ಸರ್ಕಾರಕ್ಕೆ, ನೀವು ಫ್ಯಾಕಲ್ಟೀಸ್ ಇರ್ಬೋದು, ಸ್ಟೂಡೆಂಟ್ಸ್ ಇರ್ಬೋದು, ಯು ಕ್ಯಾನ್ ಗಿವ್ ಗುಡ್ ರೆಕಮೆಂಡೇಷನ್ಸ್ ಟು ದಿ ಗೌರ್ಮೆಂಟ್. ಇದನ್ನು ನಾವು ಎದುರು ನೋಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ನನ್ನ ಮಾತನ್ನ ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ.
Thank you so much for your words and insights, sir. It was indeed very meaningful and knowledgeable. Thank you once again. Finally, I would now like to call upon our beloved Assistant Professor of Law, IQAC Coordinator, Vivipuram College of Law, Dr. Sanjeev Gowda, sir, to give away the vote of thanks for the inaugural program.
Good morning, all. Respected dignitaries on the dais, legal academia, and student friends. Indeed, it is my great privilege to express gratitude to today's guest. On behalf of Karnataka Institute for Law and Parliamentary Reforms and Visvesvarapura College of Law, I extend our heartfelt gratitude to Honorable Mr. Justice Krishna S. Dikshit, Judge, High Court of Karnataka, for gracing inauguration of our national conference. Sir, your willingness to share your wisdom and expertise has deeply enriched our community for a long time. We are truly honored to have you inaugurate this significant gathering. Thank you, sir. Thank you very much on behalf of all, sir. I would like to extend our heartfelt thanks to Professor Dr. C. Basavaraju, Honorable Vice Chancellor, Karnataka State Law University, for gracing us with their insightful and inspiring words. Sir, your expertise has enlightened us all, offering a fresh perspective in a valuable knowledge that will undoubtedly resonate within our professional and personal endeavors. We are truly honored to have you, sir. Thank you very much once again. Friends, today we have another revered teacher, Professor Dr. C.S. Patil, Research Director, Karnataka Institute for Law and Parliamentary Affairs. Sir, thank you very much for your presence, sir. Truly, sir, truly. Thank you, sir. Thank you very much. Yes, I thank Dr. K. Dwarkanath Babu, Director, Kilpar, for constant support to materialize this event. Sir, thank you very much on behalf of Rajya Vakkaligara Sangha and Visvesvarapura College of Law. Sir, I would like to extend my heartfelt thanks to our Chairman, Governing Council, Vivipura College of Law. Sir, thank you very much for your constant support to materialize this function. Today we have another guest, Mr. Vasant Ladwa, Syndicate Member, Karnataka State Law University. Sir, thank you very much for your presence. All the way you have come over here and witnessed this great event. Thank you very much, sir. And yes. Madam. We have another person, Madam Savitramma, Syndicate Member, Karnataka State Law University, Government Advocate, High Court of Karnataka. Madam, thank you very much for your presence. A guiding force behind this event, our beloved Principal Dr. Sudhaji, Principal and Conference Director. Thank you very much, Madam, for your support and guidance. And my dear colleague, friend, Dr. Revaya Vadayar, Research Head, Karnataka Institute for Law and Parliamentary Affairs, Organizing Secretary of this event. Sir, thank you very much. And I extend my heartfelt thanks to all panelists. So here we have a Professor Dr. C.S. Patil sir, then Honorable Justice Ashok G. Nijakandan is going to join in the first technical session, member Karnataka State Law Commission. And I extend my heartfelt thanks to KBK Swami, another panelist. And we have a speaker, Dr. Girish Kumar R., Advocate, High Court of Karnataka, Bangalore. Sir, thank you very much. And I extend all, grateful thanks to all the faculty members come over here to witness this program and student friends. Thank you all. Thank you one and all again.
Good morning, respected dignitaries on the dais and off the dais. Hi, Vasvi Shri Harsha, of the Syndicate and Academic Council of KSLU and Director of KSLU Law School for 7 years and Head of the Research Center for Democracy and Constitutional Government. He superannuated on 31st August 2023.
Listening to the lecture of most eminent and veteran professors of our universities. And most importantly, two eminent speakers are here. One is Dr. Professor C.S. Patil and Dwarkanath sir. With them, the team of professors of Vivipuram Law College and lecturers and professors from other colleges and the most bright student coming from various colleges. And I extend my profound thanks to this institution for inviting me to deliver the lecture on the issue of honor killing. My friends here, please understand the term expression honor killing. When you translate it into Kannada, it is far more dangerous than honor killing. Maryada Hatya. How powerful, how lethal the expression is very, very important. In the name of honor of any family or of any particular community or of any particular caste or of any society, violent incidents are taken place in the subcontinent. And my friends here, honor killing is a global phenomenon. It is not restricted to India or not restricted to any one particular part of the Indian subcontinent like Western Uttar Pradesh. Western Uttar Pradesh is the most prominent place where nearly half of the honor killings are taking place in India. It has attained such an authority, Western Uttar Pradesh, and some parts of Rajasthan, Haryana are known for honor killing. And nowadays in Karnataka, And most importantly, in Tamil Nadu, the southern state, the incidence of honor killing is rampant. If we give a restricted meaning to the word or expression honor killing, we are doing some offense to this particular issue. I can tell you, my friends, if you look at the history, if you turn the pages of history, honor killing is not a new phenomenon. When you go back to history in 12th century, during the time of Lord Basaveshwara, Anna Basavanna, there was a violent incident in the state of Kalyana ruled by King Bijjala. You may be aware of the fact that there was a person called as Samagara Chennaya, and his son fell in love with Madhuvarasa's daughter, and Madhuvarasa come from an high priest family, and Samagara Chennaya, and he was a person who was into the profession of manufacturing of footwears. I mean, they were in love, and Anna Basavanna decided to solemnize their marriage. That was an intercaste marriage which was opposed by the priestly class. As far as Karnataka is concerned, I can tell you with historical findings that may be one of the most violent honor killing which ever took place in the history of Karnataka. Ultimately, King Bijjala was forced to eliminate the young couples. The parents of the young couples were tied to the legs of the elephant, and they were taken all throughout the town of Kalyana. It was the most brutal, you can call it as, you can go back to if you turn the pages of the revolution of 12th century Kalyana, you can see there was a punishment called as Ele Ute Shikshe. Ele Ute, that's a Kannada word. Ele Ute andre, ಆನೆಯ ಕಾಲಿಗೆ ಗಮನಿಸ್ಕೊಳ್ಳಿ, ಆನೆ ಹತ್ರ ಹೋಗ್ಲಿಕ್ಕೆ ನಿಮಗೆಲ್ಲ ಭಯ ಆಗುತ್ತೆ. ಸಚ್ ಎ ಜೈಜಾಂಟಿಕ್ ಅನಿಮಲ್. ಆನೆ ಪದ ಹೇಗಿದೆ, ಪದ ಚಿಕ್ಕದಾದ್ರೂ ಆನೆಯ ಗಾತ್ರ, ಅದರ ಶಕ್ತಿ ಅಗಾಧ. ಅದರ ಕಾಲಿಗೆ ಕಟ್ಟಿ ಜನರನ್ನ ಪೂರ್ತಿ ನಗರದಾದ್ಯಂತ ಎಳ್ಕೊಂಡು ಹೋಗೋದಿದೆಯಲ್ಲ, ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಎಳೆ ಊಟೆ ಶಿಕ್ಷೆ. ಇಫ್ ಯು ಗೂಗಲ್ ಇಟ್ ಔಟ್, ಯು ವಿಲ್ ಗೆಟ್ ದಟ್ ಪಿಕ್ಚರ್ ಇನ್ ದ ಗೂಗಲ್ ಆಲ್ಸೋ, ವಾಟ್ ಈಸ್ ಎಳೆ ಊಟೆ ಶಿಕ್ಷೆ. Because we are living in such a most complex and sensitive society. Now my role is, as a guest speaker, to confine myself to the contemporary challenges. When I invite your attention to the contemporary challenges, it is my bounden duty to take you back to the historical findings, historical anecdotes also. I can tell you, after this incident, the most violent incident which took place in 12th century, then the entire Kalyana movement that has been smashed by the King Bijjala and his followers. Now let us come to the other issues. I said in the very opening remarks of my lecture that honor killing is a global phenomenon. My friends here, myself, and the most senior and the eminent lecturers here, speakers, we have all passed your generation. We are aware how your mind and heart and soul flows. See, for your age, love, friendship, affection is the most interesting aspect. Just go back to the COVID era, after 2019 and 2020. There was a news report in India that Saudi princess, the daughter of Saudi's king, had come to India. She had entered into India without any valid visa or permission. She was picked up from Indian authorities, handed down to the Saudi king. Now you remember, she too had fell in love with a person that was against the wish of the Saudi king. I can tell you, see, there are two things which I can tell you in contemporary challenges. We are a society where you can study the society both horizontally and vertically. One from the rural segment, another one from the urban segment. If you are studying a particular aspect called as honor killing from the rural segment, caste is the most glaring aspect which you can see, which will bifurcate the young couples.
or people who are fell in love, either it is a extramarital relationship or an intercaste marriage, the caste is the primary aspect in the rural segment. If it is in the urban segment, it will be class, rich, middle and poor. In urban societies, and most particularly in metropolitan city like Bangalore or Chennai, Delhi, Bombay, etc., the element of caste is undermined and the element of wealth comes to the consideration. When you take these issues for the purpose of empirical research or for non-empirical research, you will get plenty of illustrations. I can tell you with authority that United Nations Population Fund, it is a organization within the United Nations which releases the report periodically. And in the last 10 years, across the globe, it was accounted that 5,000 women have been killed across the globe for violating the norms of their family or their caste, creed or race. This is, I am referring to the global phenomena. Now when it comes to the Indian perspective, you have to look at the data released by the National Crime Records Bureau, NCRB. My friends here, most of you are law students. You are aware, every year the Home Ministry of the Union of India releases the data. How many murders have taken place? How many attempts have been made? How many negligent cases have been reported? How many dowry deaths have been reported across India? The data is collected from all the states. And when such data is released from the NCRB, it is only from 2014, please understand, it is only from 2014 the Home Ministry has started to release the data regarding the death in respect of the honor killing. Until then, there was no separate classification. Murder is a murder, killing is a killing. That's all. Whether it is for any other, see, please understand the motive for murder. Why? The prominent motive is honor. When you read the newspapers regarding the commission of any offense, particularly the murder, you will see the motive is extramarital relationship. ನೋಡಿದಿರಲ್ವಾ ಪತ್ರಿಕೆಗಳಲ್ಲಿ, ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ದಿ ಕ್ರೈಮ್ ನ್ಯೂಸ್, ನಗರದಲ್ಲಿ ಕೊಲೆ ಪ್ರಕರಣ, ಪತ್ನಿಯ ಶೀಲವನ್ನು ಶಂಕಿಸಿ ಹತ್ಯೆ ಮಾಡಲಾಗಿದೆ. ದಿಸ್ ಆಲ್ಸೋ ಆನರ್ ಕಿಲ್ಲಿಂಗ್. ಆನರ್ ಕಿಲ್ಲಿಂಗ್ ಅಂತ ಅಂದರೆ, ನೀವು ಆ ಗಣೇಶ್ದು ಸಿನಿಮಾ ಇದೆಯಲ್ಲ, ಯಾವುದದು ತಮಿಳ್ ಸಿನಿಮಾನ ರೀಮೇಕ್ ಮಾಡಿದ್ರಲ್ಲ, ಆ ಒಂದು ಗಣೇಶ್ದೊಂದು ಸಿನಿಮಾ ಇದೆ, ಚೆಲುವಿನ ಚಿತ್ತಾರ. ದಟ್ಸ್ ಎ ಕ್ಲಾಸಿಕ್ ಎಕ್ಸಾಂಪಲ್ ಫಾರ್ ಆನರ್ ಕಿಲ್ಲಿಂಗ್, ಮೈ ಫ್ರೆಂಡ್ಸ್. I must tell you, you are all students, you are fond of movie. In the silver screen you have seen. In fact, I had seen it in Tamil first, then later in Kannada also, Kannada version. That is the best example. Please listen to me for a moment. I can tell you much more interesting example also. See, when you read the newspaper, you will come to know there is a death, there is a murder. The murder is on account of extramarital relationship. See, there are some cases where wife is entering into conspiracy with her boyfriend, eliminating her husband. So this is called as motive. What is the motive? Motive is extramarital relationship. Now coming to the case of honor killing, what is the motive? Honor is the motive. What is the motive for murder? It is a murder for gain. When murder is committed in the course of commission of dacoity or robbery, then we call it as murder for gain. Soon after the commission of the murder, when the murderer takes away the wealth, then it is called as murder for gain. ಯಾವುದೋ ಒಂದು ಲಾಭಕ್ಕೆ, ಯಾವ ಲಾಭಕ್ಕೆ? ಆಸ್ತಿಯ ಉದ್ದೇಶದಿಂದ ಕೊಲೆ ಮಾಡಲಾಗಿದೆ, ಆಸ್ತಿಯ ವ್ಯಾಜ್ಯದಿಂದ ಕೊಲೆ ಮಾಡಲಾಗಿದೆ, ಅಥವಾ ದರೋಡೆ ಮಾಡಲು ಸಲುವಾಗಿ ದರೋಡೆ ಮಾಡುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಕೊಲೆ ಮಾಡಲಾಗಿದೆ. ಇದು ಮರ್ಡರ್ ಫಾರ್ ಗೇನ್, ಮೋಟಿವ್. See, because motive is the foundation for any crime. When you wish to determine any crime or offense, motive is the foundation. And And when it comes to the issue of the honor killing, what is that honor? Honor of our family. Sir ಹೇಳ್ತಾ ಇದ್ರು ತುಂಬ ಚೆನ್ನಾಗಿ. In our native North Karnataka slang, the son and sir was very, very fluently, taking some illustrations. ನಮ್ಮ ಮರ್ಯಾದೆ ಹೋಯ್ತು, ನಮ್ಮ ಕುಟುಂಬದ ಗೌರವ ಹೋಯ್ತು, ನಾವು ಬೇರೆ ಕಡೆ ತಲೆ ಎತ್ಕೊಂಡು ಓಡಾಡುವಂಗಿಲ್ಲ. My friends, please understand here, I don't spare anyone in my speech. I must tell you very frankly, an anthropological study states that everybody's mind always works in a negative way. That is the reason we try to train our mind by reading more number of shlokas, more vachanas, more Tirukkurul and more Bhagavad Gitas. We try to train give a particular shape. No, we should not do this because that's an offense, that's an immoral act, that is a sin. We want to streamline ourselves every day. Every day we offer prayer thrice. Some people offer prayer 5 times. It is a way of purification of our mind. Sir was saying that there are 3 things called as punitive, restorative, then other thing I immediately forget it. There are 3 things: restoration, preventive, then there is another aspect. So therefore, what we see from all these things is that honor killing. Why this is being taken place? Friend, this is not a new phenomenon. Although the topic which is chosen by me is contemporary. When you read it contemporary, from the contemporary perspective, you must go back to history and study how this is being taken place. There are so many pseudo concepts in our mind, in our society, that the pride of caste, the pride of community, the pride of our religion would come in the mind. There are so many other reasons also. I must tell you an example of Tamil Nadu case where there is a political party called as PMK, Pattali Makkal Kachi, PMK. I think if anybody is from Tamil Nadu, they will understand what exactly is PMK is there. There was a case reported from the North Tamil Nadu that a boy from scheduled caste community had fell in love with an upper caste girl in the college, where the student wing of that PMK, they gave a call to the upper caste students to boycott the college. This went on for about 2 years. The boy who comes from a scheduled caste was eliminated. The entire North Tamil Nadu has taken this issue in a political spectrum. It has taken the shape of political spectrum ultimately. Then ultimately the Human Rights Commission of the Tamil Nadu intervened the issue, tried to pacify the student wings also. To such an extent, the mind of students, the mind of younger generation have been polluted because of the interference of the policy makers, particularly the politicians and the legislators. To gain some votes, to gain the power, people can go to any extent, because please understand, and we are living in a democratic setup, and in the democracy, if anything is construed as an offense, that must be dealt within the 4 corners of the law. Now I can tell you by citing the reported judgments of the Supreme Court that the word honor killing is not defined. You cannot get a exact definition to the word or expression honor killing. Honor killing has been, in fact, the apex court in many cases, like in Shakti Vahini reported in 2018, volume 7, SCC 192, tried to give a definition to the honor killing, but however the Supreme Court said that no, it cannot be done so. Because the Indian society itself is a complex society. The culture, the practice of South Indians differs from North India and from East and West. It is such a complex society wherein we cannot give a definition. That's what the Supreme Court felt in many judgments. Even the parliamentarians, they did not think of formulating a definition for that. However, the Indian Law Commission has made an attempt, and it had also recommended to the Parliament to define what exactly is the honor killing. See, now we are in the process of formulating a definition to the honor killing also. Friends, because you understand very well what is murder, section 299 and 300 of the IPC, probably after 1 or 2 months we will have to forget IPC. Such a classic, I must tell you, as a practitioner of law, yes, BNS. If you say it as an INS, it will be a sedition. You must say it as BNS. That is how, and sir was saying, because his experience counts, it matters. ನೋಡಿ, ನಾನಿವಾಗ ಮಾತಾಡ್ತಾ ಇದ್ದೇನೆ, ಇದು ಮಾತು. This is an academic discussion. If the parliament thinks that my speech is illegal, they can frame a law. That is the power. That is the brutal power in democracy. Tomorrow they may call it as an offense. No, you should not stand and speak. You must sit like in Gurukula. ನೀವು ಪದ್ಮಾಸನ ಹಾಕೊಂಡೆ ಪಾಠ ಮಾಡಬೇಕು. ಹಿಂಗೆ ನಿಂತ್ಕೊಂಡು ಮಾಡಿದರೆ ಇಟ್ ಈಸ್ ಅನ್ ಅಫೆನ್ಸ್ ಅಂದ್ರೆ ನಾಳೆ ಅದು ಅಫೆನ್ಸ್ ಆಗುತ್ತೆ. That is how the legislative system works in any democratic system. ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ತುಂಬ ಚೆನ್ನಾಗಿ. ನಾನು ಅದನ್ನು ಯಾಕೆ ಹೇಳ್ದೆ ಅಂದ್ರೆ ಹಂಗೆ ಮಾಡಲ್ಲ, ಹಂಗೆ ಮಾಡೋಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಬಟ್ ಮಾಡೋದಕ್ಕೆ ಅಂಥದ್ದೊಂದು ತಾಕತ್ತನ್ನು ನಮ್ಮ ಶಾಸಕಾಂಗಕ್ಕೆ ಡೆಮೋಕ್ರಸಿನಲ್ಲಿ ನಾವು ಕೊಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೇವೆ. ಯಾವುದು ಅಫೆನ್ಸ್ ಅಂದರೆ ಏನು ಅಂತ ಡಿಫೈನ್ ಮಾಡೋ ಪವರನ್ನು ನಾವು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ನಾಳೆ ನಾವು ಏನು ಪಾಠ ಮಾಡಬೇಕು, ವಾಟ್ ಶುಡ್ ಬಿ ಟಾಟ್ ಇನ್ ದ ಲಾ ಸ್ಕೂಲ್ಸ್, ವಾಟ್ ಶುಡ್ ನಾಟ್ ಬಿ ಟಾಟ್, ಕೆನ್ ಆಲ್ಸೋ ಬಿ ರೆಗ್ಯುಲೇಟೆಡ್ ಬೈ ದಿ ಪಾರ್ಲಿಮೆಂಟ್. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್, ಆನರ್ ಕಿಲ್ಲಿಂಗ್ ಅನ್ನು ಡಿಫೈನ್ ಮಾಡುವಂಥ ಜವಾಬ್ದಾರಿ ಇಟ್ ಈಸ್ ನಾಟ್ ದ ಟಾಸ್ಕ್ ಆಫ್ ದ ಕೋರ್ಟ್, ಇಟ್ ಈಸ್ ದಿ ಟಾಸ್ಕ್ ಆಫ್ ದ ಪಾರ್ಲಿಮೆಂಟ್. ಇನ್ ಫ್ಯಾಕ್ಟ್, indeed, I must tell you very honestly, the parliament is not functioning as a parliament. The law is prepared, manufactured somewhere else, it is brought and submitted in the parliament. If the parliamentarians like Ambedkar, if they debate, then we will have a classic like another Indian Penal Code. Indian Penal Code is really a classic. If you read it and understand, it is a time-tested law. I must tell you, it is a time-tested law. So the continuity and consistency are the fundamental characters of any law. Please understand, these are the two important characters. Continuity and consistency are the hallmark of any judicial dispensation system. Assuming for a moment that today I am delivering a judgment on a particular aspect in a particular manner. Tomorrow, if I get an identical case, I must lay down the same law. If I differ tomorrow, then it will send a wrong signal to the democracy. Therefore, in any case, continuity and consistency, because why I am saying all these things, don't think that I am deviating from the original aspect. Because the word expression honor killing is not defined in the Indian Penal Code or in any other special laws. It is a word which is being coined by the Supreme Court in many cases. I must tell you the cases such as Lata Singh versus Union of India. That is one of the case where Supreme Court has dealt with the issue of the honor killing, and more particularly in Lata Singh's case, 2006 volume 5 SCC 475. If you see this judgment, Supreme Court has held that in unequivocal terms, there is nothing honorable in honor killings. Supreme Court in Lata Singh's case has held that there is nothing honorable in honor killings, and they are nothing but barbaric and brutal murders by bigoted persons with feudal minds. This is reported in 2006, volume 5, SCC 475. And in sometime in 2018, sometime in 2018, Justice Deepak Mishra, while heading a constitutional bench in the matter of Shakti Vahini versus Union of India, has held that the choice of a life partner is governed under Article 21. Please understand Article 21. The scope, the ambit of 21 is much, much wider than any other fundamental rights stated under Chapter 3 of the Indian Constitution. Justice Mishra in Shakti Vahini versus Union of India has held that the choice of a life partner is governed under Article 21. 19(1)(a), that is freedom of expression, expression of love and affection, that is an integral part of human development. It is inseparable. It is insegregable. You cannot separate it. And nobody could stop me from loving my wife or my ex-girlfriend. That is Article 19(1)(a) or Article 21. If there is a conflict, then honor killing will take place. If my wife objects or somebody who is related to my wife objects, then it will take the shape of honor killing. That is the simplest example which I can tell you. The choice is governed under Article 19(1)(a) and Article 21 of the Indian Constitution. So also, when you read Article 15 Class 1 and Class 2 also, you can try to correlate the scope of the freedom or the choice of an individual. Because you cannot read any article in isolation of Article 21. It is a kind of triangle or a triage, Article 19, Article 21 and Article 15. You cannot bifurcate all these things. For a comprehensive human development, as we grow, as we develop, love, marriage, family, procreation, individual autonomy are all regulated by the law. I can tell you an example. In Indian Penal Code, if you have already read Indian Penal Code, I think you have read the chapter on exception. Any act or omission which is regarded as an offense committed by a boy or girl of less than 7 years is not an offense. Haudalva? Between 7 to 12, there is a separate category. From again 12 to 16, now you please understand, you can ask me, why not 18? This is after 2019, after Nirbhaya case, and after amendments brought in view of J.S. Verma committee recommendation. Now there is yet another classification between 16 to 18 years. An exception class that has gone, if a boy who has attained the worldly knowledge and who is between the age of 16 to 18 years, he can be tried as an adult in the session court, not in the juvenile courts. See, law changes depending upon the situation. Law is not static. Please understand. Law annodu kanunu ninta neeralla. Because in the discussion, of course, I must tell you, I am a privy to the discussion which took place inside the chamber, wherein Justice Krishna Iyer, he was throwing light on the various aspects. Law is not static. Law is an instrument of social change. It is not the only instrument of social change. Law is only one such instrument. ಕಾನೂನು ಒಂದು ಸಾಧನ ಅಷ್ಟೇ. ಈ ಆನರ್ ಕಿಲ್ಲಿಂಗ್ ಅನ್ನ ಹೇಗೆ ನಾವು ಪ್ರಿವೆಂಟ್ ಮಾಡಬೇಕು? ಸರ್ ವಾಸ್ ಸೇಯಿಂಗ್ preventive measures, corrective measures, restorative measures. Yes, of course, these three. What are those preventive measures? It is we, by way of educating ourselves, by way of spreading the message of Article 19, Article 21 and Article 15 of the Indian Constitution. Friends, please go back to the Special Marriage Act. If you have read the Special Marriage Act, it says that any marriage between a girl who has attained the age of 18 years and a boy of 21 years from different religion is also governed, and their marriage is regarded as legal marriage. When the Special Marriage Act was enacted, that was much prior to the enactment and implementation of the Indian Constitution. That was the mind of the Britishers. That is why I say that Indian Penal Code is a time-tested. ಹಳೇದಾದಷ್ಟು ತುಂಬ ಚೆನ್ನಾಗಾಗುತ್ತೆ, ಯಾಕೆಂದರೆ ಮಾಗುತ್ತೆ, ಪಳಗುತ್ತೆ. ಈಗೆಲ್ಲ ನಿಮಗೇನೋ ಅನಿಸಿರುತ್ತೆ, ನಿಮ್ಮ ವಯಸ್ಸಿದ್ದಾಗ ನಮಗೂ ಅದು ಅನಿಸಿದೆ, ಸಾರ್ಗೂ ಕೂಡ ಅನಿಸಿರ್ಬೋದು, ಅನಿಸಿದೆ ಇಲ್ಲ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆದರೆ ಹೋಗ್ತಾ ಹೋಗ್ತಾ ಅವ್ರು ಪಾನಿಪುರಿ ಕಥೆ ಹೇಳಿದ್ರಲ್ಲ, ಅಲ್ಲಿಗೆ ಬಂದ್ಬಿಡ್ತೀವಿ ನಾವು. ಮೊದಲಿಗೆ ಏನಾಗುತ್ತೆ, ಆ ಉತ್ಸಾಹ, ಆಂಗ್ಸೈಟಿ, ಟು ಹ್ಯಾವ್ ಸಮಥಿಂಗ್, ಟು ಕ್ಯಾಚ್ ಸಮಥಿಂಗ್, ಟು ಫಾಲ್ ಇನ್ ಲವ್ ಸಮಥಿಂಗ್ ವಿತ್ ಸಮಥಿಂಗ್, ಏನೋ ಮಾಡಬೇಕು. Then over a period of time, when we mature ourselves, when we train our mind and heart, then naturally we will get into the normalcy. ಹಾಗೆ ಲಾನು ಕೂಡ ಅದು ಪಳುಕ್ತಾ ಸಾಣೆ ಹಿಡಿತಾ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ತಾ ಇರಬೇಕು, ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮೇಲೆ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಗ್ತಾ ಇರಬೇಕು. ಆಗ ಲಾಗೆ ಒಂದು ಒಳ್ಳೆಯ ಅದ್ಭುತವಾದಂಥ ಹೊಳಪು ಬರುತ್ತದೆ. ಮನೆಯಲ್ಲಿ ಪಾತ್ರೆ ತಿಕ್ಕಿ ಅಮ್ಮ ಅಂಡೆ ಹೆಂಗೆ ಪಳ ಒಳೆಯಂಗೆ ಮಾಡ್ತಾರೆ ಅಪ್ಪನ ತಲೆ ಥರ, ಹಾಗೆ ಕಾನೂನು ಕೂಡ. ಅದಕ್ಕೆ ಕಾನೂನನ್ನು ಮಾಡಿಬಿಟ್ಟು ಕಪಾಟಲ್ಲಿ ಹಾಕಿಟ್ಬಿಡೋದಲ್ಲ, ಕಾನೂನನ್ನು ಬಳಸ್ತಾ ಇರಬೇಕು. ಅಂದರೆ ಕಾನೂನು ವೈಲೇಟ್ ಮಾಡಬೇಕು ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಕಾನೂನು ಬಳಸೋದು ಅಂತಂದರೆ ಯು ಪೀಪಲ್ ಮಸ್ಟ್ ಡಿಬೇಟ್, ಯು ಪೀಪಲ್ ಮಸ್ಟ್ ಇಂಟ್ರಾಕ್ಟ್, ಯು ಮಸ್ಟ್ ಥ್ರೋ ದ ಚಾಲೆಂಜಸ್ ಟು ಯುವರ್ ಲೆಕ್ಚರರ್ಸ್, ಯು ಮಸ್ಟ್ ಥ್ರೋ ಯುವರ್ ಚಾಲೆಂಜಸ್ ಟು ದ ಸ್ಪೀಕರ್ಸ್ ಆ್ಯಂಡ್ ಟು ದ ಜಡ್ಜಸ್ ಬೈ ಬಿಕಮಿಂಗ್ ಗುಡ್ ಅಡ್ವೊಕೇಟ್ಸ್. And in the society, you will come across these kind of cases. Don't think that honor killing, it is only a case of murder. It will take away the very social fabric of Indian society in the name of caste, family, creed, race, ethnicity, etc. ನೀವು ನೋಡಿ, ನಮ್ಮಲ್ಲಿ ಬಿಟ್ಬಿಡಿ, ನಾವು ಕನ್ನಡಿಗರು, ನಮಗೊಂದೇ ಎಥ್ನಿಸಿಟಿ ಇರೋದು. ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ನಾವು ಬೆಂಗಳೂರಲ್ಲಿದ್ದಾಗ ಮುದ್ದೆ ತಿಂತೀವಿ, ದಾವಣಗೆರೆಗೆ ಹೋದರೆ ರೊಟ್ಟಿ ತಿಂತೀವಿ. ನಾವು ಕನ್ನಡಿಗರು, ನಮ್ದು ಒಂದೇ ಎಥ್ನಿಸಿಟಿ. ವಿ ಮೇ ಡಿಫರ್ ಇನ್ ಅವರ್ ಫುಡ್ ಹ್ಯಾಬಿಟ್ಸ್, ಬಟ್ ವಿ ಹ್ಯಾವ್ ಒನ್ ಎಥ್ನಿಸಿಟಿ. ಬಟ್ ವೆನ್ ಯು ಟೇಕ್ ದ ಎಕ್ಸಾಂಪಲ್ ಆಫ್ ನಾರ್ತ್ ಈಸ್ಟ್, ಮಣಿಪುರ್, ನಾಗಾಲ್ಯಾಂಡ್, ಅರುಣಾಚಲ ಪ್ರದೇಶ್, ಅಸ್ಸಾಂ, ಮೇಘಾಲಯ ಅಂಡ್ other states which are called as Seven Sisters, there are more than 200 different ethnic groups. ಒಂದು ಎಥ್ನಿಕ್ ಗ್ರೂಪ್ನವರು ಇನ್ನೊಂದು ಎಥ್ನಿಕ್ ಗ್ರೂಪ್ ಹುಡುಗಿ ಜೊತೆ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ, ನೀವೆಲ್ಲ ಇತಿಹಾಸದಲ್ಲಿ ಓದಿದ್ದೀರಾ, ರಾಜ ಯುದ್ಧಕ್ಕೆ ಹೋದಾಗ, ಇನ್ನೊಂದು ರಾಜ್ಯವನ್ನು ಗೆದ್ದಾಗ ಅಲ್ಲಿರೋ ಯುವರಾಣಿಯನ್ನು ಆರಿಸ್ಕೊಂಡು ಕುದುರೆ ಮೇಲೆ ಕರ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದ. ಬೇರೆ ಬೇರೆ ಎಥ್ನಿಕ್ ಗ್ರೂಪ್ಗಳು, ಬೇರೆ ಬೇರೆಯ ಒಂದು ಕಲ್ಚರು, ರಿಚುವಲ್ಸ್ ಇರುವಂಥವ್ರು. ವಯೋಲೆಂಟ್ ಇನ್ಸಿಡೆಂಟ್ಸ್ ಟೇಕ್ ಪ್ಲೇಸ್ ನಾರ್ಮಲಿ ಇನ್ ದ ನಾರ್ತ್ ಈಸ್ಟರ್ನ್ ಸ್ಟೇಟ್ ಬಿಕಾಸ್ ಆಫ್ ದೀಸ್ ಕೈಂಡ್ ಆಫ್ ಕೇಸಸ್. ನಮ್ಮಲ್ಲೂ ಇದೆ. ನಮ್ಮಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಅಂತರ್ಜಾತಿ ವಿವಾಹ. ಸಿ, ಆಸ್ ವಿ ಗ್ರೋ, as we develop, we are becoming more and more sensitive and more and more started to love our caste and religion, and in the process of loving our caste and community, we have started to hate the other communities. This is a kind of reverse. ನಾವು ಒಂದು ವಸ್ತುನ ಜಾಸ್ತಿ ಇಷ್ಟಪಡೋಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ ಮೇಲೆ ಮಿಕ್ಕಿದ್ದೆಲ್ಲದ್ರ ಬಗ್ಗೆ ನಮಗೆ ಆಟೋಮೆಟಿಕ್ಕಾಗಿ ದ್ವೇಷವನ್ನು ಬೆಳೆಸ್ಕೊಳ್ತಾ ಇದ್ದೇವೆ. ಸೊ ದಿಸ್ ಈಸ್ ಎ ಕೌಂಟರ್ ಪ್ರೊಡಕ್ಟಿವ್ ಫ್ಯಾಕ್ಟರ್. ಹಾಗಾಗಿ ವಾಟ್ ಐ ಮಸ್ಟ್ ಟೆಲ್ ಯು ಈಸ್ ದ್ಯಾಟ್ the present law for any offenses which is regarded as honor related violence or honor killing is dealt only under the Indian Penal Code. Please correct me, sir, if I am wrong, if there is any other special legislation to deal with the honor killing. Any cases which are considered as honor related violence or honor killing is dealt only under the Indian Penal Code, that too under section 302 of the Indian Penal Code. But Supreme Court has made an attempt in many cases. I must tell you, in Shakti Vahini's case, you must read the judgment from your library. It is one of the best judgment which is, authored by Justice Deepak Mishra. You must remember 2 years ago, there was a case from Kerala, Hadia case, habeas corpus. Hadia comes from Hindu community, and media report claims that she fell in love with a person from another community. Hadia's father objected for this. He filed a petition in the High Court of Kerala. High Court of Kerala dismissed that habeas corpus petition. Matter went in appeal to the Supreme Court under Article 32. Supreme Court laid down the law that it is the choice of an individual who has attained the age of 18 years and 21 years in the case of girl and boy respectively to choose their life partners. The habeas corpus petition filed by her father got dismissed. So these are all the instances which I can tell you readily, because of course ultimately law is only an instrument. See, there was a discussion to what extent law can survive also. As long as the society respect the law, until then it can survive. Otherwise, it will crumble like Syria or like any other Middle East countries which we are seeing today. Utter lawlessness you can notice. Total lawlessness. India is such a country where we are blessed by our forefathers. And our forefathers like Gandhi, Ambedkar, Nehru, and many others, they devoted their time, they spent their valuable time in grooming this nation as to how we should proceed in this particular direction. Of course, some of the laws are all colonial. That doesn't mean that we have to throw it away and take back everything new. You must learn, you must study, understand whatever good is available, you have to take it. Now, for a moment, in the case of honor killing, I must tell you, law schools are the best places to teach, to train, to guide the public. When you go to villages as a part of your legal aid camps, you must create awareness. That is the best thing which you can do from your side to train the villagers as to what exactly is the law. And many people are not aware. So they are still guided by their pseudo idea that honor is the utmost important and the prime object of their life. And what is honor for you may not be honor for me. And what is respectful for you may not be respectful for me, because the sir was saying in the law courts, why a accused is, acquitted. He was quoting the example of evidence. I must tell you, my friends, in the Supreme Court, in the very entrance of the Supreme Court, there is a caption, Satyameva Jayate. What is that Satya? Can anybody tell me what exactly is Satya? Truth. Truth alone triumphs. Ellideva. Where do you find the truth? Where do you find the truth? Of course, I must tell you as a practitioner, in any law courts in India, the law courts determine the case based on the evidence, not on the truth. How do you derive the truth? From the logical conclusions. From the logical conclusions, you will determine what exactly is the offense, what not is an offense. Sir was saying that innocence, the presumption of innocence. Because of course I must tell you, tomorrow if I am arraigned as an accused in any case, the entire might of the state is on me. Entire state, entire machinery is on me. How to defend against the mighty person. To create a level playing field. ಒಂದು ಆಟ ಆಡಬೇಕು ಅಂದರೆ ನಾನು ಕ್ರಿಕೆಟ್ ಆಡ್ತೀನಿ, ವಿರಾಟ್ ಕೊಹ್ಲಿನೂ ಕ್ರಿಕೆಟ್ ಆಡ್ತಾರೆ, ಹೌದಲ್ಲ? ವಿರಾಟ್ ಕೊಹ್ಲಿಗೂ ನನಗೂ ಮ್ಯಾಚ್ ಇಟ್ಟರೆ ಯಾರು ಗೆಲ್ತಾರೆ? ಅದಕ್ಕೆ ಒಂದು ಲೆವೆಲ್ ಪ್ಲೇಯಿಂಗ್ ಫೀಲ್ಡ್ ಮಾಡಬೇಕಲ್ಲ. ನಾನು 10 ಸರಿ ಔಟ್ ಆದರೂ ಒಂದೇ ಸರಿ ಔಟು, ಕೊಹ್ಲಿ 1 ಸರಿ ಔಟ್ ಆದರೆ ಔಟು. ಇಂಥದ್ದೊಂದು ಲೆವೆಲ್ ಪ್ಲೇಯಿಂಗ್ ಫೀಲ್ಡನ್ನು ಪ್ರಿಸುಂಪ್ಷನ್ ಆಫ್ ಇನ್ನೋಸೆನ್ಸ್ನಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಬರ್ತಾರೆ. ಯಾಕೆಂದರೆ ಅವರ ಶಕ್ತಿ, ಅವರ ಸರ್ಕಾರದ ಶಕ್ತಿ ಇದೆಯಲ್ಲ, ಅವರ ಮೆಷಿನರಿ ವಿರುದ್ಧ ಒಬ್ಬ ನಿರಪರಾಧಿ ಹೇಗೆ ಸೆಣಸಾಡ್ತಾನೆ. ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ದ ಬರ್ಡನ್ ಆಫ್ ದ ಸ್ಟೇಟ್, ಇಟ್ ಈಸ್ ದ ಬರ್ಡನ್ ಆಫ್ ದ ಗವರ್ಮೆಂಟ್ ಟು ಡಿಟರ್ಮೈನ್ ದ ಗಿಲ್ಟ್. ಇಟ್ ಈಸ್ ನಾಟ್ ದ ರಿವರ್ಸ್ ಫ್ರಮ್ ದಿ ಸೈಡ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್. ನಮ್ಮಲ್ಲಿ ಏನು ರಿಸೋರ್ಸ್ ಇರೋದಿಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ವೆನ್ ಯು ಟ್ರೈ ಟು ಕೋರಿಲೇಟ್ ಆಲ್ ದೀಸ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ and more particularly in the case of the honor killing, the social factors, the local political factors and the local religious factors play a pivotal role. Therefore, I must tell you very candidly that this is a place where you can learn more on the aspect of the honor killing. And the main causes of the honor killing are the mentality of the people, firstly. The secondly, the rigid caste system. And thirdly, the issues pertaining to interreligious marriages. And fourthly, lack of adequate specialized laws. Fifthly, illiteracy and awareness among the various groups. And the sixth important concern is premarital sexual relationships and extramarital relationships and marrying within the same gotra sometime. So you can see these kind of cases are also emerging, and a brother marrying the sister, and in the case of chikkappa doddappa makkalu maduve madಕೊಳ್ಳುವಂಥದ್ದು, because they come from the same gotra, where also to prevent the honor of the family they are eliminated in our nation. And most importantly, and we have scant regard for the governance. And lastly, I must tell you, the inefficient law enforcement agency, in fact that should have become the first cause here. The weakness of the law enforcement agency is one of the primary concern, which is the chief cause, because the entire system, whatsoever may be the power of the law, if the enforcement agency is weak, if the enforcement agency is not up to the mark, then ultimately all powerful laws would fail one fine day. And therefore, the honesty and integrity of the people who are at the helm of affairs is the primary concern. And therefore, I must tell you, the conjoint reading of Article 14, equality, Article 15, 1 and 3 also, prohibition of discrimination on the ground of sex, creed, religion, and Article 17, untouchability, Article 19, 1A, that is freedom of expression, not only speech. Expressing one's love towards another, that's also form of, a kind of human development. Article 21, so this umbrella of rights provided under the Indian Constitution, if read conjointly with the Special Marriage Act or even with the Hindu Marriage Act, gives us an idea as to what exactly is the institution of marriage, what exactly is the institution of family, what exactly is the institution of society. If you understand these three basic aspects, the institution of marriage, institution of family and society, you will fully understand the scope and the seriousness of the honor killing. Then ultimately, I must tell you, the initiatives which are supposed to be taken from the side of the government and non-governmental organizations. The first and foremost is educate, create awareness and implement the law. These are the only things which I can tell you from my side. I must thank everyone here, and more particularly Professor Sudha Madam, for inviting me to address the August gathering here. And I extend my profound thanks to the eminent speakers who are here and with whom I shared the dais, and I'm very grateful to everyone. Good luck. Satyameva Jayate. Thank you.
ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅವ್ರದ್ದು, ಸ್ವಾಮಿ ಅವ್ರದ್ದು, ಟೆಕ್ನಿಕಲ್ ಸೆಷನ್
ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿಕೊಂಡಿರುವಂಥ ಶ್ರೀ ದ್ವಾರಕನಾಥ್ ಬಾಬು ಸಾಹೇಬ್ರೆ, ಹಾಗೂ ನನ್ನೊಂದಿಗೆ ಸಂಪನ್ಮೂಲ ವ್ಯಕ್ತಿಯಾಗಿರುವಂಥ ಶ್ರೀ KBK ಸ್ವಾಮಿ ವಕೀಲ್ ಅವರೇ, ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾಂಶುಪಾಲರು ಮತ್ತು ಇನ್ನಿತರ ಎಲ್ಲ ಸಿಬ್ಬಂದಿ, ಉಪನ್ಯಾಸಕೇತರ ವರ್ಗದ ಸಿಬ್ಬಂದಿಯವರೇ, ನೆರೆದಿರುವ ಎಲ್ಲ ಬಂಧುಗಳೇ, see, honor killing, the Honorable Justice traced that it was there long ago during the ancient period also. It is changing forms and now it has become very popular under the name honor killing. We are living through a very, very complex time. This is a world of paradoxes. On one side, we have swung the pendulum to the opposite direction of the individual autonomy. And especially people of your age, you are trained to assert yourself. I am the most important person. This is my body. This is my life. And I am totally in charge of my life and my body. Nobody else should have any authority or ability to control what I do, what I eat, what I say. Constitutionally recognized over a period of time through a series of cases culminating in Puttaswamy's judgment. Right to choose, freedom of choice. It has become a fundamental right. On the other hand, there are elders in the system, parents in the system. They say, look my child, the decisions you are taking are not good for you. I have lived 65 years. I have lived 50 years. I have the experience. You are taking a wrong decision, you definitely. As your father, I cannot permit you to take this step which is disastrous and dangerous for you. I have the experience. This is paternalism. I am your father and I am interested in your well-being. Okay? John Stuart Mill somewhere writes, those people who torment you in the name of your own good can torment to the unlimited extent. In the name of your good, ಮಗಳನ್ನ ಕರ್ಕೊಂಡು ಪೇಟೆಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿನಿ. ಮಗಳು ಕೇಳ್ತಾಳೆ, ಅಪ್ಪ ಚಾಕ್ಲೇಟ್ ಕೊಡಿಸು. ಅಮ್ಮ ಚಾಕ್ಲೇಟ್, ಸಿ ಯು ಹ್ಯಾವ್ ದಿ ಮಿಲ್ಕ್ ಸೆಟ್, ನೆಕ್ಸ್ಟ್ ದೇರ್ ವಿಲ್ ಬಿ ಪರ್ಮನೆಂಟ್ ಸೆಟ್. ಇಫ್ ಯು ಸ್ಟಾರ್ಟ್ ಈಟಿಂಗ್ ಚಾಕ್ಲೇಟ್ ನಾವು 2-3 kg, ನೋ ಫಾರ್ ಯುವರ್ ಗುಡ್ ಯು ಶುಡ್ ನಾಟ್ ಈಟ್ ಚಾಕ್ಲೇಟ್. ಓಕೆ, ಮತ್ತೆ ಮುಂದೆ ಹೋದ್ವಿ. ಅಲ್ಲಿ ಐಸ್ ಕ್ರೀಮ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ. ಅಪ್ಪ ಐಸ್ ಕ್ರೀಮ್ ಕೊಡಿಸು. ಬೆಂಗಳೂರು, ಡಿಸೆಂಬರ್, ಜನವರಿ, ನೋ 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 ಸರ್ದಿ ಆಗಿಬಿಡ್ತದೆ, ನೆಗಡಿ ಆಗ್ತದಮ್ಮ, ಐಸ್ ಕ್ರೀಮ್ ತಿನ್ನಬಾರ್ದು, ಈ ಸೀಸನಲ್ಲಿ ತಿನ್ನಬಾರ್ದು, ಸಮ್ಮರಲ್ಲಿ ತಿನ್ನಬೇಕು. ಇನ್ನೂ ಸ್ವಲ್ಪ ಮುಂದೆ ಪಾನಿಪುರಿ, ಇಲ್ಲಿ ಅನ್ನ ಹಸಿನೇ ನೋಡು, ಅವನ್ನೆಲ್ಲ ಬೆರಳೆಲ್ಲ ಹಾಕಿ ಪಾನಿಪುರಿ ಇದೆಲ್ಲ ಅದು ತಿನ್ನಬಾರ್ದು. ಇನ್ನೂ ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋದ್ಮೇಲೆ, ಮೈ ಡಿಯರ್ ಚೈಲ್ಡ್, ಯು ವಾಂಟ್ ಸಮಥಿಂಗ್? ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್. Such a wonderful papa. She knows that this fellow has reason for everything in the name of her good. This is the catch point. In the name of her good, I take decisions without understanding whether it is for her good or not, whether she likes it or not. Totally divorced. She is totally divorced from the decision-making process. That's why these people have started asserting freedom of choice. I decide now. And during childhood, it is all right. Paternalism works. But somewhere we have another expression, state paternalism. State says it stands in the position of the parents to the citizens. And it decides what is good for you, what is not good for you. That is one of the reasons because of which attempt to commit suicide was denounced by the law. It says, I cannot permit you to do that. See, these are the conflicting dimensions that we have when we come to these points of freedom of choice. Marriage is a choice. Living relation is a choice. And another expression 3 years back which I learned, open relationship is a choice. And we are living here to expect many more types and dimensions of these developing types of relationships. I am in charge, I decide. I have decided to live in. I have decided to do this. I have decided to marry this. So who are you to interfere? So now a line is to be drawn. Societal interest is one thing. Morality and the minimum content of morality. Any law should have minimum content of morality. That is the jurisprudential requirement. In the name of freedom of choice, we cannot throw the pendulum to other direction, because whatever that goes to the other direction will come back sometimes. Okay, so what are the limits? What is to be done? How we are going to? See, whenever new crimes come into existence, the type of things which the system was not knowing, law has to change to keep pace with the society. When it comes to the point of criminal, and now we are speaking in terms of criminalizing an activity which goes against the freedom of choice in the name of honor killings. So if you are to criminalize, there should be a policy decision taken. In that Kenya's outlines of criminal law, in the first chapter, at the beginning there is a sentence: crimes originate in the policy of the government of the moment. Crimes originate in the policy. It is the prerogative of the state to criminalize certain of the activities and also to decriminalize. The foreign exchange is decriminalized. Now it is no more an offense. The Foreign Exchange Management Act came, decriminalizing all other. So these things keep on happening. Society which tolerated something once may denounce in the next period of time. So we have to criminalize certain of the activities if these activities are to be prevented. For that reason, we have to think of what type of law we should have to tackle this. There is a very, very age-old popular saying: subtle laws are seldom obeyed, stringent laws are seldom enforced. ಸೂಕ್ಷ್ಮವಾಗಿರೋ ಕಾನೂನು, smoking in public place is prohibited. What is a public place is defined. But you will see people smoking around. ಏನಾಗ್ತದ ಅವನು ಬಂದು ಹಿಡ್ಕೊಂಡ್ರೆ ಏನಾಗ್ತದ ಅವನು ಯಾರು ಬರ್ತಾನಲ್ಲ, 100 ರೂಪಾಯೋ 200 ರೂಪಾಯಿ ಇಸ್ಕೊಂತಾನೆ. ನಾನು ಒಂದೊಂದು ಸಲಕ್ಕೆ 20 ರೂಪಾಯಿ ಸಿಗರೇಟೇ ಸೇರಿ ಬಿಸಾಕ್ತೀನಿ, ಅವನಿಗೆ 20 ತಗೊಂಡೋಗೋದು ಸಿಕ್ಕರೆ, ಇಲ್ಲಾಂದ್ರೆ ಅವನಿಗೊಂದು ಸಿಗರೇಟ್ ಕೊಟ್ಬಿಡೋದು. ಇದನ್ನ ಅಷ್ಟು ಗೌರವದಿಂದ ಕಾಣ್ತಾ ಇಲ್ಲ. ಆದರೆ ಸಾಮಾಜಿಕ ಜವಾಬ್ದಾರಿಯನ್ನು ಅರ್ಥಕೊಂಡು ಇಂಥದ್ದೊಂದು ಕಾಯ್ದೆ ಇದೆ, ನಾನು ಪ್ರೊಫೆಸರ್ ಇದ್ದೀನಿ, ಸೂಟ್ ಬೂಟ್ ಹಾಕೊಂಡಿನಿ, ಹಿಂಗೆ ಪಬ್ಲಿಕ್ನಾಗ ನಿಂತ್ಕೊಂಡು ಸಿಗರೇಟ್ ಸೇರಬಾರ್ದು ಅನ್ನೋ ಒಂದು ಭಯಕ್ಕೆ ಅವನೆಲ್ಲೋ ಹೋಗ್ತಾನೆ. ಸೊ ದೇರ್ ಆರ್ ಡಿಫರೆಂಟ್ ಎಲಿಮೆಂಟ್ಸ್ ಇನ್ ವರ್ಲ್ಡ್. ಅಲ್ಲಿ ಒಬ್ಬರು ಜಡ್ಜ್ ಸಾಹೇಬರು ಈ NDPS ಕಾಯ್ದೆ, ಇಲಿಸಿಟ್ ಟ್ರಾಫಿಕ್ ಇನ್ NDPS ಆ್ಯಕ್ಟ್, ಅದರಲ್ಲಿ ಮಿನಿಮಮ್ ಪನಿಷ್ಮೆಂಟ್ ಇದೆ, ಕಡ್ಡಾಯ. If a person is found guilty, sentence is compulsory. And the judge, see, an youngster of 17-18 years is produced for possessing drugs. How the judge will think, look, this boy is a student and is at this age. The whole life is there. If I convict him, he has to go to prison. Because there is no alternative. Having convicted, you have to send him to prison only, because minimum punishment is there. And if he comes out of prison, what will happen to his life? What will happen to the expectations of his parents? Then as a judge, what alternative I have? Acquit him. Find some loophole, give benefit of doubt, acquit him. I know he has committed that offense, but if I convict him, I have to send him to jail Because I do not want to send him to jail, the alternative open to me is acquittal only, nothing else. Whether by imposing that minimum punishment, minimum mandatory punishment, whether the law serves anything is a question to be asked. It is very simple. We teachers, when we sit to prepare your syllabus, we speak of standards. Hey, ಈ ಪುಸ್ತಕ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡು, ಅದು ಹಾಕು, ಈ ಡಾಕ್ಟ್ರಿನ್ ಹಾಕು, ಈ ಯೂನಿಟಲ್ಲಿ ಇದಾಕು, ಆ ಯೂನಿಟಲ್ಲಿ ಅದಾಕು. 5 ಯೂನಿಟ್ ಪ್ಯಾಕ್ ಮಾಡಿ 5 ಟ್ರಕ್ ನಿಂದಿರಿಸಿ ಸಿಲೆಬಸ್ ಕವರ್ ಮಾಡುವಾಗ ಟರ್ಮ್ ಮುಗಿಯಕ್ಕೆ ಬಂದಿರ್ತದೆ. ಇನ್ನು 2.5 ಯೂನಿಟ್ನಾಗ ಹೊಂಟಿರ್ತಾನೆ, ಒಬ್ಬೊಬ್ಬರಿಂದ 1ನೇ ಯೂನಿಟ್ನಾಗ ಹೊಂಟಿರ್ತಾರೆ ಅವರು. ಲಾಸ್ಟಿಗೆ ಅದು ಸಿಲೆಬಸ್ ಎಲ್ಲ ಒಂದು ಟೇಬಲ್ ಇಟ್ಟು ಒಂದು ಗೋಣಿ ಚೀಲ ಹಾಕಿ ಸಿಲೆಬಸ್ ಕವರ್ ಅಂದ್ಬಿಡೋದು. ಅಂತ ಸಿಲೆಬಸ್ ಯಾಕೆ ಮಾಡಕ್ಕೆ ಹೋಗೋದು? So don't make laws which cannot be enforced. In the anxiety of providing for stringent laws, that's why certain laws are seldom respected, stringent laws are seldom obeyed. And when you criminalize, how the law should be, there is a doctrine, nellum crimen sine lege. Nellum crimen sine lege means you cannot convict a person without a clear and a definite basis. You cannot convict a person without a clear and a definite basis. For that purpose, whenever we decide what is honor crime, what are the activities associated with the honor crimes, etc., we should be very, very clearly defining these activities. Otherwise, we will run into problem, because clear and definite basis is necessary, especially when we speak in terms of presumptions. Okay? When I am going to presume, shift the burden of proof. This is the trend. Wherever the activity is to be suppressed with an accurate iron fist, Chinese proverb is there. One stringent law enforced with unerring accuracy is worth all the words of all the sages. ಒಂದು ಕ್ರಿಮಿನಲ್ ಲಾ, ಸರಿಯಾದ ಒಂದು ಕ್ರಿಮಿನಲ್ ಲಾ ಪ್ರಾವಿಷನ್ ಎನ್ಫೋರ್ಸ್ ಮಾಡಿದರೆ ನೀವು ಉಪದೇಶವೇ ಬೇಡ. ಎವ್ರಿ ಒನ್ ಈಸ್ ಎ ಜೆಂಟಲ್ಮನ್ ಇನ್ ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಪೊಲೀಸ್ಮನ್. That is the equation. So if you have such a big stick policy, people will behave. That is the equation. But in the anxiety of doing that, if we overdo things, we may run into problems. When you say it will be breathed, this is a very simple thing. See, now technology has developed and all this communication is there. In everything there is a thing like this. Yeah, this one. Ganapati, okay, Anjaneya, for everything. Sometimes, ನನ್ನ ಕಾಲೇಜಲ್ಲಿ ಒಂದು ಸಮಸ್ಯೆ ಹಿಂಗೆ ಆಗಿತ್ತು. ಒಂದು ಹುಡುಗಿ ಬಂದ್ಬಿಟ್ಟು ಒಂದು ಕಂಪ್ಲೇಂಟ್. ಏನದು ಕಂಪ್ಲೇಂಟು? ಸರ್, ಇವ್ ಹುಡುಗ ಈ ಮೆಸೇಜ್ ಕಳ್ಸ ನೋಡ್ರಿ, ಅದು ಇಮೋಜಿ. ಈ ಪೆಕ್ ಇಮೋಜಿ ಕಳಿಸ್ಬಿಟ್ಟನು. ಕಿಸ್ ಕೊಡೋದು ಹಿಂಗಿರ್ತದೆ. ನಾನು ಸ್ಟ್ರಿಕ್ಟ್ ಪ್ರಿನ್ಸಿಪಾಲ್. ಅವನಿಗೆ ಬರಲಿ ಇಲ್ಲಿ ಅಂತ. ನನ್ನ ಮಗ ನನ್ನ ಕಾಲೇಜಿನಾಗ ಹುಡುಗಿ ಈ ಇಮೇಜ್ ಕಳಿಸಿದ್ದೀನಿ, ಎಷ್ಟು ಧೈರ್ಯ ನಿನಗೆ? ಅದು ಸರ್ ಸ್ವಲ್ಪ ಕೇಳ್ರಿ ಸರ್, ನಾನು ಹೇಳೋದು ಕೇಳ್ರಿ ಸರ್. ಸರ್, ಇದು ಹೊಸದು ಮೊಬೈಲ್ ತಗೊಂಡಿದ್ದು ಸರ್, ಬಸ್ನಾಗ ಬರ್ತಾಯಿದ್ದೆ, ಹಿಂಗೆ ಮಾಡೋಗಿ ಹಿಂಗೆ ಆಯ್ತು ಸರ್, ಹೋಗ್ಬಿಟ್ಟು ಸರ್. ನನಗೆ ಅಲ್ಲಿ ಎಷ್ಟು ಧೈರ್ಯ ಬರ್ತದೆ ಸರ್, ಅದು ನಿಮ್ಮ ಕಾಲೇಜ್ನಾಗ ನಿಮ್ಮಂಥ ದುಷ್ಟಿದ್ದಲ್ಲಿ. ಸರಿ, ಐ ಫೆಲ್ಟ್ ಹಿ ವಾಸ್ ವೆರಿ ಆನೆಸ್ಟ್. ಹುಡುಗಿನ ಕರೆದೆ, ಬಾರಮ್ಮ ಇಲ್ಲಿ ಅಂತ. ಅವನು ಅದನ್ನು ಕಳ್ಸೇನಿಲ್ಲ. ಹೌದು ಸರ್, ವಾಪಸ್ ಕಳಿಸ್ಬಿಡ. ಹಂಗೆ ವಾಪಸ್ ಕಳಿಸ್ಬೋದಾ? ದಟ್ ವಿಲ್ ಬಿಕಮ್ ಡಿಸಾಸ್ಟ್ರಸ್. Okay, see, these are the things. Mobiles are alive and recording. Mobiles are tracking our movements. and lot many types of WhatsApp things. Other day some lady was telling me, sir, even deleted messages also you can read, there is an app. And I said, I do not want to read messages. Forget the deleted messages. That will create more problems. No? See, in this world, when we think of crimes, we have to think totally different. What we do in the anxiety of providing a stern criminal law, we provide for presumptions. We provide for presumptions. We speak in terms of strict liability. No need to prove mens rea. Without proof of mens rea, if XYZ facts are proved, it will be presumed that this is a honor killing. It will be presumed that this fellow is an abettor or is involved in incitement, etc. Strict liability, absolute liability. We speak in terms of shifting the burden of proof to the accused. See, in the traditional criminal law, the procedural fairness as per the due process requirements are such that everyone is presumed to be innocent till proved guilty. This is the basic principle of criminal. But when we try to tackle these new crimes, we go to the opposite principle, that the accused shall be presumed to be guilty unless he proves to be innocent. See, 90% of the crimes, criminals escape because of the inability of the prosecution to discharge the burden of proof. Burden of proof is very difficult to discharge. That's why we need criminal lawyers. But now, because your prosecution cannot prove, you shift the burden to the accused. And that fellow will be wrongly caught, especially if there is a false complaint. Very disastrous. Presumptions are very, very dangerous. They are not in tune with the requirement of due process. Presumptions will be, say, unfortunate fellow will go behind the bars, and deterrent punishment. Minimum 3 years punishment, minimum 7 years punishment. See, it is a very, very simple thing, which will have more disastrous effect. Our old criminal law let 1,000 people escape, not even a single innocent should be convicted. This is the old criminal. Reverse it. Can we take a chance of convicting an innocent in the anxiety of not allowing anybody to escape the clutches of law? Now we are trying such laws. Benjamin Franklin, those people who are ready to sacrifice little liberty for little security will neither have liberty nor security. That's what he says. Okay, take a chance. Let some innocent also go behind the bars. All these terrorism laws, unlawful activities laws, PMLA laws, all these things, there is an element of risk. Sometimes innocent also will go behind the bars. After 12, 13, 14 years, oh, you are innocent, you are released, you can go. So what he has spent, liberty is gone. So when we speak of new criminal jurisprudence, of shifting the burden of proof, making the offences cognizable, non-bailable, prescribing mandatory minimum punishment, and all these things, we should be very, very careful. There is a requirement. All procedural requirement that is absolutely not necessary for the protection of innocent is a lurking danger for the guilty. That is the problem. On the other side, you speak of procedural fairness, and in this procedural fairness, the real guilty fellow will escape. See, this is the problem. We had one infamous case, Jessica Lal murder case. The fellow was acquitted. She was shot in the open bar. So many witnesses were there, but at the end of that, everyone was acquitted. Then a newspaper item appeared. Everyone knows who killed Jessica Lal except the judge. Judge has to go by the evidence, rule book. And if the evidence has come, he will convict. If the evidence has not come, judge cannot do anything. So, it was a sort of mockery that happened. That is why whatever process that we are going to speak, whatever law we are going to speak, should be directed towards determination of truth. While speaking, our Honorable Director said, yes, there will be possibility of abuse. That also to be addressed by the lawmakers. Possibility of abuse. The stringent laws are very, very dangerous. All these accusations, see, Me Too. Anyone remembers this Me Too? Somebody say, I liked your lecture. Me Too. No Me Too. For me. What is this Me Too? Me Too became a mess over a period of time. See, it is well by a sim in the name of a lady, put it in a phone, take the help of a person and say, ನೀನು ದಿವಸ ಹೋಗಿ ಅಲ್ಲಿ ಸಿ ಎಸ್ ಪಾಟೀಲ್ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಬಾ, ಅಲ್ಲಿ ಹೋಗಿ ಅಲ್ಲಿ ಲಿಫ್ಟ್ ಇರ್ತೈತೆ, ಅಲ್ಲಿ ಹೊರಗಡೆ ನಿಂತ್ಕ, ಒಂದು ತಾಸು ಅಲ್ಲಿ ನಿಂತ್ಕ ಬಾ. ಅವ್ನು ಮೊಬೈಲ್ ಜೇಬಲ್ ಇಟ್ಕೊಂತಾನೆ, ದಿವಸ ಹೋಗಿ ಅಲ್ಲಿ ನಿಂದಿರ್ತಾನೆ, ಬರ್ತಾನೆ. ಅದೇನು ರೆಕಾರ್ಡ್ ತೋರಿಸ್ತದೆ, ಆ ಹುಡುಗಿ ದಿನಾಲು ನನ್ನ ಭೇಟಿ ಮಾಡೋದಕ್ಕೆ ಆಫೀಸಿಗೆ ಬಂದಿದ್ಲು. ಅದು ನಿಮ್ಮದೇನು ಇದಿರ್ತದಲ್ಲ, GPS. ಎವಿಡೆನ್ಸ್ ಈಸ್ ಕ್ರಿಯೇಟೆಡ್, ನೋ? ಆಮೇಲೆ ಒಂದು ಕಂಪ್ಲೇಂಟು, ಸಿ ಎಸ್ ಪಾಟೀಲ್ ನನ್ನ ಕರೀತೇನೆ, ಆಗಲಿಲ್ಲ, ದಿವಸ ಬಾ ಅಂತಂದು ಹೇಳ್ತಾನೆ, ಪ್ರೂಫ್. ಅದು ಇದು ರೂಟ್. These are the things. That's why we should be very, very careful when we address this situation. Whatever element of new criminal jurisprudence that we are going to press in service should be very, very cautiously done. As far as the crime is concerned, there is no doubt, no second opinion that this is the utmost heinous of the crime which deserves to be denounced with the utmost contempt and stigma. Only those people, see, it is so unfortunate. Who kills? In honor killings, who are the people? Caste people, religion people, they come later. Often it is their own brothers and sisters. Often it is their own parents. ಇದು ನಮ್ದು ಹೆಂಗೆ ಟ್ರೈನಿಂಗ್ ಆಗಿದೆ ಅಂದರೆ, ನೀನು ತನ್ನ ಮನೆಗೆ ಹುಟ್ಟಬಾರ್ದಾಗಿತ್ತು. ಅವನಿಗೆ ಪ್ರಚೋದನೆ ಮಾಡೋನು, ನಿನ್ನ ಮಗಳಂತ ಮಗಳು ನನ್ನ ಮನೆಗಿದ್ದರೆ ಕಡ್ದಾಕಿಬಿಡ್ತಿದೆ. ಇವನು ದೊಡ್ಡ ಮರ್ಯಾದಸ್ಥ. She also has her own choice. He also has her own choice. And that's why the court has spoken in terms of 3 levels: preventive, protective, and corrective measures. State has to, law should provide for preventive measures. ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರಲ್ಲ ಅವಾಗಲೇ, ಇನ್ಫಾರ್ಮೇಷನ್ ಬಂದ ತಕ್ಷಣ earliest you have to act, because death may happen anytime, crime may be committed, and immediately whoever officer to whom this is brought to notice, he has to act immediately and take preventive steps. Facilitate this couple who are interested in getting married or have married or whatever, provide them temporary shelter, etc. And the process is there, investigation process. There will be punishment for officers. Having come to know, if he conceals it, he will become an abettor. As it happens in the SC/ST Atrocities Act, negligent police officer. Being negligent police officer is another crime for which there will be punishment for the officers. That's how you have to ensure the enforcement of law by the officers. Then, see, penalty will be imposed, minimum punishment will be imposed, and there will be a provision that a portion of the penalty shall be given to the, and there will be a provision like bulldozer justice, attaching the property of the offenders and all that. These things may be there, that's fine. But ultimately, there is some dimension which is known as corrective. I will use another expression, restorative. Restorative. See, we are a very, very peculiar society. How we look at the victim of a rape. She is a victim. but she is unwanted. She becomes unwanted in her own family. She becomes unwanted in her school. ಟಿ ಸಿ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ನೀನು ಎಲ್ಲಾದ್ರೂ ಬೇರೆ ಕಡೆ ನಮ್ಮ ಸ್ಕೂಲ್ನಾಗ ಬೇಡ. She becomes unwanted in the neighborhood, being a victim. If you treat an offender like that, anybody can understand. But you are treating a victim like this. That means we are not trained how to treat this victim. See, here you will have victims. And how the society should respond to these people who are involved in these types of intercaste, interreligious marriages, who are assaulted and who have survived. How the college should treat them, how the neighborhood should treat them, how the parents should, see, there are parents. Okay, my daughter's choice is my choice. Happy? My dear, you have taken a decision, no? I am with you. ಹೇಳ್ತಾನೆ ಬೇಡಮ್ಮ ಅದು ಜಾತಿ ಬೇರೆ ಆಯಿತು ಇದಾಯಿತು ಬೇಡ ಮದುವೆ ಬೇಡ. ನೋ ಡ್ಯಾಡಿ ಐ ಹ್ಯಾವ್ ಡಿಸೈಡೆಡ್. ಅದೇ ಇಲ್ಲಾಂದ್ರೆ ನನ್ನ ಜೀವನವೇ ವ್ಯರ್ಥ. ಓಕೆ, they haven't done that. The fellow, ಈಗ ಹೇಳ್ತಾರೆ ಕನ್ನಡದಲ್ಲಿ ಹೊಟ್ಟೆಗೆಕ್ಕೆಂಬೋದು ಅಂತ, ಮಕ್ಕಳು ಮಾಡಿದ ತಪ್ಪು ಹೊಟ್ಟೆಗೆಕ್ಕೆಂಡು. There will be parents who will stand by the decision of their children, and when things go wrong they say ಹಾಳಾಗೋಲಮ್ಮ ಬಾ ಬಂದು ಮನೆಗಿರೋ ನಾನೇ ಇದ್ದೀನಿ ನೀನು ಯಾಕೆ ಎದುರ್ತಿದ್ದೆ, ಅವನನ್ನು ಕರ್ಕೊಂಬ, ಏನನ್ನು ದುಡಿತಾನೆ ಇಲ್ಲ ಅವನು, ಈಸ್ ಎ ಫ್ರೀ ಮ್ಯಾನ್ ಆಫ್ ದಿ ಫ್ರೀ ಕಂಟ್ರಿ. ಓಕೆ, ರೈಟ್. That type of parents may be there, but sometimes parents are to be trained. Parents are to be counseled to accept this. Justice side, awareness. Things are happening, but at the same time, conscience should be the guard. One should not fall prey. You see, it is a very simple thing. ನಾನು ದಾರ್ಯಾಗ ಹೋಗ್ತಾ ಇರಬೇಕಾದ್ರೆ ಫುಟ್ಪಾತ್ ಮೇಲೆ ಸೆಕೆಂಡ್ ಹ್ಯಾಂಡ್ ಪುಸ್ತಕ ಮಾರುವಲ್ಲಿ ಅಲ್ಲಿ ಕಡಿಮೆ ರೇಟಿಗೆ ಸಿಗ್ತಾವಂತ ನೋಡೋದು. ಹೌ ಟು ಬಿಕಮ್ ಎ ಗುಡ್ ಹಸ್ಬೆಂಡ್ ಅಂತ ಒಂದು ಪುಸ್ತಕ ಇದೆ. ಡೋಂಟ್ ಟೆಲ್ ಮೈ ವೈಫ್, ಓಕೆ. ಸೊ ಐ ಟುಕ್ ದಿಸ್ ಬುಕ್ ಆ್ಯಂಡ್ ರೆಡ್ ಹೌ ಟು ಮೇಕ್ ಎ ಗುಡ್ ಹಸ್ಬೆಂಡ್. ಯು ಸಿ, I borrowed so many lessons from that. Once you are out of your house, forget your house, wife, everything. Be jolly well. When you are going back home, on the way, you saw somebody selling a watermelon, take watermelon and go. Wife thinks, look at this fellow. He is working for Kilpa, occupied from morning till evening. And he remembers us. On the way back, he has bought a fruit for us. What fruit? Big fruit. If I learn the skills of, there is another small book, How to Fall in Love Successfully. Right now I am reading a wonderful book. I will not tell what is the book. Okay, don't give it a dash dash dash. Right? So maybe that Romeo of the modern era has a plot for this girl. He is not a good intentioned person. You may fall prey, you may fall victim. One should be. That's why all these social paradoxes are there. Parents opposing, religious leaders opposing. But ultimately, adult people make their choice, and it is a choice recognized by the Constitution, and it is to be respected. So when we frame any law more enthusiastically, we should not swing the pendulum to the opposite direction. We should keep the law in conformity with the due process requirements. However blameworthy the activity may be, law should be moderate to respect the constitutionally recognized rights, at the same time involving adequate measures to curb the ill thing that has come into the society. Thank you very much.
many legislations for the Karnataka, including the Karnataka State Human Rights Codes Rules 2006. He has received a commendation for his work in the field of human rights in 2010. He was a member of expert committee for the establishment of Karnataka Rural Development and Panchayat Raj University. Thank you, sir. We have Sir KBK Swami, advocate, as a speaker, and on behalf of RVS, Vivipura College of Law and Kilpar, extend a warm welcome to you, sir. A brief profile is here. KBK Swami, advocate, is known for his expertise in defending and prosecuting criminal cases before various courts and have highly successful track record in the appeals against conviction in serious offences. Sir has represented corruption cases, investigated CBI and Lokayukta, and has unique heart of cross-examination. KBK Swami, specially known for his integrity and conveying right advice and protecting clients' rights and interests. Warm welcome to you, sir. So I request the chairperson, Dwarakanath Babu sir, to commence over the sessions. Thank you.
Our session, ಯಾರು ತಗೋತಾರೆ? ನಮ್ಮ ಇವರು ಬರ್ತಾ ಇದ್ದಾರಲ್ಲ, ಜಸ್ಟಿಸ್. ಹಾಂ, ಈಗ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಗಿರೀಶ್ ಅವರು ತಗೋತಾರಲ್ಲ. ಈ ತಮ್ಮನ್ನೆಲ್ಲ ಅಡ್ರೆಸ್ ಮಾಡಿ ಮಾತಾಡಿದಂಥ ಮಾನ್ಯ ಪ್ರೊಫೆಸರ್ CS ಪಾಟೀಲ್ ಅವರಿಗೂ ಹಾಗೂ ಸ್ವಾಮಿ ಅವರಿಗೂ ಧನ್ಯವಾದ ಹೇಳ್ತೀನಿ. ನಮಸ್ಕಾರ. ಸರ್ ಕೇಳಿ.
We extend our thanks to KBK Swami, who embarked on contemporary challenges on human honor killing and reflected on historical violent killing of young couple. Thank you very much, sir.
Chair this session. On behalf of Rajya Vakkaligara Sangha, Kilpar, Vivipura College of Law, I welcome you too, sir, for this session. Now I call upon Dr. Girish Kumar R to the dais to continue the technical session 2. Welcome you, sir, on the behalf of sir. Brief profile of the sir. Dr. Girish Kumar, professionally he is a dentist. He was also our colleague. He has completed his bachelor in dental surgery from Government Dental College, Bengaluru, college only. Later, he completed his master's in criminal law and awarded gold medal for securing first rank in LLM degree, and also secured third rank in Karnataka State Law University in LLB degree. And he has delivered numerous talks as a guest speaker at various forums and presented many papers at international and national conference. After his meritorious academic career in law, he is serving in the capacity of panel advocate for Rajiv Gandhi University of Health Science, Karnataka State Law University, Bangalore University, and Karnataka State Dental Council. He also teaches IPC and Evidence Act in Vivipura College of Law. Now, sir has delivered the speak on the topic psychosocial aspect of honor-based violence. Welcome you, sir.
I am the chairperson for this session and the house should be under my control. My good friend Dr. Girish Kumar, he is going to talk on a very important topic. We do not know many things. Somewhere it is stated, thoughts make paths in brains. These neurons that are there, some of us will have genetic lottery. By hereditary thing we get some ability. Some of us have to cultivate our brains. And it is possible to cultivate brains. That's what I heard from a medical doctor. There is a lot of confusion in this world. You have seen that movie, Three Idiots. That hero advises, Bahar nahi aana, idhar bahut lafda chal rahe. I have already shown that symbol, no? I used to invite a psychiatrist and arrange a lecture in my college to drive home, make students understand what is the difference between love, lust, affection, obsession, infatuation, etc., etc., etc. जब भी कुछ होता है, how you arrive at the conclusion that that is the thing that is happening. There are two wonderful books written by the same author. I Am Okay, You Are Okay is one book. Being Okay is another book. Okay. What okay? Okay is a wonderful word. You have seen okay written on those trucks and the highways. You see them, no? Okay. Earlier, when the engine was invented, it was a kerosene engine. There used to be kerosene bunks. And then diesel engines came. So in the same bunk there is kerosene and there is also diesel. And these trucks which are running on kerosene will have this okay on kerosene. Okay, you will put kerosene there. This is different type of okay. When we speak of the topic like this, what is the psychological dimensions that are there of the people at the heart of it? Those people who have exercised their freedom of choice under Article 21 and those cognate people who are surrounding them and they are having resort to vehement and violent activities, their thinking process. I am equally eager with you to listen to Professor Dr. Girish Kumar. Welcome, sir.
Good afternoon, respected chair, dignitaries of the dais, students, delegates. I know it's time for lunch. I understand your anxiety. I'll not take much time, so I will cut down my deliberation. First, let me thank the Kilpar and my college, Vivipuram College of Law, for giving me an opportunity to deliberate on this particular topic, that is psychosocial aspects of honor-based violence. See, I have not used the word killings, but I have used the word honor-based violence. There is other violences apart from the killings also. And in my topic, I've used the word psychosocial. What are the psychological aspects? What are the sociological aspects? And I've used this psychosocial for the very reason that these two aspects are intertwined. So one is dependent on the other. So that is the reason why I've used this word psychosocial. This changes life. Yes, we all know that honor-based violence is a social vice which has been ingrained within the society from the time immemorial. And the notions of honor and shame and their use as justification for violence and killing is not unique to many cultures or religion. And indeed, honor or honor-based violence are reflected in historical events in many countries and in many works of the literature. And the present talk is aimed at to provide some sort of an psychosocial aspects of these honor-based violence. Next. Let us have some sort of historical context in respect of this honor-based violence. Ancient Roman time, the elderly male had the right to kill a woman who is engaged in premarital sex or extramarital affair. In Britain, Henry VIII, he beheads the fifth wife for committing an adultery. And under Ottoman rule in Arab country, a killer would sprinkle his victim's blood on his clothes and parade through the streets displaying the bloody murder weapon. And early Jewish law mandated death by stoning for an adulterous wife and her partner. And you all know the sati practice, which has been prevalent in our country, where the widow used to jump into the funeral pyre of the husband and sati was performed. And they call it as karo kari killings. Karo is called as the adulterer, the kari is the adulteress. So these are all some of the historical context which we could take in respect of this honor-based violence. Then what are the psychosocial aspects that could be considered in these sort of honor-based violences? One is purity or impurity. See, there are various psychosocial aspects, and this is one aspect that has to be looked. Purity or impurity. What is this purity or impurity? See, purity comprises of customs and nouns which pertains to the body and sexual behavior. And it may appear to be a question of personal preference and priority. And sexual impurity is considered as a crime in many cultures. What is this sexual impurity? Infidelity, immorality, lesbian relationship. These are all some of the sexual deviances which may happen. And this is very important. Woman is treated historically. Woman is treated as a piece of chattel. You know what do you mean by chattel? It's a personal property. So, welcome, sir. So, historically, woman is treated as a piece of chattel. A piece of chattel means a woman is a personal property and who shall be closely tied to two things, to other things. One is, if she is an unmarried girl, she should be tied to a virginity. If she is a married woman, she should be tied to a chastity. Chastity means refraining from having any sort of extramarital affair. So this is how a woman is being treated as a personal property in respect of virginity and chastity. See how the woman is being projected in the society. And this cannot be the similar things which we could attribute to a man. And woman's right to life will be endangered if she engages in any sort of this sexual deviances that what I have mentioned, whether it is infidelity, immorality, or any sort of other things, other sexual behavior. And in this aspect, one case I would like to quote which happened in the rural parts of Chikmagalur. A man, he comes to the police station with a gunny bag. ಒಂದು ಗೋಣಿ ಚೀಲದಲ್ಲಿ ಒಂದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್, ರೂರಲ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಬರ್ತಾನೆ. ಪೊಲೀಸ್ ಅವ್ರು ಏನೋ ಒಂದು ಗಂಟು ತಗೊಬಂದಿರ್ಬೇಕು ಇವನು ಅಂತ ಅನ್ಕೊಳ್ತಾರೆ. ಅವನು ಆ ಗೋಣಿ ಚೀಲನ ಬಿಚ್ತಾನೆ, ಬಿಚ್ಚಿಬಿಟ್ಟು ತನ್ನ ಹೆಂಡತಿದು ರುಂಡನ ಎತ್ತಿ ತೋರಿಸ್ತಾನೆ ಪೊಲೀಸವ್ರಿಗೆ. And the reason for beheading the wife's head is that she was having an extramarital affair with another person. And he comes home, he caught, red-handedly he was caught, he wanted to kill even the other person, but the other person escapes, wife was caught, wife was beheaded, her head was taken in a gunny bag, taken to the police station, and he lifts it in the honor that I've killed my wife. This is the honor killing. And this is one of the psychological aspect. This will also form a basis for the honor-based violence. And I'll tell you one more example which I would like to quote, which happened probably 15 years back. A girl, 20 years old, was pursuing her degree, and who comes from an Orthodox Iyengar family. She gets married, her family gets married to one more Iyengar boy from one more Iyengar family. And after few days, the girl come to know that husband is impotent. She brings this news to her, she tells this news to her father, mother, brothers. But she was convinced and persuaded not to leave that family. She wanted to take divorce. But she was persuaded just because she had other 2 daughters to get married. And she continues with this person. And after 15 years, she comes to the office and she wants to file a divorce petition. But she never wanted to take up this particular ground. But she tells that there is a cruelty from my father-in-law, mother-in-law, husband. I don't want to leave anymore. The reason why she has come now is that her last sister gets married just a few days back, and she wants to get rid of this particular thing. See, I've used the word honor-based violence for the reason that this is a classical case where this particular lady's sexual desire is being curbed by the honor in order to protect the honor of the family. Just because the other sisters has to get married, if she is a divorcee in an Orthodox family, who is going to come forward to get married to those sisters? And this is the thing which has been happening. This is a sort of an honor-based violence that has been meted out to this girl. And she comes after 15 years. Probably she might be around 35 years of age, and she wants to get rid of that family, but she never wanted to take the ground of impotence. Yes. Next is the belief. Something you believe to accept as true. And it is based on the facts, opinions, or assumptions. See, the bone of contention of beliefs between a person and a family are with respect to the marriage, with respect to the education, with respect to the dress code or in conformance of to the norms and expectations of the family or community. ನೀನು ಇದೇ ಓದಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ, ಫೋರ್ಸ್ ಮಾಡ್ತಾರೆ, ಇಂಥ ಹುಡುಗನ್ನೇ ನೀನು ಮದುವೆ ಆಗಬೇಕು ಅಂತಾರೆ. ದಿಸ್ ಇಸ್ ಎ ಹಾನರ್ ಬೇಸ್ಡ್ ವಯಲೆನ್ಸ್. ಇದೇ ಥರ ಡ್ರೆಸ್ ಹಾಕ್ಬೇಕು ನೀನು. ದೋ ಅವರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಪ್ರೊವೈಡ್ಸ್ ದ ಫ್ರೀಡಮ್, gives every right, but still she has to wear the dress which has been in accordance with the conformity of the norms of the family, the society, or whatever it may be. This is the belief that the person is going to have, and if there is any deviation from that belief, or if something contrary happens to that belief, then honor based violence steps into the picture. See how brutal these things have been happening. Then the anxiety of constant pressure to follow the rigid social norm, fear of losing a face in the society. One of the important causes in respect of this. See, we have a standing in the society. What will happen if my daughter marries to somebody of her choice who is not in the same status? What will happen to my standing in the community? These are the things. So what will happen? Suppose if they marry, I will be isolated from the community. These are all the anxieties that will creep in respect of the perpetrators. And desire to maintain one's standings while also being afraid of losing it is the reason why these honor killings might happen. Then the attitude, feelings, actions, thoughts towards a particular object or a person or a thing or an event. And it has a significant impact on the person's behavior, and it plays a very vital role in causing this honor-based violence. So another aspect, this is a sociological aspect, caste endogamy. A social rule to marry within the same caste or same religion. Deviation from this caste endogamy again results in honor-based violence. And there are a lot of instances where this caste hierarchy has sponsored these honor-based violences. And intercaste marriage is a prime factor to trigger this honor-based violence. Then another sociological aspect is the patriarchy, men-dominated society, where the task of the woman is reduced to home care and child care, and female feticide. Probably you might have, of late you have seen in the media, lot of female feticide which has been taking. This has been rampant, I'll tell you. Only now the police have come into the action, and unfortunately, I have to bail out some of the doctors where I represented before the Honorable High Court, where we got a stay in respect of those doctors. See, actually the police, I'll tell you one aspect which you should be aware is that there are a lot of false implications in the cases, which my learned friend also agree with the things, how the police has been acting over there. See, this is an act where it comes under the PCPNDT Act, where the police will not be having any sort of a role unless there is a complaint from an appropriate authority. But here, the police suo motu registers the complaint and files a case against the doctors, against a pediatrician who is no way concerned with that particular act. See, pediatrician's role will step in only when the babies are born. Female feticide will take place once a detection of the fetus, of the sex of the fetus, is been made by a radiologist and aborted by a gynecologist. But here, if pediatrician fixed for the reasons best known to the police. And main gynecologists and radiologists who were the part of that scam were not at all booked in that particular case. It is very unfortunate things, but this is a topic which is out of this thing. But female feticide is a first stage where this sort of honor-based violence is being casted upon the child which is not at all born, which is in the womb of the mother. Premarital sex and extramarital affair, another another reason which causes this social vice, which is being regarded as bringing a dishonor to the family's name and reputation or character. So notion of virginity or chastity hold significant importance in the Indian society. And some of the notable cases of honor-based violence, Manoj and Babli case, which happened in the year 2010, an interesting case where both Manoj and Babli, who gets married, and this will come to know, the relatives come to know, and they bring him before the Kap Panchayat. And the Kap Panchayat imposes a punishment. And probably in this case, both of them were brutally murdered, and which was abated by the Kap Panchayat. And the Honorable Court imposes a punishment on the members of the Kap Panchayat also. Then another infamous case, Nitish Katara case, well-known case which happened in Delhi. Nitish Katara, the Yadav's family, I think so, Bharti Yadav, she was the one who was in love with this Nitish Katara. Three brothers of Bharti Yadav, they take Nitish Katara, then he was found dead after a few days. And this is also one of the honor killings that happened in the Delhi. Then Netravati case which happened in Tumkur. Here again this girl Netravati was in love with one boy from the scheduled caste community. Then father and brother, they forced her to consume pesticide, for which she resists. Because she resisted, they strangulate her to death and they try to dispose the body. This is a recent case which happened in Tumkur. And also Bhavna Yadav case, again one more honor-based violence. Then we have got the legal framework, UN Convention on Elimination of All Forms of Discrimination Against Women, CEDAW, Article 12 of International Convention on Economic and Social Cultural Rights. Our Constitution provisions, as already Sir dealt, Article 14, 15, Clause 1 and 3, 17, 19 and 21. 21, one of the important articles where the right to life is been initiated, the proposition of right to life, which has been given of paramount importance. Then SC/ST Prevention of Atrocities Act, Protection of Human Rights Act. Then provisions under the Indian Penal Code, and probably the provisions under the Evidence Act, probably that is one which we could make a recommendation in respect of some sort of, because 113A and 113B of Evidence Act that is there, which shifts the onus on the accused to disprove his case. And as you all know, in law, proving a case is difficult, disproving a case is also difficult. Not proving a case is very, very easy. You should simply sit. Nothing is, if the prosecution, because we follow the system of acquisitorial jurisprudence, where the presumption of innocence, we go on that presumption of innocence, we go on that premise. The entire burden will be on the prosecution, and the prosecution has to prove the case. Any doubt that will be created in the mind of the court, that benefit of doubt will always go to the accused. So in that sense, proving a case is difficult. Whereas in inquisitorial system, they follow this presumption of guilt, where the entire onus will be on the accused to disprove that he has not committed this. Probably we might have to incorporate, especially in relation to this honor-based violence, some provisions under the Evidence Act, wherein the initial burden that will be there on the prosecution might get shifted onto the accused, as it has been done in cases of section 113A and 113B, abetment to suicide and dowry death. And also in cases of rape cases, the presumption of consent. So if something is been done, because these honor killings will not take place in a crowded area. And in this, the another problem that will be faced by the prosecution is, in these honor killings, there will not be any sort of an eyewitnesses. The prosecution has to depend on the circumstantial evidences. So that is the reason, if there is some sort of amendment that could be brought and incorporated in an Evidence Act, where the burden of proof or the onus of proof, if it shifts on to the accused, probably we might get some sort of a justice for such honor-based violences. Then my last suggestion and conclusion is that, yes, caste-based discrimination should be removed, intercaste marriages should be encouraged, and awareness should be created about the rights and liabilities of the honor-based violence, and the mentality of the people should be changed, and NGOs should actively get involved in spreading the awareness. So with this, I thank the chair as well as the Kilpar as well as the Vivpuram Law College for providing me an opportunity to deliver this topic. Thank you, sir. Thank you.
I welcome Justice Ashok G. Nijagananavar for Karnataka, Member, Law Commission of Karnataka, to this technical session to behalf of Vakkaligara Sangha, Kilpar and Vivpuram College of Law. Welcome you, sir. Yogendra, please honor the sir. I would like to read the brief profile of Honorable Justice Ashok G. Nijagananavar. Sir, born on 9th July 1959 at Dharwad, he did his BSc degree from Karnataka Science College, Dharwad, and LLB and LLM from Karnataka University Law College, Dharwad. Sir enrolled as an advocate in the year 1983 on the roll of Karnataka Bar Council and joined the chambers of Sri I.G. Iregaudar in civil and criminal law. Sir started as a legal advisor at several nationalized banks and cooperative banks, and he was the legal advisor of Hubli Dharwad Municipal Corporation, New India Assurance Corporation, Life Insurance Corporation, LIC Housing Finance, Karnataka University, University of Agriculture Science, Dharwad. Sir worked as honorary lecturer in University Law College and Urakaddi Ajja Law College at Dharwad. Sir is appointed as a direct district judge in the year 2002 and served as 13 additional city civil and session judge Mehal, Bengaluru up to March 2004. Sir worked as presiding officer of Special Court constituted for narcotic drugs and psychotropic substance till 26/5/2007. He served as first additional district judge at Asan, and he has also served as principal district judge and session judge Kodagu, Madikeri, Mangalore and Belagavi. Sir has served as member secretary of Karnataka State Law Legal Service Authority, Bengaluru from May 2013 to June 2016. He has also served as Registrar General High Court of Karnataka, Bengaluru, and later Sir elevated as Judge of High Court of Karnataka and assumed office on 22/10/2013 and retired on 9/4/2016. Sir now is a member of Law Commission of Karnataka from 4/10/2021. Welcome you, sir. Sir, Sir speaks on the topic need of the legislation, recommendation of Law Commission and Supreme Court about honor killing. Welcome you, sir, for this session.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಾನೇ ಕೊನೆಯ ಸ್ಪೀಕರು, ಯಾರು ಹೆದರ್ಕೋಬೇಡಿ. And I will not take much of your precious time also. I do not want to test your patience here. ಊಟಕ್ಕೆ ಟೈಮ್ ಆಗಿದೆ. Before I could address you all, dignitaries on the dais, Dr. C.S. Patil, Dr. Girish, Dr. Dwarkanath, Dr. Vadiyar, all honorable members of the teaching staff of this prestigious institution, and my dear friends, all great students of this college. I'm delighted to be here for a only reason that I could interact with you youngsters with a radiant faces and a bubbling energy. ಜೀವನದಲ್ಲಿ ಮೊದಲೇ ಪಾಠ ಹೇಳೋದು ಅಂದರೆ ಬದಲಾಗುವುದು ಈ ಲೋಕ ನೀ ಮೊದಲಾದರೆ ಅಂತ. ನಾವು in a society like, in a civilized society like this, ours, we have a collective responsibility. ಎಷ್ಟೇ ಕಾನೂನು ಮಾಡಿದರೂ ಏನೂ ಆಗಲ್ಲ. We have got to change the mindset of the people. ಆದರೆ ಕೆಲವೊಂದು ವಿಷಯ ಮಾತ್ರ ಅದು ಐ ವಾಂಟ್ ಟು ಟೆಲ್ ಯು ಲೈಕ್ ಎ ಲೇಮನ್, ಸಾಮಾನ್ಯ ಪ್ರಜೆಯಾಗಿ ಹೇಳ ಬಯಸ್ತೀನಿ, ನಾಟ್ ಆಸ್ ಎ ಜಡ್ಜ್, ಬಿಕಾಸ್ ಇವತ್ತು ಆಲ್ರೆಡಿ ಒಬ್ಬ ನಮ್ಮ ಜಸ್ಟಿಸ್ ದೀಕ್ಷಿತ್, ವೆಲ್ ನೋನ್ ಜಡ್ಜ್, ವಾಸ್ you have heard his electrifying speech on mythology, and he has given the insights how the law could be. And you have also heard the thought-provoking and informative speeches by Dr. C.S. Patil, Dr. Girish and others. You have already heard a lot, and you are fortunate to get this kind of information. Hardly a very few people can acquire the knowledge of this kind. Before I could speak very few words, I would like to ask one or two hypothetical questions. Please don't feel offended. ಮೊದಲೇ ಪ್ರಶ್ನೆ ಕೇಳೋದು ಅಂದರೆ ನಾನು, how many of you are of the opinion that your parents will support you in case if you go in for an intercaste marriage? ಕೈ ಎತ್ತರಿ. ದಯವಿಟ್ಟು ಎರಡೆರಡು ಕೈ ಎತ್ತಬೇಡಿ. ಎರಡನೇ ಪ್ರಶ್ನೆ, ದಿಸ್ ಇಸ್ ರಿಯಲಿ ಮೈಂಡ್ ಬಾಗ್ಲಿಂಗ್. ನಿಮ್ಮಲ್ಲಿ ಎಷ್ಟು ಜನ ಯೋಚನೆ ಮಾಡಿದ್ದೀರಾ, ಮನೆಯಲ್ಲಿ ತಂದೆ ತಾಯಿ ಪ್ರೀತಿ ಕಡಿಮೆ ಆಗಿ ಹೊರಗಡೆ ಪ್ರೀತಿ ಜಾಸ್ತಿ ಸಿಗುತ್ತೆ ಅಂತ ಇಂಟರ್ ಕಾಸ್ಟ್ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಳಕ್ ರೆಡಿ ಆಗಿದ್ದೀರಾ? ಇದು ನಿಮಗೆ ನಾವು ದಿಸ್ ಕ್ವಶನ್ ಮೇ ಅಪಿಯರ್ ಟು ಬಿ ಲಿಟಲ್ ಸಿಲಿ ಫಾರ್ ಯು, ಬಟ್ ನೀವು ಸುಮ್ಮನೆ ಒಬ್ಬರೇ ಇದ್ದಾಗ ಯೋಚನೆ ಮಾಡಿ ನೋಡಿ. ನೀವೆಲ್ಲರೂ ನಿಜವಾಗ್ಲೂ ಭಾಗ್ಯವಂತರು. ಯು ಆರ್ ಆಲ್ ಫಾರ್ಚುನೇಟ್. ಯು ಆರ್ ಸ್ಟಡಿಂಗ್ ಇನ್ ಅ ಪ್ರೆಸ್ಟಿಜಿಯಸ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಯುವರ್ ಪೇರೆಂಟ್ಸ್ ಹ್ಯಾವ್ ಸೆಂಟ್ ಯು ಹಿಯರ್, ಹ್ಯಾವ್ ಗಿವನ್ ಆಲ್ ಫೆಸಿಲಿಟೀಸ್ ಇನ್ ಲೈಫ್. ಎಲ್ರಿಗೂ ಆಲ್ ಆರ್ ನಾಟ್ ಆಲ್ ದಟ್ ಫಾರ್ಚುನೇಟ್. ಎಲ್ಲ ಮನೆಯಲ್ಲಿ ಇದ್ರೂ ಕೂಡ ಕೆಲವೊಂದು ಸಲ ಏನೋ ಕೊರತೆ ಕಾಣ್ಬೋದು. Some people get frustrated because of the environment at house or home. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇನ್ನೂ ನಾನು ಹೇಳ್ಬೋದು ಅಂತಂದರೆ ಈ ಸಿನಿಮಾಗಳ ಎಫೆಕ್ಟು ಇರ್ಬೋದು. ಐ ಆಮ್ ಸ್ಪೆಷಲಿ ಸ್ಪೀಕಿಂಗ್ ಆಫ್ ದ ಮೈನರ್ ಗರ್ಲ್ಸ್ ಪ್ಲೇಯಿಂಗ್ ಅವೇ ಫ್ರಮ್ ದ ಹೌಸ್. ಯಾರೋ ಒಂದು ಕತೆ ಇರುತ್ತೆ, ಅದು ಕತೆ ನೋಡೋಕೆ ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಅನಿಸುತ್ತೆ. ಆಗರ್ಭ ಶ್ರೀಮಂತರ ಮನೆ ಮಗಳು ಯಾರೋ ಡ್ರೈವರ್ ಜೊತೆ ಅದು ತೋರಿಸೋದು, ಲವ್ ಸ್ಟೋರೀಸ್ ಎಲ್ಲ ತೋರಿಸ್ಬಿಡ್ತಾರೆ. ಆಯಿತು, ದೇರ್ ಆಲ್ ಇಟ್ಸ್ ಸಮ್ ಕೈಂಡ್ ಆಫ್ ಫ್ಯಾಂಟಸೀಸ್. ಇನ್ ರಿಯಾಲಿಟಿ ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್, ಈ ಜಗತ್ತಿನಲ್ಲಿ ನೀವು ಯಾರನ್ನೇ ಕೇಳಿ, ತಪ್ಪು ಮಾಡಿದವನ್ನ ಗ್ರೇಸ್ಫುಲಿ ಅಡ್ಮಿಟ್ ಎಲ್ಲರೂ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಹೌದು ಸರ್, ನಾನು ಮಾಡಿದ್ದು ತಪ್ಪು ಅಂತ. ಈಚ್ ಪರ್ಸನ್ ವಿಲ್ ಹ್ಯಾವ್ ಹಿಸ್ ಓನ್ ಜಸ್ಟಿಫಿಕೇಶನ್. ಅದು ತಂದೆ ತಾಯಿಗಳಾಗಿರ್ಬೋದು, ಇಂಟರ್ ಕಾಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿರೋ ಹುಡುಗ ಆಗಿರ್ಬೋದು, ಹುಡುಗಿ ಆಗಿರ್ಬೋದು, ಅಥವಾ ಯಾರೇ ಆಗಿರ್ಬೋದು. ಪ್ರಶ್ನೆ ಇಷ್ಟೇ, ಇನ್ ಎ ಸಿವಿಲೈಸ್ಡ್ ಸೊಸೈಟಿ ಇದೆಲ್ಲ ನಮ್ಮಲ್ಲಿ ಯಾಕೆ ವರ್ಗ ಭೇದ ಇದು ಎಲ್ಲ ಸಾಕಷ್ಟು ಬಂದ್ವು ಅಂದರೆ, ಇದು ಯಾವುದು ನ್ಯಾಚುರಲ್ ಲಾನಲ್ಲಿ ಯು ಮಸ್ಟ್ ಹ್ಯಾವ್ ಸ್ಟಡಿಡ್. ಯು ಡೋಂಟ್ ಫೈಂಡ್ ಎನಿ ಕಾಸ್ಟ್, ಕ್ರೀಡ್, ಪ್ಲೇಸ್ ಆಫ್ ಬರ್ತ್ ಏನೂ ಇರಲ್ಲ ಪ್ರಾಣಿ ಪಕ್ಷಿಗಳಲ್ಲಿ. ಅದೆಲ್ಲ ಇರೋದು ನಮ್ಮಲ್ಲಿ ಮಾತ್ರ. ಸೋ ಕಾಲ್ಡ್ ಎಜುಕೇಟೆಡ್ ಆರ್ ಎ ಸಿವಿಲೈಸ್ಡ್ ಸೊಸೈಟಿನಲ್ಲಿ ನಾವೆಲ್ಲ ತಿಳಿದಿದ್ದೀವಿ ಅನ್ನೋರಿಗೆ ನಾವೇ ಮಾಡ್ಕೊಂಡಿದ್ದು. 12ನೇ ಶತಮಾನದಲ್ಲಿ ಜಗದ್ಯೋತಿ ಬಸವೇಶ್ವರ ಹಿ ಟ್ರೈ ಟು ಬ್ರಿಂಗ್ ಈಕ್ವಾಲಿಟಿ ಬೈ ಪರ್ಫಾರ್ಮಿಂಗ್ ಇಂಟರ್ಕಾಸ್ಟ್ ಮ್ಯಾರೇಜಸ್. ಆದರೆ ನಮ್ಮ ಸಮಾಜದಲ್ಲಿ ನಾವು ಯಾರೂ ಸಪೋರ್ಟ್ ಮಾಡಲಿಲ್ಲ. ವಿ ಹ್ಯಾಡ್ ದೇರ್ ಓನ್ ಜಸ್ಟಿಫಿಕೇಶನ್. ನೀನು ನಮ್ಮ ಕುಲಗ ಗೆಡ್ಸ್ಬಿಡ್ತೀಯ ಅಂತಂದಿರ್ಬೋದು, ಅಥವಾ ಏನೋ ಸಾಕಷ್ಟಿದೆ. ಕಲ್ಯಾಣ ಕ್ರಾಂತಿ ಆಯಿತು, ಆಲ್ ರಿಫಾರ್ಮಿಸ್ಟ್ ಹ್ಯಾಡ್ ಟು ರನ್ ಅವೇ ಫ್ರಮ್ ಕಲ್ಯಾಣದಿಂದ ಓಡೋಗ್ಬಿಟ್ರು ಬಸವ ಕಲ್ಯಾಣ. ಸುಮಾರು 12ನೇ ಶತಮಾನದಿಂದ ಈಗ ಎಷ್ಟು 21ನೇ 22ನೇ ಶತಮಾನಕ್ಕೆ ಕಾಲಿಡ್ತಾ ಇದ್ದೀವಿ, ಇನ್ನೂ ನಾವು ಸುಧಾರಿಸಿಲ್ಲ. ಅದಕ್ಕೆ ವಾಟ್ ವಿ ನೀಡ್ ಇಸ್ ವಿ ವಾಟ್ ಟು ಚೇಂಜ್ ಅವರ್ ಮೈಂಡ್ ಸೆಟ್. ಯಾವಾಗಲೂ ಮೋಸ್ಟ್ ಆಫ್ ದ ಲಾಸ್ ಆರ್ ಬೇಸ್ಡ್ ಆನ್ ಮಾರಲ್ ವ್ಯಾಲ್ಯೂಸ್. ಅದು ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ತಳಹದಿ ಮೇಲೆ ಇರ್ತವೆ. ಅವನ್ನೆಲ್ಲ ನಾವು ಕಾನೂನಂತ ಮಾಡದೇ ಇದ್ರೆ ಜನ ಹೆದರೋಲ್ಲ. ನಾನು ಕೊಟ್ಟಿರೋ ಟಾಪಿಕ್ ಮೇಲೆ ನಾನು ವೆರಿ ರಿಸ್ಟ್ರಿಕ್ಟೆಡ್ ಇದ್ರೊಳಗೆ ನಾನು ಹೇಳ್ತೀನಿ, ನೀಡ್ ಫಾರ್ ಲೆಜಿಸ್ಲೇಷನ್ ಯಾಕೆ ಬೇಕು? ಈಗ ಸಾಕಷ್ಟು ಕಾಯ್ದೆಗಳಿವೆ. 1872 ಲಾರ್ಡ್ ಮಕಾಲೇನ ಈಗ ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡ್ ಮಾಡ್ದ. SC/ST ಆಕ್ಟಿಗೆ ಕಾಯ್ದೆ ಇದೆ, ಪೋಕ್ಸೋ ಇದೆ, ಪ್ರಿವೆನ್ಷನ್ ಆಫ್ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಇದೆ. There are so many laws. Despite that, why we are feeling or that there is a constraint to punish the offenders who are involved in honor killings? The first and the foremost reason would be the violence in the these honor killings on account of intercaste marriages is qualitatively and quantitatively different from offenses under other acts. honor killings are nothing but these are horror stories. Violence, tragedy, all sorts of pain is there in that. ತಂದೆ ಮಗಳನ್ನ ಕೊಂದ್ರೆ ತಾಯಿ ರಾತ್ರಿ ಇಡೀ ಜೀವಮಾನ ಅರ್ಥ ಕೊಡ್ತಾಳೆ. ಕೊಂದವ್ರು ಯಾರು ಬೇರೆ ಇರೋಲ್ಲ ಅರ್ಥಲ್ಲಿ. Their own kith and kin. The people who have nurtured, taken care of their kids resort to this kind of violent activities only to save from the blamings of the society. Sometimes because of the religious, the boycott, social boycott what they face in the society. ಕೆಲವೊಂದು ಏನೇ ಕಾರಣ ಇರ್ಬೋದು, but it is not justified. That is why most of the time the Honorable Supreme Court has felt the need to pass some legislation. Of course, some modification is required. ಈಗ ನಮ್ಮ ಡಾಕ್ಟರ್ ಗಿರೀಶ್ ಹೇಳಿದ್ರು, onus of proving the case, the burden should be shifted on the accused instead of the prosecution. Section 300 IPC ನಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ? Because always under the constitution you have got every right to keep silent. You can't open your mouth. The law cannot compel you to speak against yourselves. That is what you call the self-incrimination. It goes to the root of the matter. Ultimately it is left to the wisdom of the legislation how best it can be taken, because ಈಗ 113A(b) ನಲ್ಲಿ dowry ಇದರಲ್ಲಿ the burden is shifted on the accused who are involved in committing the barbaric acts like this, killing a female. ನಾವು ಯಾರನ್ನ ಅಂದರೆ most of the honor killings, females are the victims. In hardly 10-20%, both boys and girls may be killed. But ultimately, the majority of the cases, the vulnerable class, the weak section is the girls who becomes the victims. By passing the law, can we change the mindsets of the people? Will be again a mind-boggling question. Always we believe in the reforming theories. ಜನರ ಮನಸ್ಸನ್ನು ಪರಿವರ್ತನೆ ಮಾಡಬೇಕು. ಈಗ ಸಾಕಷ್ಟು ಚೇಂಜ್ ಆಗಿದೆ. ಸಾವಿರಾರು ಜನ, ಲಕ್ಷಾಂತರ ಮಕ್ಕಳು either they go to foreign countries or they come from different states here. The question that arises most of the times, Honorable Supreme Court has clearly said, 2 adult male and female consenting parties are there. Thinking of the pros and consequences of that, they may feel it that even though it is an intercaste marriage or an inter-religious marriage, whatever you say, is beneficial to them to lead happy married life. Those couples should not be harassed. They should not be hurt, should not be caused to them under the guise of. There will be some sort of miscreants in the society. Always they try to create mess out of it. Or ಸುಮ್ಮನೆ ಕೊಡೋಕ್ಕಾಗದೆ ಬೇರೆಯವರು ಕೂಡ ಫೋರ್ಸ್ ಮಾಡಿ they resort to this kind of killings. In all walks of life, you take ಹಿಂದೆ ಮಾರ್ಟಿನ್ ಲೂಥರ್ ಕಿಂಗ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದ, it is not the violence committed by the very few class of persons which are harmful, it is the silence of the majority of the people. ನಾವು ತುಂಬ ಜನ ಪ್ಯಾಸಿವ್ ಆಗಿ ರಿಯಾಕ್ಟ್ ಮಾಡ್ತೀವಿ. ನಮ್ಮನೇದಲ್ಲ ಕೇಸ್, ಬೇರೆಯವ್ರ ವಿಷಯದಲ್ಲಿ ಪರರ ಚಿಂತೆ ನಮಗೆ ಕೈ ಅಂದರೆ ಇಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡೋದು ಬೇಡ. ನಾವು ವಿ ಶುಡ್ ರೆಸ್ಪಾಂಡ್. ಅದಕ್ಕೆ ಹೇಳಿದೆ, ಬದಲಾಗುವುದು ಈ ಲೋಕ, ನೀವು ಬದಲಾದ್ರೆ ಅಂತ. ನಾವು ಸಮಾಜದ ಏಳಿಗೆಗೆ ದುಡಿದ್ರೆ ಮಾತ್ರ ನಮ್ಮ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ನೀವೇನು ತುಂಬ ಹೋಗಿ ಕೆಲಸ ಮಾಡಬೇಕು ಅಂತಿಲ್ಲ. ಈ ಜಸ್ಟಿಸ್ ಆರ್ ದ ಇನ್ಜಸ್ಟಿಸ್ ಅನ್ನೋದು ಇಟ್ ಈಸ್ ಸಚ್ ಎ deep rooted in the sense of Justice Brennan of the US Supreme Court once said, nothing rankles more in human heart than brooding sense of injustice. Every person na ಹೇಳಿದ್ದೆ ನಿಮ್ಗೆ ಆಗಲೇ, parents will think that injustice has been caused by their own daughter because they are totally blinded to the realities. ನನ್ನ ಮಗಳು ಖುಷಿಯಿಂದ ಇರ್ತಾಳೆ ಅಂತ ಬಯಸಲ್ಲ, ಅದು ಏನು ಯಾರು ಮಾಡ್ಕೊಂಡಿದ್ದು ಎಲ್ಲೋ ಹೋಯ್ತು ಹುಡುಗಿ, ನಾವು ಇಷ್ಟು ಚೆನ್ನಾಗಿ ಬೆಳೆಸಿದ್ದು ಇದಕ್ಕೆ ಆರ್ ದ ಅದರ್ಸ್ ಮೈ ಥಿಂಕ್ those who are forward little, they may come with a concept, some kind of reason that ನಮ್ಮ ಅವ್ರನ್ನ ಬೆಳೆಸೋದ್ರಲ್ಲಿ ಏನಾದರೂ ಕಡಿಮೆ ಆಯ್ತಾ. But at the same time, the younger generation, the boys and girls will think, ನಮ್ಗೆ ಯಾಕೆ ತಂದೆ ತಾಯಿ ಇಷ್ಟೊಂದು ನಮಗೆ ಉಸಿರು ಕಟ್ಟಿಸುವಂಥ ವಾತಾವರಣ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಮಗಷ್ಟು ನಮಗೆ ಬೆಲೆ ಇಲ್ವಾ, ನನ್ನ ಜೀವನ ನಾನು ಇನ್ನೊಬ್ಬರ ಜೊತೆ ನಾನು ಸುಖವಾಗಿರೋದನ್ನ ನನ್ನ ತಂದೆ ತಾಯಿಗಳು ಬಯಸೋದು ಬೇಡವಾ. ಇದು ಎರಡು ಕಡೆ ಇಷ್ಟೊಂದು ದ್ವಂದ್ವ ಆಗ್ಬಿಡುತ್ತೆ ಅಂದ್ರೆ, ಇದನ್ನ ದ್ವಂದ್ವ ನಿವಾರಣೆಗೆ ನಮ್ಮ ಮೈಂಡ್ ಸೆಟ್ ಸರಿಯಾಗಿ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಅಲ್ಲಿವರೆಗೂ ನಮಗೆ there is a need for legislation. The Supreme Court has come up with some novel ideas. ಇಲ್ಲಿ ನನಗೆ I got some few guidelines. Please read if you make use of your library. ಯಾಕಂದರೆ 2:30 ಆಗ್ತಾ ಬಂತು. I do not want to test your patience again. But what best can happen in your life is, you are the better judge for your life. ಯಾರ್ದೋ ಕೆಲವೊಂದು ಫೋರ್ಸಿಬಲ್, ಡಾಕ್ಟರ್ ಚೆನ್ನಾಗಿ ಹೇಳಿದರು, ಫೋರ್ಸಿಬಲ್ ಮ್ಯಾರೇಜಸ್ ಬೇರೆ, ಇಂಟರ್ ಕಾಸ್ಟ್ ಮ್ಯಾರೇಜಸ್ ಬೇರೆ, ವಿದಿನ್ ಫ್ಯಾಮಿಲಿ ಆಗೋದು ಬೇರೆ, ಇದೊಂದು ಸಗೋತ್ರ. ಯಾಕಂದರೆ ಕೆಲವೊಂದು ಹೇಳಿದ್ರಿ ಇಂಟರ್ ಕಾಸ್ಟ್ ಮಾಡ್ಬೋದು. ದರ್ ಇಸ್ ಅ ಸ್ಪೆಷಲ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ವಿಚ್ ಎಂಕರೇಜಸ್ the newly married couple to get their marriage registered. There is no prohibition as such in law. ಆದರೆ ಒಂದು somebody has pointed out that, ಸರ್ 1 ತಿಂಗಳು ನೋಟಿಸ್ ಕೊಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಆ 1 ತಿಂಗಳಲ್ಲೇ ಅವರು ಪೇರೆಂಟ್ಸ್ ಮನೆಯವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬಿಟ್ರೆ ಬಂದು ಹೇಳ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತಾರೆ ನಮ್ಮನ್ನು. ಆ 1 ತಿಂಗಳು ಎಲ್ಲಿ ಮುಚ್ಚಿಟ್ಕೊಳ್ಳೋದು. Again, these are all minor loopholes of them. How to correct them, it is left to the wisdom of the legislation. You come with your feedback to the Kilpar, who has been doing a wonderful job by organizing such conferences or creating a platform for you all to apply your mind. Mechanically, book ಓದೋದು ಬೇರೆ, ಇದು ಬೇರೆ. ನೀವು 1-to-1 when you discuss the matters, it goes directly into your brain. That is why, my dear friends, ಕೆಲವೊಂದು ವಿಷಯ ಸಮಾಜದಲ್ಲಿ ಏನು ನಡೆಯುತ್ತೆ ಅಂತ, ಯಾಕಂದ್ರೆ ಯು ಆರ್ ಗೋಯಿಂಗ್ ಟು ಬಿ ಲಾಯರ್ಸ್, ನೀವು ಸಮಾಜದ ಒಂಥರ ಕನ್ನಡಿ ಇದ್ದಾವೆ. ಯು ಕ್ಯಾನ್ ರಿಫ್ಲೆಕ್ಟ್ ವಾಟ್ ಈಸ್ ಹ್ಯಾಪನಿಂಗ್ ಇನ್ ದ ಸೊಸೈಟಿ. You can create a public opinion and take up the onerous duty of spreading the awareness. ಕಾನೂನಲ್ಲಿ ಬರೀ ಎಲ್ರಿಗೂ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡೋಕ್ಕೆ ಕಾನೂನು ಇದ್ರೆ ಅದು ದಟ್ಸ್ ನಾಟ್ ಎ ಕಾನೂನು. ಈಗ ಡಾಕ್ಟರ್ CS ಪಾಟೀಲ್ ಅವರು ಹೇಳ್ತಾ ಇದ್ರು, ಸರ್ ಯಾಕಂದರೆ ಈ ಆನರ್ ಕಿಲ್ಲಿಂಗ್ಸಲ್ಲಿ ಈ ಮೊನ್ನೆ ಒಂದು ರೀಸೆಂಟ್ಲಿ ಯು ಆಲ್ಮೋಸ್ಟ್ ರೆಡ್ ಇನ್ ದ ನ್ಯೂಸ್ ಪೇಪರ್, ಬೆಳಗಾವಿ ಜಿಲ್ಲೆಯಲ್ಲಿ ವಂಟಮುರಿ ಗ್ರಾಮದಲ್ಲಿ ಆಯಿತು. ಪೊಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ ಯಾರೂ ಮುಂದೆ ಬರಲಿಲ್ಲ. Even the division bench in which our Honorable Justice Dikshit was one of the person or the judge in the division bench, they could even had to make an observation that the whole village has to be penalized because ಬ್ರಿಟಿಷ್ ಟೈಮ್ನಲ್ಲಿ ಏನಾಗ್ತಾ ಇತ್ತು, ಅವ್ರ ಊರಿನಲ್ಲಿ ಕಳ್ಳರು ದರೋಡೆಕೋರರು ಎಲ್ಲರೂ ಇದ್ದಾಗ ಅವ್ರು ಯಾರು ಅವ್ರಿಗೆ ಹೆದರ್ಕೊಂಡು ಅವ್ರ ಊರು ಜನ ಯಾರು ಮುಂದೆ ಬರ್ದಿದ್ದಾಗ ಎಲ್ರಿಗೂ ಪುಂಡಗಂಧಾಯ ಹಾಕ್ತಿದ್ರು. ಪುಂಡಗಂಧಾಯ ಅಂದರೆ ಇಂಪೋಸಿಂಗ್ ಸರ್ಟನ್ ಪೆನಾಲ್ಟಿ ಟು ಡಿಸ್ಕರೇಜ್ ಆರ್ ಟು ಎಂಕರೇಜ್ ದ ಪೀಪಲ್ ಆಲ್ಸೋ. ಇದರಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ ಅಂತಂದ್ರೆ ಪ್ರಶ್ನೆ ಬರೋದಿಷ್ಟೇ, ಯಾರು ಮುಂದೆ ಬರದೇ ಇದ್ದಾಗ ವಿ ಶಾಲ್ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಎ ಪ್ರಾಜೆಕ್ಟ್ ಫಾರ್ ವಿಟ್ನೆಸ್ ಪ್ರೊಟೆಕ್ಷನ್. ಈ ಕಪಲ್ ಮದುವೆ ಮಾಡ್ಕೋತಾರೆ, ಕಪಲ್ ಮದುವೆ ಮಾಡ್ಕೊಂಡ್ರೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಅವ್ರಿಗೆ ಯಾರು ಸ್ವಲ್ಪ ನ್ಯೂಸ್ ಸ್ಪ್ರೆಡ್ ಆಗಿಬಿಟ್ರೆ ಅವ್ರಿಗೊಂದು ಏನು ಜೀವನ ನಡೆಸೋದು ತುಂಬ ಕಷ್ಟ ಆಗುತ್ತೆ. ಅದು ಪ್ರೀತಿ ಆಗಿರ್ಬೋದು, ಯಾವುದಕ್ಕಾಗಿರ್ಬೋದು, ಪ್ರೀತಿ ತುಂಬ ದಿವಸ ನಡೆದ್ರೆ ಅವ್ರು ಹೌ ದೇ ಶುಡ್ ಸರ್ವೈವ್. ದ ಕಪಲ್ ಡೆಫಿನೆಟ್ಲಿ ವಿಲ್ ಬಿ ಪುಟ್ ಟು ಹಾರ್ಡ್ಶಿಪ್. ಅದಕ್ಕೆ ವಿಕ್ಟಿಮ್ ಕಾಂಪನ್ಸೇಷನ್ ಇರಬೇಕು, ವಿಕ್ಟಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇರ್ಬೋದು, ವಿಟ್ನೆಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇರ್ಬೋದು. ಅವ್ರಿಗೆ even the Supreme Court has come out with new suggestions. The higher officers should take up this investigation, and the couple should be provided with some safe place to stay. Otherwise, the life becomes miserable. There are so many novel ideas suggested by the Honorable Supreme Court. Please go through them. Let us make an endeavor to have a novel, most appropriate legislation to curb the menace of these honor killings. I thank Kilpar and other management of this prestigious institution for giving me an opportunity to share few ideas with you all. Thank you, Anand.
Now we have heard two excellent presentations by Honorable Justice Sri Ashok Ji Nijganawar and Dr. Girish Kumar. Voluntary restraint in all aspects of life. When it is time to go for lunch, there should not be observations, compliments, etc. Over to the organizers for further procedures. Madam.
From College of Law, I would like to extend my heartful gratitude to our honorable guests of this session for your busy schedule. I would like to extend a special thanks to C.S. Patil sir to chair this session. I would like to extend special thanks to Honorable Justice Ashok G. Nijganawar. The session was very informative, sir. Now C.S. Patil sir to facilitate the Ashok sir. Dwarkanath sir. Thank you, sir. I would like to extend special thanks to Dr. Girish Kumar sir. Speak on the topic. Thank you, sir. Your valuable words. I would like to call upon Dwarkanath sir to facilitate Girish Kumar sir. Thank you one and all for making this event most successful with your presence. Thank you all. Now the lunch is followed. Now you can have the lunch. Next, the parallel session will be started at 3 o'clock.
Presented around 40 papers at national and international conference organized in different parts of the country. Secured Best Paper Award for paper titled Live-in Relationship, Impact on the Hindu Marriage at national conference organized by JSS Law College, Mysore, published articles in reputed journals in India. She has actively participated in creating legal awareness to weaker sections of the society, especially rural women, in programs organized by the Karnataka Legal Services Authority. She had been invited by Karnataka Legal Services Authority to give a guest lecture on women's rights at PU colleges and degree colleges and for NSS officers in Bangalore. She also served as NSS officer for Karnataka State Law University, Hubli, and organized legal aid camps and legal awareness programs in Bengaluru. She has even delivered guest lectures on intellectual property rights, child rights, succession, women's rights, trafficking of women and children, sexual harassment at workplace, etc. in various seminars. The All India Law Teachers Association selected her as an executive member for South India. She was appointed Director of Karnataka Law Teachers Association for Bangaluru's North Zone, and presently she is a Board of Studies member for Faculty of Law, PS University and University Law College, Bengaluru. She served as a professor of law at CMR School of Legal Studies for the past 12 years. Overall, she has serving in legal education and contributed in molding the future of the students as a law graduate for the past 25 years. She has been awarded as a Best Guru in the 5th International Award Conference of RACE 2022. It stands for Research, Analysis, and Communicate and Evaluate. And her hard work and outstanding achievements in her area of expertise and contribution to socio-economic development and nation building by International Association of Research and Development Organization. She was conferred with National Trailblazer Triumph Award, Gratis Award for Excellence in Book Writing in the esteemed category of Distinguished Social Sciences Author 2022. Accolade was organized by Majestic Technology Solutions Private Limited, Chennai for the book Study and Analysis and National Register of Citizens of Assam. And Madam also has been confirmed with Global Excellence Award, Distinguished Service in Legal Education, and STAR 2023 4th Global Multi-Track Conference and Awards organized by Special Minds India and UNIFAC West University, Brazil, South America for 25 years service in legal education. Now I would like to please Madam take the proceedings further and come to the dais. Thank you, ma'am. And with the permission of the chair, so I would like to call upon the presenters of the day, parallel session 1. Dr. Ashwini P., Assistant Professor of Law, Anushri S., Research and Scholar upon honor killing in India, unraveling the socio-legal challenges.
Good afternoon, everybody. So my topic honor killing in India, unraveling the socio-legal challenges. So I have done my paper with Dr. Ashwini ma'am, and so today, so to look into, first of all, analyzing the existing laws. We all know what is honor killing. Honor killing is killing, or honor killing can also be considered as a heinous crime because it is also known as we have to evaluate the current effectiveness of the current legislation. So through my paper, I am trying to find out the current scenario, what is happening in India, and what are the causes of honor killing, and what are the current situation, and what is the solution to that. Honor killings are troubling worldwide issue that arises from socio-psychic dynamic and that are common in all civilization. Before honor killing, we all were aware about the practice called as sati system, which was actually abolished after the coming of Constitution of India. And also killing someone is always wrong, and it is always against law and a fragment violation of human rights. To take someone's life without cause is justification is wrong, and it also violates law and as well as the constitution, because under the constitution, under article 21, which is the mother of all liberties, there is a protection already given that everybody have a right to choice. So right to choice is a fundamental right, and everybody have that choice. And here through honor killing, that choice has been questioned, that has been violated. So to go to the overview of honor killing in India, honor killing is morally wrong, and it violates the constitution rights, as well as choosing a spouse is legally protected freedom, and as well as honor killing is labeled as shame killing. And it is, what are the main reasons we look into why honor killing is in India? It is, first of all, the main reason is socio-cultural factors. India is a country where we are culturally diverse, but even though under the constitution we have the right to preserve our cultures, but it should not violate our fundamental rights. And also the consequences of this is more often severe in women, as well as honor killings are distinct from the past customs. And like, as I already told, there is sati system, which was representing modern challenger to outdated beliefs. Okay, so now what are the specific reasons of honor killing in India? First one is mentality of the people. There is a high need to change the mentality of the people regarding to the right to choose and honor killing. As well as the second thing is caste system rigidity. Especially when in the earlier times it was Brahmin, Kshatriyas, Vaishyas and Shudras. But if you take the subcaste, it is also different. So this caste system rigidity in the minds of the people is one of the main reasons or specific reasons to honor killing. Third reason is inter-religion marriage. Then the next reason is illiteracy and lack of awareness. So sir has already suggested us that is through legal aid camps and through awareness classes, we can change this behavior in the society. And there is inadequate laws if we look into the specific reasons of honor killing in India. Then also the another main reason that has been happened recently is homosexuality, because homosexuality has been one of the major reasons that has been happening for the honor killings. Because in a recent case which happened in Kerala, 2 Muslim girls were actually homosexuality, but their parents has actually banned them, and that went to a case law, and that through habeas corpus writ in the Kerala High Court, the solution has been came up. Then next is the abuse of the practices or absence of a certain legislature. Next, if you look into the legislative background regarding honor killing in India, in Indian Constitution we have Article 14, right, equality before the law. And then under Article 15 we have the discrimination based on gender, religion, caste, gender and place of birth. Then Article 15 clause 3 says that there should be a special preference. The state government can make special preference for the women and children. And if you look into the case law that has been there, there is a case law called as Leda Singh versus State of UP. It is a Supreme Court ACC case. In that case, the Honorable Judge has told that it is barbaric and shameful, the act of honor killing. That act of honor killing brings a shame on the Indian society, and that has been, and the people were held as punished under the case Leda Singh versus State of UP. Then there is one more another case, that is Armugam Servai versus State of Tamil Nadu. In this case, there were actually Ka Panchayat. I hope Ka Panchayat means it is a system. Okay. So I would like to go to the suggestions and conclusions, and I am concluding it. Can you go to suggestions and conclusions? So the solution to tackle is present crime system, that is currently there is an act which has been came up, that is Prevention of Crimes in the Name of Honor Tradition Bill 2010. Then also if you look into the current enactments, we are having IPC, but even though IPC provisions are not sufficient to support honor killing, and as well as I just explained regarding this Ka Panchayat, this Ka Panchayat is a caste based system. So if you look into that, in Rajasthan which was very famous, the Rajasthan has actually enacted a law regarding that, that is the Rajasthan Prohibition Intervenes with the Freedom of Matrimonial Alliance in the Name of Honor and Tradition Bill 2019. So to conclude, I would like to say that there should be more awareness as well as legal legislations more, so that this specific act or this shameful killing or heinous offense can be prevented. Thank you.
Good evening to one and all. Respected chairperson in this technical session, Professor Palamaramati Madam, and all various faculties, my dear students. My name is K.S. Jayakumar, research scholar, University of Mysore. I am Mysore, and also my Guru, Honorable Vice Chancellor, Dr. C. Baswaraju, Karnataka State Law University, Hubballi. My topic is constitutional dimension of, especially related to the honor killing in India, a critic. What are the important of the constitutional measures under the provisions of Article 14, Article 15 subclass 1(3), and Article 19, including the Article 17 and also Article 21? Yes. Let us now the discussion for the one quote in the Justice V.R. Krishna Iyer says, "Law without justice is blind. Justice without law is lame. Law geared to justice is order." It is a opinion for one of the important court justice, V.R. Krishna Iyer. There are 5 important of the concept in the constitutional dimension of the honor of the killing. First one is in the definition of the honor killing. And the second one is, what are the important of the international perspective? Yes, in case of the CEDA and also Article 3, Article 12, a number of the article, it's provided for the supported by the international perspective of the honor killing. That's the second concept. And the most important of the criteria, constitutional provision. Article 14, Article 15 subclass 1(3), Article 17, Article 19, and including by the Article 21 of the right to life and personal liberty. That is the third important component. And the fourth important component is, it's a main concept is a legal framework. It's already in the technical session in the senior advocate in the Swami sir and also in the Dr. Girish Kumar sir, a number of legal provision. For example, in the case of provisions of Indian Penal Code 1860 and also Scheduled Caste and Scheduled Tribes in the 1879 and also in the Domestic Violence Act of 2005, a number of legal framework, it's a provisions of under related to the provision of honor killing in India. And the last concept is, it is a judicial contribution. For example, a number of cases related to the, already in the Dr. Girish Kumar told, called as Manoj Bobuli case and also in of the Tumkur important case. So many the criteria. Next. Let us now briefly, a discussion for the provision of, in the introduction part, Indian law, it is there is no defined by the provisions of the honor killing as per the provisions of the, in case of the constitution. But some important of the aspect, a number of the defined by the provisions of the honor killing. For example, Oxford Dictionary law and also another law commissions of India, human rights and also Amnesty International. So many defined by the provisions of the honor killing. For example, in case of one concept, in the provision of Oxford Dictionary law enforcement, honor killing is the purposable pre-planned murder or generally of the woman or by at the command of the members or family stipulated by the prescription she has a brought shame in the family. There are a number of the defined by the provisions of the honor killing. Next, There are, whether any international perspective, yes, it is a number of international aspects related to the provisions of the honor killing. For example, in the case of United Nations, in order to protect the provisions of called as a CEDA. What do you mean by CEDA? In the Convention of Elimination of Discrimination Against Women is called as also in the supported by the provisions of the honor killing. It is a most important criteria. And also some convention is adopted by the 1799 in United Nations of the General Assembly, and also in the supported by the 189 state. Next. There are number of the supported article in the provisions of the honor killing, Article 2, Article 16, and also one of the provisions of International Convention of Economic and Social Culture. Already in the morning session is told some international perspective of the technical session. Next, the another important of the concept is, yes, another most provision, Indian Constitution provision. Yes, there are the totally in the main provision of the related to the one of the provisions of the honor killing in India. Article 14, state shall not deny for the all equality before law, equal protection of law. It is also one provision. And Article 15 subclass 3, a special provision for related to the women's and in the, especially in the children category. And also Article 17, abolition of untouchability. This is the most important of the criteria in the Article 17. And Article 19 subclass 1, called as freedom of speech and expression, and Article 21, right to life and personal liberty. And also some important supported by the director principle of the state policy, Article 19 subclass A, Article 19 subclass 1A, it is also one of the provision. Next, conclude. So Indian some legislative of the framework, for example, Indian Penal Code, section 300 and 3435, 120A, and Indian Evidence Act, and also Hindu Marriage Act, section 5 of the Hindu Marriage Act. And the last some important of the criteria, judicial behavior. Some important case law called as a Saktiwa in state of Uttar Pradesh is already told, morning session is concluded. And also another important case laws in the Tumkur case, last one. Okay. Next, some recommendations of the provision, my opinion, some recommendation. For example, in the case of the mindset of the people, already told in the Girish Kumar, it's a number of some suggestion for the provisions of the honor killing. My conclusion that honor killing is a barbaric customary practice, though was not given much importance, is now seen as a serious and heinous crimes of the India. It is a specific legislation is provided for in case of honor killing. So thank you, give me an opportunity for Kilper and Madam on behalf of the Vishwesvaraya College of Law, Bangalore. Thank you, once again.
Of law.
He's robbed me of all the provisions and all the points that I wanted to make. ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೀವಿ ಭಾಷಣಕ್ಕೆ ಯಾವತ್ತೂ ಫಸ್ಟ್ ಆಗಿರಬೇಕು, ಯಾಕಂದರೆ ನಮಗಿಂತ ಮುಂಚೆ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟಿರ್ತಾರೆ, ನಮಗೇನೂ ಇಲ್ವೇ ಇಲ್ಲ. ಬಟ್ ಇವ್ರು ಬೇರೆ 4 ನಿಮಿಷ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಟಾಪಿಕ್ ಹೇಳಿ ನಮ್ಮ ಸಜೆಷನ್ಸ್ ಹೇಳೋದ್ರಲ್ಲಿ 4 ನಿಮಿಷ ಆಗೋಗಿರುತ್ತೆ. ಬಟ್ ಏನಿವೆ, ಐ ವಿಲ್ ಸ್ಟಾರ್ಟ್ ವಿತ್ ದ ಪರ್ಮಿಷನ್ ಆಫ್ ದ ಚೇರ್, Madam Valarmati. This is Dr. Sumitra from Vivekananda College of Law. There was a time in 7th century when women folk practiced Sati Sahagamana, in which she would jump into the burning pyre of her deceased husband, because it was thought that there is no life after death. There is no life after the death of one's husband. And later on, there was a practice in northeastern regions called Jauhar. This was mainly practiced by Rajput women and the girls. It was a mass suicide, wherein they would indulge in self-immolation, only to avoid capturing, enslavement, or rape by the Islamic invaders. This is one genre of honor killing, and of course these practices were voluntarily undertaken by the women to protect their honor. But today we have a different meaning for honor killing. This is not what they undertake deliberately, but this is committed by the family members. So I would like to call this as homicide than honor killing. Recently, I think that was on December 30th, just before the new year, a newly married couple, this happened in Arsikere in Hassan, a newly married couple, she had a penchant for wearing modern clothes. After marriage, the husband didn't like her wearing modern clothes. He reprimanded her, but she didn't pay heed to him. That day, December 30th, she was going out somewhere in a modern clothes. He told her not to, asked her to change a dress. She was reluctant to, she didn't. He said, come, I'll drop you to the place wherever you want to go. He took her on a bike, took her to the forest, killed her by slitting the throat. Is this honor killing? I do say this is honor killing. Honor killings do happen after marriage. It need not happen before marriage. Why after marriage? The husbands are apprehensive that if the wife wears a particular kind of clothes, or if a behavior is not as per the custom that is prevalent in their own families or in the community, it would bring shame onto the family, because of which they are killed. In fact, one of the resource persons in the morning addressed a situation wherein a woman, especially in Rajasthan, and this used to happen in Andhra Pradesh. A woman, if she gave birth to daughters, she was being abandoned. But in case he thought that this would pose a danger to her, danger to him getting married again, they would go to the extent of killing the first wife for the only reason, for the only fault that she committed was giving birth to the daughters. So honor killing does not or is not limited to killing of the daughters. Honor killing has different facets. We should keep ourselves open, wherein ladies are killed for only protecting the honor, be it before wedding, after wedding, and it also takes part or takes the form of other killings where a wife is being killed or a sister is being killed or the mother is being killed for having extramarital affair by the sons. So what are the recommendations? Because my time is running. What are the recommendations that I can make? First of all, IPC, which provides for the punishment for murder, minimum punishment is life imprisonment and death sentence. I strongly advocate in the case of honor killing, the minimum punishment should be life imprisonment till death and the death punishment, which should not be commuted at the later stage when they go in appeal. Secondly, as one of my friend was telling, the Ka Panchayat or similar such outfits should be banned. They're running a parallel government. They're running a parallel administration at the village level. They should be prohibited from operating so that there is only one governance. And Indian Evidence Act should also be amended, wherein the burden of proof lies mainly on the accused than on the victim. And no amount of law, no amount of guarantee of your fundamental rights can protect unless there is a change in the mindset. Let's change the mindset, especially the parents and also the children. As Gandhiji says, be the change, you be the change that you want to see in the society. Let us have a change in the mindset. Our motto should be prepare and prevent rather than repair and repent. So when the couple whose marriage is interreligious or intercaste, in case they ask for the police protection, please do give them the police protection. Accommodate them. And we have under the Special Marriages Act, in case a couple wants to get married, they have to give a notice period of 1 month. I think that should be taken a lenient view. Of course, the intention behind this notice period is entirely different, but then I think we can do away with this because we see that no parents will go to the sub-registrar office or no parents will go to this office and see if my daughter's name is there in the notice board or if my son's name is there in the notice board. And we have seen in practicality is that one notice is stuck on the other notice. The notice board is not big enough to paste all the notices. So this can be given a go by. Thank you so much. Yes. Yes, gentlemen. Time is over. I thought you wanted to ask me something. I hope I have not bulldozed anybody. I didn't stick to the whatever that I had prepared. Okay. Any questions? Thank you so much. I thank the chairman, lady here. Thank you so much, lady.
Now, I would like to call upon Mrs. Bhavana Chandran, Assistant Professor, to give on the research, Challenging Norms, Honor Killing.
Respected Chairperson, august guest, respected teachers, dear colleagues. I'm Sofil Ahmed from School of Law, Presidency University. I'm going to present my topic, Challenging Norms on Honor Killings and the Ongoing Struggle for Women Rights. Most of the provisions that we inserted in the research paper have already been taken up and discussed in the morning session. What in general that I would like to be discussing with you is the term honor killing. Can killing be justified in the name of honor? Firstly, the name itself, honor killing, is a misnomer in itself. Killing can never be taken the pride of being an honorable part. There is nothing honorable in honor killing. Article 1 of the Universal Declaration of Human Rights provides the first article that all human beings are born free and equal in dignity and rights. The same is being provided under multiple provisions of the Indian Constitution, be it under Article 14, 15, Clause 1, Clause 3, Article 19, Article 21, multiple other laws of Indian Penal Code, Indian Evidence Act, Special Marriage Act. All of that has been discussed in detail in the morning session as well as with my fellow colleagues in the previous papers. Honor killing over a period of time, it's not something that has its roots in the present itself. It was prevalent in the past from 1772 BC, 1075 BC in the Hammurabi and Assyrian law, wherein it was considered the fathers or the husbands to owe the rights upon the women's, wherein if they are found or commit any offense against the religion or caste or creed of their own, they might be punished brutally to death. And that onus was taken up by the own family members mostly, rather than putting the burden on the shoulders of the people or the caste or any tribe or community for inter-caste marriages, inter-community marriages or inter-religious marriages. This global impact, it states that the menace of this crime is not only present here in India, it is also found in the countries like Bangladesh, Brazil, Israel, Sweden, Turkey, Uganda, and many more. The names and numbers. The cultural and societal factors, the basic phenomena, or you can say the basic pressurization based on which people take it as a part of pride or honor in putting an end to this offense, which they term it under honor killing. Under the shadow or under the, what you can say is, under the points provided under the religion, caste, sexism, social behavior through violence, which ma'am have present in the earlier lecture, family pressures of committing or doing an act which is not in favor or is not in accordance with the societal norms of that religion or the caste or that family clan itself, they go to the extent of putting an end to a life and taking the pride saying that it was in against the honor of the family, clan, caste, tribe or religion. So putting an end is an honor killing. That should be curbed down. There are various other reasons based on which honor killing takes place, though it has not been defined anywhere under the IPC or under any such legislations. Different statements have been brought down in different cases laid down by the Honorable High Courts and the Honorable Supreme Courts, wherein cases were cited for interreligious marriages, extramarital relationships, restriction to females to select their own spouse, fear of losing their caste, homosexuality, leaving relationship, patriarchal, and the name goes on and on and on. But the question which remains with us today in this room is, are these reasons enough to put an end to a life? The whole concept or the whole phenomena of this discussion of today's conference, that is honor killing in India, need for legislative framework, that mindset that we do have, that we have justifications under the pride or honor of our own family or religion, caste, creed, name whatsoever. Can we put an end to it? That's a question that remains to the audience to answer themselves towards the end of today's session. Legal frameworks, I won't go deep into it as most of the things have been discussed in previous sessions itself. I'll quickly try to sum up with the conclusions and few remarks that which we try to bring it towards the end of the paper. Is basically continued advocacy, that is to create awareness through such kind of conferences, seminars, legal aid camps, putting into the people about the laws which are prevalent in the country that put an end, be the Indian Penal Code, the other criminal legislations, bringing in societal transformation, by which I mean to state to change a behavioral attitude or change in the behavioral attitude of the people of the society. And most important, the last suggestion which I would like to put in is to remove the word honor from such an heinous offense and protecting or like putting it under the bracket of the name of honor as an honor killing. Thank you for being patient listeners for today's session. Thank you, ma'am.
Arun S. Associate Professor, to present upon Supreme Court on Honor Killings.
Respected Chair and dignitaries, my topic has been almost covered, so I'm going directly to the case laws which has been decided by the Supreme Court. First one is Lata Singh versus State of UP and another 2006 by SCC 475, which was one of the initial cases where a divisional bench of the Supreme Court observed that no offense has been committed by the couple marrying outside their caste, and has been observed that there is no bar on an intercaste marriage under the Hindu Marriage Act or any other law. Interestingly, the court opinion that if parents do not approve the choices of partner of their children, the maximum that they can resort to is cut off the social relations with them. He further directed the police personnel throughout the country to ensure the intercaste couples are not subjected to any kind of violence, and in the event of such, to institute criminal proceedings against such people. Later, in Arumugam Servai was a state of Tamil Nadu in the year 2011, 6 SCC 405, while dealing with a case of caste conflict, the Supreme Court has been observed that Kap Panchayats are akin to courts and issuing decrees against intercaste couples are wholly illegal and has to be ruthlessly stamped out. In an appeal filed by an accused against his conviction for the killing of his daughter, the Supreme Court in the case of Bhagwan Das was a state in city of Delhi in the year 2011, 6 SCC 396 held that honor killing comes under the rarest of rare categories, so that it serves as a deferment for such outrageous acts. Coming to the conclusion part, as there are many rights and regulations to prevent honor killings, the crime continues to be a widespread issue. Honor killing, which is more likely to cultural than a religious ritual, as it has been in the almost all the religious issues, in all the religions it's there. So it has been secretly embraced by the society but publicly discouraged and banned elsewhere. The caste system in India has unfortunately been a social evil for many people. So the education regarding the value of citizens' life on this planet should be promoted, and awareness programs has to be done by the governments. Thank you for giving me an opportunity to present.
Now, I would like to call upon Professor Sahana Florence, Assistant Professor of Law, and Dr. Satish K.S., Associate Professor, on Right to Life with Human Dignity, Honor Killing, a Critical Analysis.
A very good afternoon. My topic for today's presentation is Right to Life with Human Dignity vis-a-vis Honor Killing, a critical analysis of Indian legal framework. To begin with, there is nothing honorable when it comes to honor killing. Right to life with human dignity is a basic inalienable right that is guaranteed in many of the international and the national legal instruments. In India, the right to live with human dignity is guaranteed under Article 21 of the Constitution. It says that the right to life includes right to choice, right to marry according to the wish and will of the person, without any force or without any compulsion or without any restrictions. The social or the cultural pressure cannot impose the condition on the person to decide whom he should get married or he should get married. This kind of practice in the Indian society is clearly unlawful. So, according to Human Rights Watch, what is honor killing? Honor killing is that kind of violence which is committed by, or we call it as a customary killing or the murder, This kind of practice is practiced by the member of the family against his own family member on the ground that just he or she has brought dishonor to the family, they must be killed or they must be murdered. So the next question arises is honor killing a human right issue? In my opinion, yes, honor killing is absolutely a human rights issue. Therefore, there are various international conventions or the declarations that have guaranteed the human rights, where even though the international conventions have not specifically addressed this particular issue, under the UDHR Article 3 and 16, if we taken into consideration, the freedom from the torture, inhuman treatment, and right to privacy, and the person's right to life and personal liberty must be protected. So another question arises here, whether this human right alone can stop the honor killing. Again, I would say no. Human rights or guaranteeing the human rights alone will not stop the honor killing, but the right approach of the human rights towards the honor killing can definitely help in stopping the honor killing practices. When it comes to India, honor killing, there are so many reasons. Our previous presenters have highlighted on that. I won't be repeating the same. Even though when these many incidents of honor killings are increasing day by day in India, our lawmakers or the state authorities have become a silent spectators. This is creating a lot of anxiety among the young couples or the young generations people or a married couple or the persons who are willing to get married. Even it is creating an anxiety among them, considering that they may be a target group or they may become the victim of this honor killing. And further, as I mentioned, there are so many causes for the honor killing. What does the law speaks on this? Whether in the national level or at the international level, there is no specific legislation or the international mechanism it speaks or address about the honor killing, except few international conventions like CEDAW, UDHR or ICSCER, and when it comes to India, through various constitutional provisions, IPC, and also the Evidence Act, Domestic Violence Act, and the other things. So even in the case of the very famously case called the Hadia case, the media called it as a love jihad case. In this case also the Supreme Court has opined that honor killing fall under the category of rarest of rare crimes, therefore the death sentence should be awarded. So with this I would like to take a small 30 seconds to conclude on the suggestion that everybody we are talking that there must be a separate law on the honor killing, but I would say that mere having or enacting the separate legislation on this, their percentage of honor killing may be reduced unless and until the mindset of the people or the mentality of the people, and very importantly, whatever the decision taken by the members of the family is accepted by the member, automatically the honor killing crimes will be automatically come into down. So thank you for this opportunity. Thank you one and all.
Now I would like to call upon Dr. C.B. Naveen Chandra, Assistant Professor of Law, to present upon the socio-legal dimensions of honor killing. Dr. C.B. Naveen Chandra. Now, Professor Rohan Nayak, Assistant Professor of Law, Historical.
Then again he did it so with finesse that probably I could not do that. Anyways, with the permission of the chairperson, I hope Jaydevan sir is treating you well. My paper primarily focuses on the historical perspectives of honor killing. Now I do digress from the fact that I have mentioned honor killing in my title, but I do focus on a lot on the honor crimes or the honor violence, because over the course of time I figured out that it's not just killing, it's the violence and the crimes that needs to be legislated upon. Because when we look at most legislations that work towards honor killings or honor crimes right now, we look at IPC or we look at SC/ST Prevention of Atrocities Act. It just focuses on the killing part. Nobody looks at revenge rape, or nobody looks at kidnappings. Nobody looks at murders from the honor perspective, or any other crimes that are associated with honor. So the need of the hour is not just to legislate on honor killings, but it is to legislate on honor crimes. Now, from a historic perspective, Khalida Brohi is one Pakistani women's activist who's now settled in US, who says that in her village of Baluchistan, honor was more important than food and water, something they lacked. It is this sense of identity of honor that gives rise to that dishonor element in the crime. Now, what usually tracks about in honor violence is that there's an element of honor which is broken down or which is dishonored by women of the family. Usually it is the women that is focused upon, because historically speaking, the blood purity would follow through, or the bloodline would flow through only when the women were pure. I do agree that this ideology seems very redundant, but that's how the element of honor was created. Aristotle's code of elitist actually brought about this concept of honor as an identity, which spread across through the Aryans of Iran. Now, if you have heard of Aryans, you would immediately recognize that they were the ones that invaded North India and ultimately became a part of India, and thus the lineage of Aryans and non-Aryans started. When Aryans created this missionary conquest to the Dravidian countries or Dravidian states, there happened a phenomenon called the Sanskritization, which was the cultural absorption by the Aryans of the Dravidians, which even today E.V. Ramasamy in his works has criticized a lot. Now, where this fear of identity arises in India is that the Brahmins basically wanted to uphold their caste superiority or their superiority in the society. Why? Because they took the example of Mauryan kingdom falling after they took up Buddhism, and they didn't want to lose that power in society, that because of a religion a kingdom failed. Thus this fear of identity came about. They legislated against mixed lineage marriages because they thought that the impurity of the bloodline would ultimately seize the Brahmanism that existed. Basically, from caste, which was already covered way back, caste has been one major issue in honor crimes. The protection, like many said, Kaap Panchayats. What Kaap Panchayats do? It's just that community of caste where elders legislate or sanction honor crimes because they want to uphold their identities. Identity became an issue. In Turkish criminal code, Article 82K, which specifically talks about custom killings. A case in the first criminal Supreme Court of Turkey, an honor killing was exonerated. A person who committed honor crime was actually acquitted because of the fact that it was not under the provisions of Article 82K. The person here is getting agitated over my long... what I would like to conclude is that the legislation on honor crimes should not just focus on unlawful assembly like the Law Commission report of 242. 1 second. So, unlike the Law Commission report of 242, we should also focus on the evidentiary fact, declining cultural defenses. We should focus on enforcement, and we should focus on other honor crimes as well. Thank you very much.
Homosexuals. Exploring honor killing against the LGBTQ community in India. As an introduction, I would like to delve into the concept of family and the concept of honor killing. We see, even till now, all the papers that were presented and all the sessions that were taken, we have seen that the concept of honor killing is considered or generally considered as a crime against women. It's usually considered women because women are considered as a vulnerable group. Similar to women, the LGBT community is also a vulnerable group. Honor killing is a crime that is taking place against the LGBT community, not just in India, but in many countries. For instance, in Iran, Saudi Arabia, Brunei, Somalia, the LGBT community can be awarded death penalty. So this particular concept of killing people belonging to this community is rampant across the world. The concept of family. When we say family, the idea is father, mother, and children. So this rigidity in the idea of family itself creates a problem. If it's father and mother, we are not considering two mothers, we are not considering two fathers. Again, the rigidity in this idea is what is rampant in India. Here also, when we talk about family, we talk about mother and father. This is a point that was raised by the Indian government in the recent case Supriyo Chakrabarti versus Union of India, where we saw same-sex marriage was not allowed. So in this case also, the point that was raised by the Indian government was that it was against our family values. Dealing with section 377, I'm pretty sure everyone knows that this has been decriminalized under the Navtej Singh Johar versus Union of India, a 2018 case. But decriminalization took place in 2018. This particular section was added in 1860. This is the evolution of the thought of anti-LGBT rights in India. Here you can see we actually had some kind of tolerance in India with relation to our epics like Ramayana and Mahabharata. But when we came to the Manu scriptures, we saw punishment being given to the homosexuals. Similarly, when the Britishers came, when they brought in the concept of Indian Penal Code of 1860, the law that was prevalent in Britain was followed in India. And that is how we got criminalization of homosexuality. Interestingly, Sexual Offences Act of 1967 and Marriage Same-Sex Couples Act of 2013 that was enacted in Britain it's actually decriminalized homosexuality and is allowing civil unions in Britain. But this particular concept is not seen in India. Then we have already discussed about the Navtej Singh Johar case, and we have the Transgender Protection of Rights Act of 2019, which is recognizing transgender rights. Again, marriage rights, adoption rights are not included. Honor killing and the LGBT community. In 2019, after the 2018 judgment, a Calcutta couple, two gay men, they had to flee from their family in fear of prosecution. Along with this, you can see instances wherein the transgender women were raped or threatened to be raped by the police who are supposed to be giving the protection. So these kind of instances are present in our community. With regard to the LGBT community, the major problem arises from the fact that being a part of the community itself is the issue. Unlike talking about honor killing with women, usually they are pretty happy in their family unit. Unless an issue of extramarital or premarital issue arises, they are protected within the family. But with regard to the LGBT community, being a part of the community itself is an issue for, or it is relating to honor killing. The only way to gain an upper hand is to recognize the rights of the LGBT community. Same-sex marriage, according to me, should have been allowed by the Supreme Court. Recognizing of same-sex marriage will give them rights, and only through rights can you actually create a change in the mind of the society. The way forward, right to marry has to be given. Most of the persons, they suffer in silence because of non-availability of solution. Police brutality is one problem, so that also has to be addressed. And then some kind of decision can be taken by the state governments to create awareness. Thank you.
If it is a death What type of death? Dowry. Because of dowry there is a cause of death. That is the reason honor has been given. Okay? That answer has been given. Now when you look into the summarizing of whatever has been done, we started with the history beautifully. Rohan had given a 360-degree global perspective excellently. He had covered every concept. And the last presenter, Rohit, he started with Ramayana, all the entire Indian perspective he covered as far as the history is concerned. Then we moved on to the constitutional, legal, judicial, and Sumitra madam gave a totally different outlook for honor killing. So long whatever you heard, we were thinking it is intercaste marriage. Intercaste marriage is honor killing. No, it has another bifurcation also, right? She moved on to the different angle and she gave her perspective, and it was a justifying one as far as the honor killing is concerned. And next, Aparna, she had a totally different thought. LGBTQ, we never think about them. We don't think that there is an existence of one life or there, a group of communities there. The killing, that also is for honor, because once the parents come to know that the child is transgender, it is below dignity, reputation is being harmed. So the parents are ready to do anything, even though they have brought up the child. So that is also a honor killing. Okay? So totally I can say that I have to congratulate each and every paper presenter. They have done the best in justifying the title for whatever they are taking. Thank you very much.
Thank you, Dr. Professor Valarmati B, for your valuable inputs and insights. It is most precious for all students, and we will take it. And I would request Professor Suchitra madam to facilitate Dr. Professor, okay, sorry, Sujata ma'am, I would request Sujata ma'am to facilitate Dr. Professor Valarmati B. Thank you ma'am for being present in the occasion.
Research on the same. Their perspectives and knowledge sharing for sure has enlightened all of us to deeply look into the topic and indulge ourselves into further research. With these few words, I would like to call upon Anaga, Vivipuram College of Law, for invocation. ನಾಳೆಗಳ ದಾರಿಯಲಿ ನಂಬಿಕೆಯ ನೆಲೆಯಾಕರಿಸು ಮುನ್ನಡೆಸು ಕೈ ಹಿಡಿದು ನಾವಾಡೋ ಪದ ಪದದಲ್ಲೂ ಸಂಚರಿಸು
ರಂಗಭೂಮಿ ತಂತಾನೆ ನಡೆಸುತ್ತೆ ಸ್ವಾಮಿ ಪಾಲಿಗೆ ಬಂದಂತ ಪಾತ್ರನ ಎಲ್ಲರೂ ಜೀವಂತಿಸಿ ಹೇ ಶಾರದೆ ದಯ ಪಾಲಿಸು ಈ ಬಾಳನು ಕಾಗಿಸು ಹೇ ಶಾರದೆ.
Sudha ma'am, Principal, Vivipura College of Law, to present a welcome address for the valedictory ceremony.
Namaste. Respected Shri G.S. Sangareshi, Principal Secretary to Government Department of Law, Justice and Human Rights, Government of Karnataka, Bengaluru. The President of Valedictory Ceremony, Shri K. Dwarakanath Babu, Director, Karnataka Institute for Law and Parliamentary Reform. Today's guest of honor, Shri K.S. Suresh, Chairman, Governing Council, Vivipura College of Law, Bengaluru, and Professor Dr. C.S. Patil, Director, KILPA. Respected Dr. Revaya Odayar, Research Head, Karnataka Institute for Law and Parliamentary Reform, Dr. Sanjeev Gowda at the conference, my dear friends, students. It's a pleasure to welcome Shri G.S. Sangareshi, the Principal Secretary to the Government Department of Law and Justice and Human Rights. Sir hails from Savadatti, the Belagavi district. Sir served as a district judge in Gadag district, Tumkuru district, Bangalore rural district, Mysore district. While serving in Mysore district, sir has settled 33 matrimonial cases in a Lok Adalat in one day. Out of 92 cases which were posted for Lok Adalat, sir settled 33 cases in one day relating to the matrimonial, and we feel he is an apt person for the valedictory session, valedictory address, because something from morning we were discussing about so-called crime against women, that is honor killing, and really it was wonderful to listen people from all generation, from C.S. Patil, sir, he shared his experiences when how a human being think at a different stages of life. So it was fantastic, and we have come to the last session of it, conclusion session. To this session, Principal Secretary is with us. It's an honor for us. I extend a warm welcome to sir on behalf of Rajya Vakkaligara Sangha, on behalf of Vishweshwarapura College of Law, and on behalf of Karnataka Institute for Law and Parliamentary Reform. May I request Dr. Arvind to honor the guest. Yes, sir. Today, the president of today's valedictory session, Dwarakanath sir, is also with us. I extend a warm welcome to you to this session, sir. Professor C.S. Patil sir is with us. A warm welcome is extended to you, sir. Revaya Odayar sir, director, and he is a man instrumental for this conference. Thank you so much. I welcome you, sir. Dr. Sanjeev Gowda, the coordinator of this function, I extend a warm welcome. Once again, a very warm welcome to you, one and all. Thank you.
This is presented by our beloved Assistant Professor of Law, Miss Suchitra J. Ma'am. Ma'am, please.
In India, need for legislative framework is organized by Vishweshwarapura College of Law in association with Karnataka Institute of Law and Parliamentary Reforms. The national seminar commenced with the inaugural ceremony graced by the Honorable Justice Krishna S. Dikshit, the Judge of High Court of Karnataka, Bengaluru, Professor Dr. C. Basavaraju, Honorable Vice Chancellor of Karnataka State Law University, Hubballi, and then Professor Dr. C.S. Patil, Director Research, Kilpar, Shri K.S. Suresh, Chairman of Governing Council, Vishweshwarapura College of Law. The inaugural session was presided by Dwarkanath Babu, Director, Kilpar, and Dr. Sudha S. Principal, VVPCL, welcomed the dignitaries. In his inaugural address, Honorable Justice Krishna Dikshit highlighted that all the religious scriptures in one or the other way degraded women. Most part of his inaugural address concentrated on the religious and women's side of perspectives on honor killing. He stressed on specific laws to be enacted to address the cause of honor killing, and also stressed on more conferences of this nature has to be organized. In his keynote address, Professor Dr. C. Basavaraju, the Honorable Vice Chancellor of KSLU, Hubballi, who quoted Basavanna, Vachanakranti, and also the verses from Vachanas in his entire address, he opined that if laws and legislations are not respected, the social evil of this gravity cannot be eradicated. He observed that it is of a great shame that we still speak on such social evils. So, the inaugural session came to an end with our IQSC coordinator, Sanjeev sir, honoring the dignitaries on the dais. And then it was followed by inaugural sessions. Followed by the inaugural sessions were the technical sessions, 2 technical sessions addressed by the distinguished resource persons, Professor Dr. C.S. Patil and KBK Swami, Shri KBK Swami, Advocate, Bengaluru. The first session was chaired by Shri Dwarkanath Babu, Director, Kilpar, and the second technical session was addressed by the distinguished speakers, Dr. Girish and Law Commission member, Honorable Ashok Nijagannawar, and followed by the lunch break was this national seminar, which witnessed thought-provoking, insightful presentations from academicians, research scholars, and the students from various institutions. 3 parallel sessions were held. We received about 52 papers altogether. And these sessions were insightful. And the national seminar served as crucial platform that fostered dialogue, thought-provoking, insightful presentations. The seminar was fruitful due to recommendations highlighted by the distinguished guest and the unique, extraordinary technical sessions. Overall, the insights shared discussed a display and urgency of specific legal framework to address this cause of honor killing. May our collective efforts pave the way for meaningful change in the society. Thank you for your patience listening. Thank you.
Now, I would call upon the guest, Shri G. Sangreshi Sir, Principal Secretary of Government, Department of Law, Justice and Human Rights, Government of Karnataka, Bengaluru, to give valedictory address to the crowd.
Good evening, everybody. Sri Dwarkanath Babu, Director, Kilpar, Bengaluru. Sri Dr. C.S. Patil, Director, Research, Kilpar, Bengaluru. Dr. Sudha G, Principal, Vivipuram College of Law. Dr. Vadier and Dr. Sanjeev Goda, and the other dignitaries on the dais and off the dais, and my beloved students.
First of all, I should say thanks to the Kilfar and his team, and also the Dr. C.S. Patil, who have invited me to grace the valedictory function, which was inaugurated today morning by Justice K.S. Dixit, Judge of the Honorable High Court of Karnataka. And also I am thankful to the organizers and also the V.Puram administration of V.Puram College of Law Administration, having given this opportunity to address you all. As a Principal Secretary Law Department, I have taken charge about 2 months back. Before this new venture of as the Law Secretary, Government of Karnataka, I had worked in the Department of Parliamentary Affairs and Legislation about 20 years back. And at that time, Divakar Babu, Dwarkanath Babu was my colleague. And before that, I want to tell you all that Dr. C.S. Patil, who is here, is a renowned scholar in the law, in the field of law. He has been given the right posting by the Government of Karnataka, that too by the Kilfar. He was my senior 2 years in the law college. I had also grown up by observing his attitude and behavior in the college campus, and I studied his notes. During those days, there was no mobile, no computers, nothing, only the library and the notes prepared by Chidanand Patil. We used to call him as CS only. Now he is being called in different names. Anyhow, he is my good friend. He has come here to address you all with his vast experience and knowledge in the field of law. The Government of Karnataka has also decided, under the able leadership of our Honorable Minister for Law, Justice and Human Rights, Sri H.K. Patil, that he has been now working as a Director Research Kilpar. Above all, he is an asset to our institutions, not only the law colleges, not only to the Kilpar, and even to the legal education, but he is asset to our law department and the Government of Karnataka. Why I am telling you is that you are all students. We have also completed our law course by observing such persons about 35 years back. I completed my LLB in the year 1988. He completed in the year 1986. He had gone to Mysore to study LLM and came back to Dharwad, and he was lecturer in the same college where he studied. I am also the student of his elder brother, Dr. J.S. Patil. And whatever you know, all of you, he has joined this Kilpar institution about 15 years back. I am taking reference of all this, that one should get inspiration from all these people. Without inspiration, a student cannot prosper in his life. There should be a man of high standard, specialist in a field, so that we can admire him, and those qualities he acquired can be inspired by all of us. So that is why, with little reference to them, I am here. And not only that, Dr. C.S. Patil is a professor to my younger brother, who also always is fond of saying that now the University Law College has produced as many as judges and district judges and High Court judges, and even Supreme Court judges, Chief Justice of India also. So the great educationist will be happy only when the students like you achieve more in your field, in the education system. So likewise, when his students were selected as direct district judges, he was more happy than their parents. Now also he is in the same style of saying that my children, I noticed several times. He is not telling everybody that your brother or his kid like that. Our children have become the district judges in the Karnataka judiciary, and our kid has become a High Court judge like that. He used to refer all of those. So I don't know how far you have given your much attention to the morning sessions, but certainly I am sure that you must have heard the lecture of Justice K.S. Dixit, who is very, who is an orator in any field of law or in any subject. So with this introduction, he was also my senior. So with this introduction, I don't take much time. I know that you all have been exhausted, and before going out by one by you, I will complete within 5 to 10 minutes, and I will take your permission to go out. From morning, there were deliberations which took place regarding honor killing. The subject today for this valedictorian function is honor killing in India, need for legislative framework. I don't want to repeat the definition or meaning of honor killing, in which part of India these honor killings are being taken place, how our existing law is taking actions against those culprits who have committed brutal murders against their own children. Honor killing is basically an act of murder by the family members. Except family members, no third person will do this heinous act. The third person may commit such murder only on the conspiracy or a direction by the family members. It is a dirty behavior of the members thinking about the purity of their life, of their family, instead of the life of a member of their family. The male member or any family member kills the one who looks to love the person not matching with their social status. We can also say that it is a pre-planned murder for which caste and religion are the main reasons. Unlike not to say like this. In the case of other offenses, there will also be motive or intention to do away with the life of a person. But here, the main reasons for the commission of those offenses are caste and religion. Mostly these type of cases are caused due to trigger done by the relatives, society, neighbors, by whom the accused feels dishonored and gets provoked. Caste and status are the main reason for honor killing. This type of activity is brutal and unlawful. In India, where we talk about the largest constitution and biggest democracy in the whole world, to have fundamental rights and the right to life as well. It has become a common practice in India. The honor killing has been spread in the whole country. Supreme Court has brought a decision against honor killing, saying that the said act is illegal and punishable. In India, the state of Haryana, Punjab, Rajasthan and Uttar Pradesh contain more cases of honor killing. The majority caste members do not accept inter-caste marriage to maintain the decorum of their caste or status of their family in the society. Due to this complex socio-cultural problems, the crime of honor killing is diverging at the high rate. Even the honor killing also takes place when the matter of same Gotra cake. The killing is done to restore the honor and the respect with the family, which lost due to the one who was in love with the person of different caste. In India, several crimes such as sati practice is completely banned. But here, we have the numbers in cases of honor killing, whereas both the crimes are committed only by triggering. Each and every citizen of our country has his own right. We have Article 14 and 15, which say equality before the law, the rights before the law. Means every citizen of India would be treated equally before the law, irrespective or without any discrimination of caste, creed, sex, race and religion. In case of honor killing, the act is done to a female more than a male of a family, which shows that there is no equality before the law. A female has been murdered, which forms even gender violation. Article 19 and 21 of the Indian Constitution deals about right to freedom and right to life, respectively. In the case of honor killing, both rights of persons have been violated. It is the right of a person to choose his or her her life partner. No person has the right to take away one's freedom of life. Even the Hindu Marriage Act, according to Hindu Marriage Act, every citizen shall become major after attaining the age of 18. As in the case of honor killing, there is the violation of law. If a person is not accepting the marriage arranged by her family, then anyone have no right to kill that person in the name of the dishonor of the family. You must have noticed, you must have come across the notable cases like Manoj Babli case, Shakti Vahini case, Eknath Kishan Kumbarkar case. The Department of Women and Child Development has made arrangements for the rehabilitation of female victims facing threat of honor killing, and efforts have been made to sensitize the society against commission of such crimes. Therefore, in the opinion of myself and other dignitaries and the legal experts, the honor killings for whatever reason come within the category of the rarest of rare cases deserving death punishment. It is necessary as a deterrent for such outrageous, uncivilized behavior. All those persons who are planning to perpetrate the honor killings should know that the gallows await them. So with this brief lecture on the honor killing in India, I am once again emphasizing that we all the students of the law must know the law. If you don't know the law, if you don't practice the law as per the law, and we don't sensitize the public whenever the matters like this come across, we are failing in our duties. With this brief notes, I am finishing my speech, and in the end, I once again say thanks to everybody who we have invited to this valedictory function, and with the permission of all of you and with the dignitaries and the dais, I may be permitted to go to the office to attend other works. Thank you, one and all.
ಕರ್ನಾಟಕ ಕರ್ತವ್ಯದ ಕರೆ ಇದೆ, ಹಾಗಾಗಿ ಬೇಗ ನಿರ್ಗಮಿಸಬೇಕಾಗಿದೆ. ಆದಾಗ್ಯೂ ನಮ್ಮ ವಿನಂತಿ, ಇವತ್ತು ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ 3 ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಪ್ರಥಮ, ದ್ವಿತೀಯ, ತೃತೀಯ ಪ್ರೈಸನ್ನು ವಿತರಣೆ ಮಾಡಬೇಕಂತ ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತಾ, ಅದರ ನಂತರ ನಮ್ಮದು ಗೌರವ ಸ್ವೀಕರಿಸಿಕೊಂಡು ನಿರ್ಗಮಿಸಬೇಕಂತ ವಿನಂತಿ ಮಾಡ್ಕೊತಿದ್ದೇನೆ ಸರ್. ಈಗ ನೇರವಾಗಿ ನಾನು ಪ್ರಶಸ್ತಿ 3 ಜನ ಪ್ರೈಸ್ ವಿನ್ನರ್ಸ್ ಬಗ್ಗೆ ಹೇಳ್ತೀನಿ. ಒಟ್ಟು 64 ಪೇಪರು ಆಗಿತ್ತು. ಅದರಲ್ಲಿ 40 ಜನ ಸ್ಟೂಡೆಂಟ್ಸು ಭಾಗವಹಿಸಿದರು, 24 ಜನ ಅಧ್ಯಾಪಕ ವರ್ಗದವರು ಮಾಡಿದರು. ಈ 40 ಜನ ವಿದ್ಯಾರ್ಥಿನಿಯರಲ್ಲಿ ಮಾತ್ರ 3 ಪ್ರೈಸಸ್ಗಳನ್ನು ಹೇಳ್ತಿದ್ದೇನೆ. ಅದರಲ್ಲಿ ತೃತೀಯ ಬಹುಮಾನದ ವಿದ್ಯಾರ್ಥಿನಿ ಎಸ್ ಮಾಲಿನಿ, ಪ್ಲೀಸ್ ಕಮ್. ಇವಳಿಗೆ ಪ್ರಶಸ್ತಿ ಪತ್ರ, ಥರ್ಡ್ ಪ್ರೈಸ್ 500 rupees ಕ್ಯಾಶ್ ಪ್ರೈಸ್. ಡಾಕ್ಟರ್ ಎಸ್ ಮಾಲಿನಿ, ವಿ ಪುರಂ ಕಾನೂನು ಕಾಲೇಜು, ಬೆಂಗಳೂರು. ಹಿಂದೆ ನಿಂತ್ಕೊಳ್ಳಮ್ಮ ಮೇಡಮ್, ಹಿಂದೆ ಬನ್ನಿ ನೀವು. ಇನ್ನು ದ್ವಿತೀಯ ಬಹುಮಾನದ ವಿದ್ಯಾರ್ಥಿನಿ ಅನುರಂಜಿನಿ ನಂದಾ ಕುಮಾರ್ ಮತ್ತು ಎಜಿ ರುಷಿತಾ. ಜಾಯಿಂಟ್ ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಇವರು ಜಾಯಿಂಟ್ ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಇವರಿಬ್ಬರಿಗೂ ಪ್ರಶಸ್ತಿ ಪತ್ರ, 700 ರೂಪಾಯಿ ನಗದು ಬಹುಮಾನ, ಪ್ರಶಸ್ತಿ ಪತ್ರ. ಇವರು ಸೇಂಟ್ ಜೋಸೆಫ್ ಕಾನೂನು ಕಾಲೇಜು, ಬೆಂಗಳೂರು. ನೆಕ್ಸ್ಟ್ ಫಸ್ಟ್ ಪ್ರೈಸ್ ನೇಮ್ ಯಾರು? ನನಗೆ ಕೊಡಲ್ಲ ಅವರು. ಪಾಯಲ್ ಜೈನ್ ಅಂಡ್ ಗೌರಂಗಿ ಮೆಹ್ತಾ, ರಾಮಯ್ಯ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಲಾ ಕಾಲೇಜ್, ಪಾಯಲ್ ಜೈನ್ ಅಂಡ್ ಗೌರಂಗಿ ಮೆಹರೋತ್ರಾ. ಇವರು ಜಾಯಿಂಟ್ ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಜಾಯಿಂಟ್ ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ ಇವರಿಬ್ಬರಿಗೂ ಪ್ರಶಸ್ತಿ ಪತ್ರ, 1,000 ರೂಪಾಯಿ ನಗದು ಬಹುಮಾನ. ಕರ್ನಾಟಕ ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಪ್ರೋತ್ಸಾಹಿಸುವ ದೃಷ್ಟಿಯಿಂದ, ಅವರಲ್ಲಿ ಸಂಶೋಧನಾ ಕೆಲಸವನ್ನು ಉದ್ದೀಪಿಸುವ ದೃಷ್ಟಿಯಿಂದ ಈ ಕಾರ್ಯವನ್ನು ಮಾಡ್ತಾ ಇದೆ. ವಿದ್ಯಾರ್ಥಿನಿಯರು ಲೇಖನಗಳನ್ನು ಬರೆಯುವುದರ ಮೂಲಕ ಈ ಸ್ಟೇಜ್ ಫಿಯರನ್ನು ಕಳೆದುಕೊಳ್ಳುವ ಮೂಲಕ ಈ ಕಾರ್ಯದಲ್ಲಿ ಭಾಗವಹಿಸಬೇಕು ಎನ್ನುವುದು ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ಸುಧಾರಣಾ ಸಂಸ್ಥೆಯ ಉದ್ದೇಶ. ಇದರ ಜೊತೆಗೆ ಅಸೆಂಬ್ಲಿ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು, ಮೂಟ್ ಕೋರ್ಟ್ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಕೂಡ ಮಾಡ್ತಾ ಇದೆ. ಅದರೆಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳು ಭಾಗವಹಿಸಿರಿ ಅಂತ ಹೇಳ್ತಾ, ಪ್ರೈಸ್ ಪಡೆದವರಿಗೆ ಅಭಿನಂದನೆಗಳು, ಪಡೆಯಲಾರದವರಿಗೆ ಕೂಡ ಅಭಿನಂದನೆಗಳು. ಮುಂದಿನ ಸಂದರ್ಭದಲ್ಲಿ ಇನ್ನೂ ಹೆಚ್ಚಿನ ಮಟ್ಟದಲ್ಲಿ ತಾವು ಸಂಶೋಧನಾ ಲೇಖನಗಳನ್ನು ಮಂಡಿಸಿರಿ ಅಂತ ಹೇಳ್ತಾ, ದಯವಿಟ್ಟು ಗ್ರೂಪ್ ಫೋಟೋ 5 ಜನ ನಿಂತುಕೊಳ್ರಿ ಸಾಲಾಗಿ. ಗಣ್ಯರ ಜೊತೆಗೆ ಗ್ರೂಪ್ ಫೋಟೋ ಮಾಡೋಣ. ಸರ್ ಕುಳಿತುಕೊಳ್ಳಿ ಸರ್, ತಾವೆಲ್ಲರೂ ಗಣ್ಯರು ಕುಳಿತುಕೊಳ್ಳಿ. ಹಿಂದೆ ವಿದ್ಯಾರ್ಥಿಗಳು ನಿಂತ್ಕೊತಾರೆ. ಮುಂದಿನ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಾನು ಅನುವು ಮಾಡಿಕೊಡ್ತಾ ಇದ್ದೇನೆ ಸರ್.
With the permission of the chairs and the participants who are here, I would like to take this opportunity to honor Department of Law, Justice and Human Rights, Government of Karnataka. Sir, thank you very much for your insight words about the present National Conference on Honor Killing. Thank you very much, sir. On behalf of Rajya Vakkaligara Sangha, on behalf of Vivipura College of Law, and on behalf of Kilpar, I extend heartfelt thanks to you, sir, for your gracious presence in this valedictory address and valedictory function. Thank you very much, sir.
Babu sir, Director Kilpar, Bangalore, to give presidential address.
ಎಲ್ಲ ಬೆಳಗಿನಿಂದ ಉತ್ಸುಕರಾಗಿ ಸ್ಪರ್ಧೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದೀರಿ. ಮತ್ತು ಟೆಕ್ನಿಕಲ್ ಸೆಷನ್ನಲ್ಲಿ ಎಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ದು ಅಭಿಪ್ರಾಯ ಕೇಳಿದ್ದೀರಾ ಸ್ಪೀಚಿನ. ಇವತ್ತು ಒಂದು ಸಾರ್ಥಕವಾದಂಥ ದಿನ ಅಂತ ನಾನಂತೂ ಭಾವಿಸ್ಕೋತೀನಿ. ನಮ್ಮ ಸಂಸ್ಥೆಯಿಂದ ಈ ಕಾರ್ಯಕ್ರಮ ನಡೆಸೋ ಉದ್ದೇಶನೇ ನಿಮ್ಮೆಲ್ಲರಿಗೆ ಇದು ತಲುಪಬೇಕು ಮತ್ತು ನಿಮ್ಮಿಂದ ನಿಮ್ಮ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಬೇಕು ಅನ್ನೋದೇ ನಮ್ಮ ಉದ್ದೇಶ. ಕಾಲೇಜಲ್ಲಿ ಪಾಠ ಕೇಳ್ತೀರಾ, ಇಲ್ಲಿ ಇನ್ನೊಂದು ಪಾಠ ಆಗಬಾರ್ದು. ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರೇ ನೀವು ಸ್ವಲ್ಪ ಹೋಮ್ವರ್ಕ್ ಮಾಡಿ, ನಿಮ್ಮ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇರುತ್ತೆ. ಈ ಒನ್ ವೇ ಟ್ರಾಫಿಕ್ ಆಗಬಾರ್ದು. ಕ್ಲಾಸಲ್ಲೂ ಪಾಠ ಕೇಳ್ತೀರಾ, ಇಲ್ಲೂ ಪಾಠ, ಅದು ಆಗಬಾರ್ದು. ನೀವು ಪೇಪರ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿ, ನೀವು ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದರೆ ನಾವು ಮಾಡಿದ ಒಂದು ಈ ಎಕ್ಸಸೈಸ್ಗೆ ಒಂದು ಸಾರ್ಥಕತೆ ಸಿಗುತ್ತೆ ಅಂತ ನನ್ನ ಭಾವನೆ. ಇದೆಲ್ಲ ಇವತ್ತು ಭಾಳ ಚೆನ್ನಾಗಿ ನಡೆದಿದೆ. ಸುಮಾರು 40 ಪೇಪರ್ಸು ಇದು ಮಾಡಿದ್ದೀರಾ. ಅದರಲ್ಲಿ ಸ್ಟೂಡೆಂಟ್ಸ್ 40 ಜನ, ಒಟ್ಟು 64 ಪೇಪರ್ಸ್ ಬಂದಿತ್ತು ಅಂತ ಹೇಳಿದರು. ಈಗ ಅದರಲ್ಲಿ ಉತ್ತಮವಾಗಿ 3 ಜನ ಆಯ್ಕೆ ಮಾಡಿದ್ದಾರೆ. ಹಾಗಂದರೆ ಬೇರೆಯವ್ರದ್ದು ಸರಿ ಇಲ್ಲ ಅಂತಲ್ಲ, ಇನ್ನೂ ಭಾಳ ಜನ ರೆಕಗ್ನೈಸ್ ಮಾಡಬೇಕು ಹೇಳಿದರು. ಇನ್ನೂ ಪ್ರೈಸಸ್ ಇದ್ದರೆ ಇನ್ನೂ ಕೊಡ್ಬೋದು, ಅಷ್ಟು ಚೆನ್ನಾಗಿತ್ತು ಪೇಪರ್ಸು ಅಂತ. ಐ ಆಮ್ ಹ್ಯಾಪಿ. ಇವತ್ತು ನಾವು ಒಂದು ಉತ್ತಮವಾದಂಥ ಈ ಕಾರ್ಯಕ್ರಮ ನಿಮ್ಮೆಲ್ಲರ ಭಾಗವಹಿಸುವಿಕೆಯಿಂದ ಆಯಿತು ಅಂತ ನಾನಂತೂ ಭಾವಿಸ್ಕೊಂಡಿದ್ದೀನಿ. ಎಲ್ಲರಿಗೂ ಥ್ಯಾಂಕ್ ಯು, ಧನ್ಯವಾದ.
Thank you so much, sir. Now, I request our beloved Assistant Professor of Law, Dr. Arvind H.T. sir, to give away vote of thanks.
Cooperation in organizing this national conference in a great grand manner. First, I would like to thank the Law Secretary to the government who came here and who delivered valedictory address on behalf of Rajya Vakkaligara Sangha, Vivipura College of Law, And also on behalf of Kilper, I extend heartfelt thanks to our Law Secretary, sir. Thank you very much, sir. Next, I would like to thank Shri Divakar Babu, sir, the alumni of our institution, and the director, Kilper. He extended all his cooperation in organizing this function, and he has been there from morning. He presided over inaugural session and also presided over the valedictory session. Sir, thank you very much for your gracing the occasion. Thank you very much, sir. Next, I would like to extend heartfelt thanks to Professor Dr. C.S. Patil, sir, the Director, Research, Kilper. Sir, thank you for your insight about the present situation of the law which government is going to bring up shortly. Thank you very much for your participation, sir. Next, I would like to thank two important dignitaries who helped in organizing this function in a great grand success manner. First, I would like to thank Shri D. Hanumantaya, the President, Rajya Vakkaligara Sangha, and Shri K.S. Suresh, President, Governing Council, Vivipura College of Law. In their absentia, I extend heartfelt thanks to these two great personalities. Next, I would like to thank Dr. Revaya Odayer, Research Head, Kilper. Sir, thank you very much for coming and involving in this activity and extending all your cooperation in organizing this function in a great grand success. I request Sanjeev Gowda and our Principal Madam to honor Shri Revaya Odayer. On behalf of Rajya Vakkaligara Sangha, on behalf of Vishweshwarapura College of Law, and on behalf of all the participants who are here, I extend heartfelt thanks to you, sir. Next, I would like to thank the pillar of our institution and who stood in a pillar manner to organizing this function in a great grand manner. None other than Dr. G. Sudha, Principal, Vivipura College of Law. On behalf of all the students, I extend heartfelt thanks to you, madam. Sapling. This is an important moment to honor our Principal Madam. Without her cooperation, this event would not be organized in such a grand manner. Madam, on behalf of all the students and participants, I extend heartfelt thanks to you, madam. And this is a moment which we all expected. This is for your hard work, madam. It shows how hard work you did for organizing this function, madam. Thank you very much for your cooperation. Next, I would like to thank one more important person who stood behind this national conference, none other than my dear colleague, Dr. Sanjeev Gowda, IQAC coordinator and organizing secretary of this national conference. Dr. Sanjeev, I extend my heartfelt thanks to you on behalf of all the participants. So we are honoring the hard work of Mr. Sanjeev Gowda. Thank you very much, Sanjeev, for your all cooperations in organizing this event. Next, I would like to thank the paper presenters who come from various colleges, the teachers, students who come forward, who sent their papers, who presented their ideas in this national conference. Thank you very much for your participation. Next, I would like to thank one of our dynamic teacher of our college, Suchitra J. She took lot of efforts and she shown lot of patience in organizing this national conference. Wholeheartedly, I extend my heartfelt thanks to Suchitra Madam. Thank you very much, Madam. It shows how much you are involved in the event, organizing this event along with the students. Thank you very much. Next, I would like to thank all the faculty members of our college who extended their cooperation, who stood with us in organizing this national conference. Thank you all my faculty members. Next, I would like to thank press and media who covered this event totally from morning to till today, till this moment. Thank you very much, press and media people. Last but not the least, fugal point of this national conference, who are here to take the ideas, to draw the conclusion to the title of this national conference, none other than my dear students. See, here I would like to mention the hard work of the volunteers. See, every day along with us from morning 8 o'clock to till 6, from last 1 week, they have been with us and still they are with us. Thank you very much for your active participation. I wholeheartedly extend my heartfelt thanks to one and all my students. With this, I conclude my vote of thanks. Thank you very much, one and all.
I would also extend our heartful thanks to Assistant Professor of Law, Arvind sir. I request everyone to please give. With this, we have formally ended the session. I request all of you to raise for the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Ronald Rohan and Nishchita. Dr. Sumant HM. Nandini J and Shai. Sanjana S. Sajjan. Sanjana S. Sajjan. Jaikumar Shailaja Swami. Rohan Nayak.
ಶಾಹಿಲ್ ಅಂಜನಾ ಸುನಿಲ್, ಡಾಕ್ಟರ್ ಅಶ್ವಿನಿ ಪಿ and Anushri S. Dr. Ashwini P and Anushri S. Abhishek Singh. Abhishek Singh. Abhishek Singh. Chandrasi. Chandrasi. Vinay Sridhar. Yoga Lakshmi R. And Kushi Rathod. Kaninika Majumdar and Shweta Singh. Kaninika Aniket Laria and Krunal Modi. Aniket Laria and Krunal Modi. Shashir Tanupriya. Shashir Tanupriya. Sahana Florence. Sahana Florence and Dr. Satish K.S. Dr. Vinayaka K. and Shivani T. Dr. Vinayak, Vishweshwarapura College of Law, Mahim S. Dr. Shweta P. and Pavan Kumar R. Dr. Shweta P. and Pavan Kumar R. Dr. Nalina R. and Jahi Snehaba. Aniket Nag and Samarth Singh. Aniket Nag and Hananya MH. Hananya MH, Rohit J. Bhavana Chandran and Shafil Ahmed. Bhavana Chandra, Assistant Professor, and Shaful Ahmed, Assistant Professor. Hemant TC, Rajendra Prasad KS. Rajendra Prasad KS.